That's because I'm talking on mute, girl. Okay, so I am posting some content right now. I'm actually gonna show it to y'all right here in a second because um I'm actually going to show it to y'all. Did I lose some? I think I lost some subscribers. Did I lose some subscribers? I probably did. I thought I was close to 80 something. Maybe not. All right, let me post this. I know. I think I lost some. So I don't know. So shout out to Starfish because Starfish made me aware of the Sade Robinson case. Are you familiar with that? Yeah, okay. So I'm about to post my little recap because they set a jury and the trial is underway. So I am going to be trying to find us. I'm gonna try and find us a stream because yeah, we need to be watching it. We need to have eyes on it. Um, that's what we need to be doing. Okay, so I'm waiting on it for it to upload and then I will share it. Um, I think it's uploaded. Let's see. I'm gonna try to see my video. Karen Reed don't start, and so I'm gonna be searching for us a good feed today. I got a slow day today, so it's a good day for me to do content. So I may push out a lot of videos today, y'all. I don't have a lot of stuff to do at work today, which is fucking amazing because it has been hard as hell. Okay, it's still loading. So whenever it loads, I'll get it pushed out. Good morning, Kim. Make sure that you run it up on TikTok. Make sure y'all run it up on TikTok. I'm posting my content kind of early today, but I know I usually have to drop my content between 10 and 4 for it to do anything, but it is what it is, man. I can't be worried about all that. I feel like too much be going on. But I am trying to find day freaking one of that trial. And I don't know who's actually in the courtroom. Okay, let me share. Let me give y'all my little recap. Make sure y'all still run over to it, hit the like button so that we can get into the algorithm. Yes, the trial started. The trial started yesterday. Let me see. Day 3 of the day. So hey that y'all watching. Now I got a new trial that I'm getting ready to watch. And I think you might want to hear about it. This trial is about the unaliving of Sade Robinson. They are calling it a date with death. Now, this is a very, very tragic story, okay? Sade was 19 years old. She was living out in Milwaukee, and she ended up going on a date with a guy named Maxwell Anderson. Now, Sade was 19 and Maxwell was 33, and he took her out. They went to a couple bars. She was served alcohol, and then she disappeared. One of her friends reported her missing when she didn't show up for work, but the story then gets crazy. Sade's car had been found. It was torched, and they found some of her body parts. A confidential informant claims to know that Maxwell actually planned to unalive Sade weeks before he actually did it, allegedly. Remember, they only found body parts of her, but there are several that they still not haven't found, including her head. Maxwell has been charged with first-degree intentional homicide, mutilation of a corpse, and arson. A jury has been seated, and the trial started yesterday. So I'm gonna try to find us a stream, and we're gonna watch that. Now we get ready to watch this because we need justice for Sade. So that is what I'm trying to get for us. I'm trying to find us a good stream so that we can watch that. Like, we most definitely need to watch that. I'm having a hard time finding the actual guess who got it, y'all? Law and Crime got it. Law and Crime got it. So we're gonna be able to watch it. We're gonna be able to watch it online. Crime. I'm getting ready to update our. We got a lot to do. We gotta keep up with Diddy. We gotta keep up with Karen Reed today, and we also gotta keep up with Sade Robinson. But I'm about to update our thumbnail because we are absolutely watching Sade Robinson. Like, I could give two fucks about Karen Reed at this point. I really can. I'm actually gonna make her super small on this thumbnail. I really want to watch Alessi's cross of this guy, but yeah. It might be good. I didn't really pay attention yesterday to the trial, so I did watch like a couple of other recaps so that I can kind of like be abreast on what's be abreast of what's kind of going on. Be abreast of what's going on, and crap. Be abreast of what's going on, and a couple things that I heard people point out yesterday was the guy testified that the car went to a different place before it got to the Sally Port. And apparently we haven't seen that video. So apparently that's something that's very interesting. And then I think in the chat, we were already talking about how he said he didn't know how John Keith was unalived. He don't know when if the car hit him. Well, he said car hit him, but he don't know when the car hit him. Stuff like that. So I do want to hear Alessi turn into him about that. But I really want us to watch Sade Robinson. So I'm trying to find that. Well, I actually did find it. I actually did find it. And we're gonna watch it. And what was crazy too, when I was reading I was watching like the news stuff about it. Why is it not? I'm so little. Okay. I was watching like the news stuff about it, and baby, they basically knew it was him. People was going to the man's house, decorating his house with stuff that said Sade name on it. Yeah. I'm so happy to have something else to watch. I'm not even gonna lie to you. Let's make Diddy small. Because if I could just cover Diddy and stop watching Karen Reed, I would absolutely love my life. Let me make this smaller. Okay. So I apologize. I'm like, I wanted to get live to let y'all know, but I also got to update this thumbnail. So I'm kind of like all over the place, but we're going to watch. We absolutely should not be like, we have a lot of downtime today. We should be able to switch from thing to thing to thing to thing today. So I am looking for a picture of our girl. And she was gorgeous. She was gorgeous. And we're going to remove the background. I promise I'm going to get y'all something on the screen besides my face in just a second. And actually, I'm wrong in my video. Today is day one, y'all. Today is day one. So yeah. This baby. All right, our little thumbnail's a little busy. I must admit, I'm not really feeling it. I must admit. It's too busy for me. Let's just do this. Let's do this. I think it'd be like a little. Karen head is so big. Like, why do I have her? Oh, because it's two of her pictures. So I'm like, what the hell? Why does she look like that? Okay, y'all. I promise I'm almost done. Mm, I don't like it. I don't like the thumbnail, y'all, but it is what it is. I need something so we can get our day started. Good morning, good morning, good morning, good morning, good morning. Yes, let me hurry up and get over there.
For or against a party, witness, or attorney. Personal opinions, preferences, or biases have no place in a courtroom. Our goal is to treat all parties equally and to arrive at a just and proper verdict based on the evidence. Do not begin your deliberations and discussions of this case until all of the evidence is presented and I've instructed you on the law. Do not discuss this case among yourselves or with anyone else until your final deliberations in the jury room. This order is not limited to face-to-face conversations. It extends to all forms of electronic communications. Do not use any electronic devices such as mobile phone or computer, text or instant messaging, or social networking sites to send or receive any information about this case or your experience as a juror. We will stop or recess from time to time during the course of this trial, and you may be excused from the courtroom when it is necessary for me to hear legal arguments from the lawyers. If you come into contact with the parties, lawyers, or witnesses, do not speak with them. For their part, they will not contact or speak with you. Do not listen to any conversations about this case. Do not research any information that you personally think might be helpful to you in understanding the issues presented. Do not investigate this case on your own or visit the scene, either in person or by electronic means. Do not read any newspaper reports or listen to any news reports on the radio, television, over the internet, or any other electronic application or tool about this trial. Do not consult dictionaries, computers, electronic applications, social media, the internet, or other reference materials for additional information. Do not seek information regarding the public records of any party or witness on this case. Any information you obtain outside this courtroom could be misleading, inaccurate, or incomplete. Relying on this information is unfair because the parties would not have the opportunity to refute, explain, or correct it. Do not communicate with anyone about this trial or your experience as a juror while you're serving on this jury. Do not use a computer, cell phone, or other electronic device, including personal wearable electronics, applications, or tools with communication capabilities to share any information about this case. For example, do not communicate by telephone, blog post, email, text message, instant message, social media post, or in any other way on or off the computer. Do not permit anyone to communicate with you about this matter, either in person, electronically, or by any other means. If anyone does so, despite your telling them not to, you should report that to me. I appreciate that it is tempting when you go home in the evening to discuss this case with another member of your household, but you may not do so. This case must be decided by you, the jurors, selected for this duty. People not serving on this jury have not heard the evidence, and it is improper for them to influence your deliberations and decisions in this case. After the trial is complete, you are free to communicate with anyone in any manner. These rules are intended to assure that jurors remain impartial throughout the course of the trial. If any juror has reason to believe that another juror has violated these rules, you should report that to me. If jurors do not comply with these rules, it could result in a new trial involving additional time and significant expense to the parties and the taxpayers. You are to decide this case solely on the evidence offered and received at trial. Now, an information is nothing more than a written formal accusation against a defendant charging the commission of one or more criminal acts. You are not to consider it as evidence against the defendant in any way. It does not raise any inference of guilt. The first count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, Wisconsin, did cause the death of Sade Robinson, another human being, with the intent to kill that person contrary to Wisconsin statutes. To this charge, the defendant has entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Now, first-degree intentional homicide is defined in 940.01 of our criminal statutes and is committed by one who causes the death of another human being with the intent to kill that person or another. Before you may find the defendant guilty of first-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following two elements were present. One, that the defendant caused the death of Sade Robinson. Cause means that the defendant's act was a substantial factor in producing the death. The second element is the defendant acted with the intent to kill Sade Robinson. Intent to kill means that the defendant had the mental purpose to take the life of another human being, or was aware that his conduct was practically certain to cause the death of another human being. While the law requires that the defendant acted with the intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even for a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill must be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing the guilt of a defendant, the state is not required to prove motive on the part of a defendant in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. If you are satisfied beyond a reasonable doubt that the defendant caused the death of Sade Robinson with the intent to kill, you should find the defendant guilty of first-degree intentional homicide. If you are not so satisfied, you must find the defendant not guilty. Now, the second count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, Wisconsin, did dismember a corpse with the intent to conceal a crime, contrary to Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of this offense charge beyond a reasonable doubt. Section 940.11 sub 1 of our criminal code is violated by one who mutilates, disfigures, or dismembers a corpse with the intent to conceal a crime or avoid apprehension, prosecution, or conviction for a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following two elements were present. Number one, that the defendant dismembered a corpse. Number two, the defendant dismembered a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and the circumstances in this case bearing upon intent. If you are satisfied beyond a reasonable doubt that both elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The third count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, at 2926 West Lisbon Avenue in the city of Milwaukee, Milwaukee County, Wisconsin, by means of fire, did intentionally damage the property other than a building of Sade Robinson, valued at $100 or more, without that person's consent, contrary to Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of the offense charged beyond a reasonable doubt. Arson is defined in 943.03 of our criminal code and is committed by one who, by means of fire, intentionally damages any property of another without the person's consent if the property is not a building and has a value of more than $100. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following five elements were present. Number one, that the defendant intentionally damaged a 2020 Honda Civic by means of fire. Damage means injured, charred, defaced, and includes smoke damage. Intentionally means that the defendant must have had the mental purpose to damage the property of another by means of fire, or was aware that his conduct was practically certain to cause damage to the property. The second element is that the 2020 Honda Civic was the property of another. Property of another means property in which a person other than the defendant has a legal interest, which the defendant has no right to defeat or impair, even though the defendant may also have a legal interest in the property. The third element is that the defendant damaged the property by fire without the owner's consent or the consent of the owner's authorized agent. The fourth element is the value of the 2020 Honda Civic was $100 or more. The fifth element is that the defendant knew that the 2020 Honda Civic belonged to another person and that the person did not consent to the damage of the property and that the value of the property was $100 or more. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in the case bearing upon intent and knowledge. If you're satisfied beyond a reasonable doubt that all 5 elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. The 4th count of the information in this case charges that Maxwell Anderson, on or about Tuesday, April 2nd of 2024, in Milwaukee County, Wisconsin, did hide a corpse with the intent to conceal a crime contrary to Wisconsin statutes. To this charge, the defendant has also entered a plea of not guilty, which means the state must prove every element of this offense charge beyond a reasonable doubt. Section 940.11 sub 2 of our criminal code is violated by one who hides or buries a corpse with the intent to conceal a crime. Before you may find the defendant guilty of this offense, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following 2 elements were present. 1, that the defendant hid a corpse. 2, that the defendant hid a corpse with the intent to conceal a crime. This requires that the defendant acted with the purpose to conceal a crime. You cannot look into a person's mind to find intent. Intent must be found, if found at all, from the defendant's acts, words, and statements, if any, and from all of the facts and circumstances in the case bearing upon intent. If you're satisfied beyond a reasonable doubt that both elements of this offense have been proven, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. Now, evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who calls the witness. Second, the exhibits the court receives, whether or not they go to the jury room. And third, any facts to which the lawyers have agreed or stipulated or which I direct you to find. You will not have a copy of the written transcript of this trial testimony available for use during deliberations. You must pay careful attention to all of the testimony because you must rely primarily on your memory of the evidence and testimony introduced during the course of this trial. You are not required to, but you may take notes during this trial, except during the opening statements and the closing arguments. I will provide you with these materials. In taking notes, be careful that it does not distract you from carefully listening to and observing the witnesses. You may rely on your notes to refresh your memory during your deliberations. Otherwise, they will be kept confidential. After the trial, the notes will be collected and destroyed. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is the believability of the witnesses and the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on a witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of the trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or the lack of clearness of the witness's recollection, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There's no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with the defendant's innocence, you must do so and return a verdict of not guilty. Now, the term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. I mean, such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth. The lawyers will now make their opening statements. And the purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show, so you will have a better understanding of the evidence as it's introduced during the course of the trial. I must caution you, however, the opening statements are not evidence. State, are you prepared to proceed?
Yes.
Please do so.
Ladies and gentlemen, the judge just read you the preliminary instructions. That is the law that is to guide you as you listen to the evidence in this case. And what I'm going to ask you to do now and ask you to do at the end of trial is two things. And they're two things that the judge just mentioned during those instructions. Use your common sense and search for the truth. That is your job. Over the course of the rest of this week and into next week, you are going to hear testimony from the witness stand. You are going to see exhibits. You are going to see a lot of exhibits and hear a lot of testimony. And all of it at the end is going to boil down to your ability to use your common sense and search for the truth. Your duty is to come to a fair and rational conclusion as to what the evidence shows. And that's how you do that. You apply the law given to you by the judge to the facts that you decide occurred, and decide if Maxwell Anderson is guilty of the charges brought before this court. Maxwell Anderson is charged with 4 crimes that have just been defined to you related to the disappearance and murder of 19-year-old Sade Robinson that occurred on the night of April 1st, 2024 into April 2nd, 2024. Sade Robinson was a 19-year-old young woman. She had an apartment on the Lower East Side, 1858 North Commerce. She was in school. She worked a job. She worked at Pizza Shuttle on the Lower East Side. She was everything that you would expect a 19-year-old girl to be. That day, April 1st, 2024, Sade Robinson went to work at Pizza Shuttle like any other day. And she made plans to meet up with the defendant, Maxwell Anderson, that evening after work. And she wouldn't know it at the time that she left her apartment that morning, but she would never return. Sade and Maxwell Anderson met up for dinner and drinks at the Twisted Fisherman restaurant in Milwaukee. They then went to Duke's bar on Water Street, and then they went back to Maxwell Anderson's house on the south side of Milwaukee around 9:20 in the evening on April 1st. After leaving Duke's and going to the defendant's house, Sade would never be seen alive again. That night, she was murdered by Maxwell Anderson. Her body was dismembered by Maxwell Anderson in a vicious and gruesome manner. And then Maxwell Anderson attempted to make her disappear from this world by discarding her body into body parts into Lake Michigan, and then taking her car and burning it behind an abandoned building near 30th and Lisbon. The evidence in this case is going to prove beyond a reasonable doubt that Maxwell Anderson intentionally killed Sade Robinson and then sought to have her disappear from this world. He cut up her body, tried to get rid of her body parts, and tried to cover it up in any way that he could. For doing this, he has been charged with 4 crimes: first-degree intentional homicide, mutilation of a corpse, arson of property for burning the car, and hiding a corpse. The evidence in this case, the testimony you're going to hear, is going to be voluminous. The judge just told you you're going to be allowed to take notes throughout the course of this trial. I would strongly encourage that you do that. The reason for that is so that when you're back there deliberating at the end of this trial, you're able to look back and understand the significance of things that you heard and remember it, because there will be a lot. So I would encourage you to do so. But at the end of this trial, the evidence will establish that Maxwell Anderson is the one who killed and dismembered Sade Robinson, and it'll prove him guilty of those 4 crimes. This is my opportunity to summarize the evidence so that you have sort of a roadmap as the trial progresses, and so you understand the context of what you're hearing about when you hear about it. You are first going to hear about April 2nd, 2024. Around 5:20 in the evening, the Milwaukee County Sheriff's Office and the Cudahy Police Department were dispatched to the shores of Lake Michigan near Warnemont Park. It was a particularly rainy day. The weather was pretty nasty that day. And 2 young men were walking the shores of Warnemont Park, and they found a human leg. And they called 911. That leg that they found would later be confirmed through DNA testing to be the leg of Sade Robinson. The leg was found down a large bluff at the park on the coastline of Lake Michigan. It's a very secluded location. You are going to see ample amount of photographs of that location. And investigators searched that area north and south of there significantly, thoroughly, but found no other human remains at the park. Now, this park and this location is near the Cudahy Water Department. Investigators also discovered that on April 2nd, April 1st into April 2nd, a vehicle had been used to ram the Service Gate Road near the Cudahy Water Department pump house. This is right next to, about 100 yards away from where the leg was found on the coastline. The Cudahy Water Department personnel reported this actually the morning of April 2nd, prior to the leg being found. Notably, where this gate was smashed, this gate takes you essentially down a service road that goes right down to the shoreline where this Cudahy Water Department pump house was located. And recovered right where this gate was smashed were pieces of a dark blue Honda Civic, 2020 Honda Civic. Sade Robinson had a dark blue 2020 Honda Civic. The pieces of that Honda Civic were recovered from that location. They were ultimately determined by an analyst from the state crime lab that they were not just from any Honda Civic, they were broken off of Sade Robinson's Honda Civic. Video was recovered from the Cudahy Water Department and the surrounding area. And the video showed that near the location of this gate, a dark blue vehicle, Sade Robinson's Honda Civic, entering the park and entering that service road where that gate is at 2:53 a.m. on April 2nd. The vehicle remains down that service road, and there's only one way in and one way out, down that service road for about an hour and a half, and departs that very same service road at 4:32 a.m. on April 2nd. Additionally, on April 2nd, just hours after that car departs the park, at 7:30 a.m., Sade Robinson's Honda Civic was intentionally set on fire behind an abandoned building near 30th and Lisbon. Later that day, April 2nd, 2024, Sade Robinson was reported missing to the Milwaukee Police Department. Friends and family, friends who knew she hadn't shown up for her work shift on April 2nd at Pizza Shuttle, hadn't heard from her, reported her missing. Police followed up. They checked her apartment at 1858 North Commerce Street. She wasn't there. No real signs of what happened. Police would then follow up on the missing persons report, speak to several family members and friends, and discover that she had gone on a date the evening of April 1st after her work shift. They also learned what her phone number was, and they learned from her family and friends that she had an app called Life 360. Life 360 and the phone number, with that information, police obtained phone records from Verizon Wireless, the wireless company that serviced Sade's phone. And those phone records from Verizon Wireless and the records from Life 360 provided very crucial information about Sade Robinson's activities on the evening of April 1st and her whereabouts. Notably, the police discovered a text message conversation between Sade and a phone number that the police would later learn belonged to Maxwell Anderson. The text conversation showed that Sade and Maxwell Anderson were planning to meet at the Twisted Fisherman that evening to get food, and indeed did meet around 5:15 p.m. on April 1st. Additionally, the records from Verizon Wireless, as I indicated, provided location information for her phone that not only confirmed her trip to Twisted Fisherman, but would provide further location information all the way up until about 4:40 a.m. on April 2nd. Police would follow up at Twisted Fisherman, and then through her phone records, also learning that she had gone to Duke's on Water Street. And they got video from those two locations that confirmed that Sade Robinson and Maxwell Anderson met up that evening, first having dinner and drinks at the Twisted Fisherman, and then they went to Duke's on Water Street to hang out and have more drinks. Through all of that information, the phone data, the videos, investigators confirmed they were at Twisted Fisherman from 5:15 p.m. until 6:24 p.m. And then they went to Duke's on Water Street from 6:30 p.m. to about 9:04 p.m. Videos also confirmed that that evening, Sade Robinson was driving her 2020 Honda Civic, the same vehicle that was used to smash the gate at the Cudahy Water Department pump house. Now, this would be time for me to mention it's a common vehicle, Honda Civic. Everyone's heard of one. But it does have distinct features. Honda Civics have sort of distinct features that are going to be worth noting when we go through the evidence in this case. Hers was dark blue. It had a sunroof, and particularly 2020 Honda Civics have these unique sort of C-shaped lights in the rear. And you're going to see those, all features that are noticeable on video, which will become important. At 9:04 p.m., Sade Robinson and Maxwell Anderson left Duke's together, and they left Duke's and got into Sade Robinson's Honda Civic. Sade was driving, Maxwell Anderson was riding passenger, just the two of them. The phone location information from both Sade's phone and Maxwell Anderson's phones, as well as other surveillance videos that you'll see from downtown and the area near Maxwell Anderson's residence on the south side of Milwaukee, confirmed that they drove from Duke's on Water to Anderson's residence. They arrived at his residence around 9:24 p.m., and you will see video of Sade's car arriving at his residence, driving right by the front of his house and then into the alley. At the exact time, her phone location information is showing her phone arriving at his residence. Sade's phone remains at Maxwell Anderson's home up until about 12:45 a.m. on April 2nd. There's a video from across the street from Maxwell Anderson's home that shows silhouettes and movement in Maxwell Anderson's residence for the intervening about 3 hours. The time she gets there, the time her phone shows that they got there, up until about 12:45 a.m. Consistent with Maxwell Anderson and Sade being there. That video from across the street Beginning about 11:24 p.m., all the way up until about 12:45 a.m. on the 2nd, shows some movement beginning in the side yard near where the back door is, where he would come out and go in. That stops around 12:45 a.m. And any human movement that you can see in the upper window stops at 12:45 a.m. Also occurring right after 12:45 a.m., Sade Robinson's phone location information begins to show her phone moving away from Maxwell Anderson's residence, where it's been stationary since her car arrived there around 9:24 p.m. Now, this is a very crucial time in the timeline. And this is where the phone location information that investigators got from Verizon Wireless and Life 360 becomes extremely important. What occurs beginning just after 12:45 a.m. is that the victim's phone moves away from Maxwell Anderson's residence and begins to travel to various locations throughout Milwaukee County for the next few hours. And investigators were able to follow essentially a trail of videos where the victim's phone was showing her phone was at various times. From 12:45 a.m. all the way up until the approximate time her phone goes off the wireless network at 4:40 a.m. This is the time where that unique look of that Honda Civic is going to come into play for you all. You will see investigators followed where Sade's phone appeared to travel to and recovered videos around the county confirming that her car was traveling in those exact areas at those exact same times. So when the phone starts moving away from her residence just after 12:45 a.m., the records show her car driving northbound near 35th Street. Videos pick her car up driving in that exact direction. The phone then ends up downtown around 1 a.m. A camera downtown that actually is a license plate reader camera captures her plate downtown just after 1 a.m. The phone then travels up into the River West neighborhood, where it remains until about 2 a.m., where cameras capture it again. It then leaves River West and heads westbound down Capitol Drive just after 2 a.m., where cameras catch it again. It then doubles back eastbound on Capitol Drive, where cameras catch it again. And the records show it appears to get on the interstate and travel southbound towards and through downtown Milwaukee, and ultimately appear to exit the interstate just around 2:40 a.m., where cameras capture it again. The phone then, after exiting the interstate near College Avenue, heads east in the direction of Warnemont Park. Also captured by a trail of videos. And then by 2:53 a.m., video shows the Honda Civic arriving at Warnemont Park, which is the video I described before of the car smashing the pump house gate. Sade's phone shows her phone records show that her phone remained at Warnemont Park for about an hour and a half, the same amount of time that the car remained down that pump house road from the video. And in that time, police recovered video from that Cudahy Water Department pump house that overlooks Lake Michigan. That video, it's nighttime, it's dark, but it paints a telling tale. It shows, just after that car arrives, a silhouette of a person descending the bluffs near the coastline of Warnemont Park, near the Cudahy Water Department, where Sade Robinson's leg would later be found on April 2nd. That person, the evidence is going to show you, is Maxwell Anderson. This is the time where Sade's body was intentionally discarded into the lake after being dismembered. By this time, Sade is deceased, and Maxwell Anderson, using her own car, is trying to make her disappear. That video from the pump house confirms that he is down there for about an hour and a half before departing the pump house and departing Warnemont Park in her car around 4:30 a.m., which is exactly what the phone records show. Shortly after that, as the phone moves north, it goes off the network around 4:40 a.m. as it heads north into St. Francis towards downtown. Now, investigators also canvassed heavily near the area of where Sade's car was burned, way over on 30th and Lisbon on the north side of Milwaukee. And they also located a trail of videos from this location, picking up around 4:50 a.m., 10 minutes after Sade's phone appears to go off the network. And her Honda Civic is again picked up on those videos in the exact amount of time it would take to drive from where her phone went off the network to the location it's picked up on camera. That trail of videos shows her car, her 2020 Honda Civic, circling around the part of town where her vehicle would eventually be set on fire at 7:30 a.m. The Honda drives around from about 4:50 a.m. to 5:19 a.m., after which it is picked up next on a camera near a playground at 31st and Galena at 6:50 a.m. This is 1.5 blocks away from where her car would later be set on fire. The vehicle drives around more before pulling into the alley where it's set on fire. Police located video from a liquor store and a Milwaukee County Transit bus that depicts the time the vehicle fire was set. Now, you're not going to see it because he parked the car behind this abandoned building that did not obviously have functioning cameras. But these two videos show something crucial. They show two women walking down Lisbon Avenue who all of a sudden stop and begin to act in distress as they are clearly watching something disturbing happen. They're watching the fire being started. They are clearly shocked. They are clearly bothered on the video, which has audio. And right after they see this, a white male walks away from the area where the fire was set as one woman points at him and yells to the passing traffic, "He did that, call the fire department." You will see this white male on video. You will see the distinct clothing he's wearing as he's walking away from Sade's burning vehicle. He's got a dark gray hooded top. He's got dark pants, shoes with white soles, and he's wearing a large camouflage backpack that appears to be very full. Police are able to follow an additional trail of videos of this person, the person walking away from her burning car. That trail of videos will show you that the person who lit Sade's car on fire at 7:30 a.m. boarded a Milwaukee County Transit bus on 35th and Lisbon at 8:12 a.m. And when that person gets on the bus, you will see their face clear as day on the bus camera video. It is him. It is Maxwell Anderson. He then takes the bus southbound on 35th Street and gets off the bus just blocks from his house. You will see that same vehicle, or that same video from across the street from his house that I mentioned before, showing him walking in his back door at 4:30 a.m., or excuse me, 8:43 a.m., right after he gets off the bus. These videos will prove that Maxwell Anderson lit Sade's car on fire, that no one else was with him. He did it behind an abandoned building in a part of town far from his home. Now, you're also going to hear that when police saturated the area, as well as family and friends who were not giving up on trying to figure out what happened to Sade, saturated the area where the car was burned, looking for any clues as to what happened to her. During these searches, family, friends, and police found Sade Robinson's other leg and other foot scattered and severed into pieces near that playground at 31st and Galena, just a block and a half away from where her car was set on fire. You will then hear that on April 18th, Sade's torso was discovered, having washed ashore on Lake Michigan in South Milwaukee. Sade's head had been intentionally cut off of her torso. Both of her legs intentionally severed from her torso. Her right arm intentionally severed from her torso. Her right breast intentionally cut off her torso. The torso was seriously decomposed, but identifying features confirmed it to be Sade. On May 11th, 2024, Sade's right arm was discovered having washed ashore on the shores of Waukegan, Illinois, severely decomposed. You will unfortunately see images of these body parts, which make it clear that Maxwell Anderson intentionally decapitated Sade Robinson, intentionally cut off both of her legs, cut off her left arm, intentionally cut off her right breast, which has never been found, and intentionally cut off her head to date, which is still missing and has never been recovered. While horribly gruesome, this will show you the intent behind what happened to Sade and the intent behind making sure she was disposed of from this world. By April 4th, Maxwell Anderson was arrested by the Milwaukee County Sheriff's Office, and you are going to hear that his cell phone was recovered from him, confirmed to be the same phone that Sade was texting on April 1st, the last text conversation Sade would ever have. Police searched Maxwell Anderson's phone. They searched his residence, trying in any way to learn more information about what happened to Sade. And while police did not locate any kind of gory scene in the residence, they located telling information in his residence and in his phone, including photos of Sade where she is laying on Maxwell Anderson's couch, face down, with his hand grabbing her right breast. And another photo of Sade's pants and her underwear being pulled off her body. The same pants and underwear that you're going to see that she was wearing on video when she went out with him that night on April 1st. And police actually find those pants and underwear in the trunk of her car after it had been burned. You will also hear from police who searched the area around Maxwell Anderson's residence and who recovered the dark gray sweatshirt that Maxwell Anderson was wearing during the time he lit Sade's vehicle on fire. You will see it's clearly visible on the bus video of him getting on the bus where his face is visible. And you're going to hear that hoodie had Maxwell Anderson's DNA on it and Sade's DNA on it. Additionally, you are going to hear from the medical examiner who examined the body parts that were recovered and was able to conclude that Sade's body was intentionally cut into pieces after her death. The medical examiner will describe the wounds to the body and what she noticed that showed the intentional severing of limbs, including the intentional severing of Sade's head. You are also going to hear and see evidence that the shores of Warnemont Park, where Sade Robinson's leg was found, were not unfamiliar to Maxwell Anderson. It was a place he knew well. It was a place he had taken a prior girlfriend to before, and that he called his secret beach. That's the location where Sade Robinson was discarded into Lake Michigan. It was a place he was familiar with and had taken a prior girlfriend to before. In total, what the evidence in this case is going to show is that Maxwell Anderson murdered Sade Robinson the night of April 1st into April 2nd. He then brutally and callously cut her apart, disposed of her body parts, and burned her car. Maxwell Anderson was the last person to text with Sade Robinson. He was the last person to be in public with Sade Robinson. He was the last person to have Sade Robinson's car. He was the last person to be with Sade Robinson. And the evidence will show that he is responsible for Sade's death. You will see, the evidence will show that what happened to Sade Robinson that night was not an accident. One does not end up going out to dinner and then going out for drinks on Water Street for a good time to being dead and cut up into pieces and discarded into Lake Michigan unless someone intends for that to happen. That's what the evidence will show happened to Sade Robinson. And the evidence will show Maxwell Anderson is responsible. At the end of this trial, I'm going to come back before you and again ask you to do what I asked you to do from the beginning, to use your common sense and search for the truth. And if you do those two things, you will find the defendant guilty.
Defense?
That is crazy.
Good morning. The state began by using the phrase common sense. You heard it yesterday during jury selection, and you heard it again today in the state's opening. And they're using the phrase common sense because they want you to ignore the mountain of reasonable doubt that exists in this case. I want to start by telling you guys that much of what Mr. Vance Curzan just talked to you about, we don't dispute. So a lot of this trial isn't in dispute. The timeline, the fact that Max met Sade, Max had met her, went on a date with her, that they went to the Twisted Fisherman, that they went to Duke's, that they were out together that night, that they went back to Max's house. None of that is in dispute. The fact that body parts wash up at Warrimont Park, the fact that body parts are found at 31st and Galena, the fact that those body parts belong to Sade, nobody here is disputing any of that. It's horrible what happened to Sade. It's horrible. Nobody deserved that. And what the state wants you to do is use the emotion of that along with this phrase like common sense and use that emotion to convict Mr. Anderson. But I implore you in this trial, your most important job as jurors is to study the evidence closely that's introduced by the district attorney's office. We have no burden of proof. Max is not required to prove anything. The entire burden lies here and rests here entirely on the district attorney's office. And it's the highest burden in the land to marshal together, to put together enough evidence to bring to you to show that Max killed Sade and that he committed those other crimes. There are a few pieces of evidence that the state will rely heavily on. Max near the scene of the car, Max when it's burning, Max being the last person to go on a date with Sade. And that's frankly why law enforcement zeroed in on Max. You are going to hear that the amount of law enforcement resources that were spent in this case by the Sheriff's Department, the Milwaukee Police Department, the FBI, the amount of resources that were spent on this case, I think is probably unparalleled in Milwaukee history. The amount of money and time and effort that was put into collecting video evidence, to searching Maxwell's home, to interviewing coworkers, interviewing people that might know him, an immense investigation. And the state knows that there are serious holes in their case. They know it. They know that there's reasonable doubt, and that's why they're coming at you with this phrase like common sense. So let's talk about that. There is absolutely no reason for Max to commit a crime like this. What you're going to hear in this trial is that Max and Sade lined up a date together like any couple of youngsters do, and they lined up a date at Twisted Fisherman. This is a place that Max used to work. You'll hear that they went there, they had dinner, and it was an ordinary evening. From Twisted Fisherman, as the state just told you, they went to Duke's. This is another place where Max is known. There was no secret place that Max took Sade that night, nowhere that anybody wouldn't have known him or recognized him. These are former places he worked and coworkers that he interacted with. And what I didn't hear was the theory of why Max did this, how Max did this. But I think what I heard in opening just now is that Max must have done this at his home. That seems to be the theory. Max brought Sade back to his home and killed her. Why? It's a normal date. You'll see them let camera footage leaving Duke's. You'll see them, Sade driving back to his place. You'll see them going there. In this timeline you were just given, I don't know how many witnesses they're going to call throughout this trial to put in this video or that video, but one thing you'll see throughout this is that we don't dispute any of that timeline, that they went out together and went back to Max's house, but that doesn't mean he killed her. How did he do it, and why did he do it? Why would he ever do something like that? If Max killed Sade in his home, if it happened in that location, as I think they're offering to you, there would be a mountain of DNA evidence. There would be blood. There would be some form of DNA. And I listened carefully when I heard the state's opening, because yes, it's gruesome. Yes, it's horrible. Nobody deserves it. But what was glaringly missing from what I heard was any discussion about DNA evidence. We have a crime lab in the state, law enforcement agencies that are tasked with collecting evidence from locations. I believe the theory that you're being offered today is that Sade was killed at Maxwell's house. What you'll hear about Max's house, I want to tell you a couple of things they didn't tell you. One is that the house is a duplex, upper and lower. There's a stairwell you can enter through the side of the home. If you go in the stairwell, there is a lower unit that has a tenant, if you will, a tenant who lives on the lower level. His name is Pete Warmington. You'll hear his testimony in this trial. Max lives upstairs, and the two of them went to that unit, that house. Pete Warmington, who's home on the lower level, is there that night. You will hear that Mr. Warmington is a self-described or self-professed light sleeper. I think one of the things he had said to the police is, even if one of Max's dogs is chewing a bone on the floor, he would even hear that and send messages to Max: your dog is chewing a bone, you're keeping me up, you're bothering me. He's a very light sleeper guy. And what Pete Warmington will tell you is that he was home, he was there that night, there was no struggle, there was no fight, there was no horrific event, argument between Max and Sade, but this is a downstairs tenant who can hear even the TV playing. He doesn't hear a thing, nothing, no struggle, no indication whatsoever that a murder is happening or happened upstairs. There's a common basement they share, but many of you can picture the type of home I'm describing, I'm sure. You walk in the door and it's a small stairwell that goes upstairs. So presumably their theory is that Max killed Sade upstairs. They didn't say it, they're suggesting the home, but upstairs, or maybe the basement is their theory. Either way, law enforcement pulled everything from that home. They searched it not once, but twice, 2 separate searches. You will also hear, by the way, that because of the publicity this case generated, other people had access to that home, social justice people who were riled up online, who showed up at the home, entered, put up banners, entered the home, had access to the area. You'll hear about that too. But law enforcement for sure searched the home twice. They didn't find a murder weapon. What weapon was used to kill Sade? They didn't find any of Sade's blood. With all the samples they took throughout that entire house, every comforter, bed sheet, tabletop, wall, none of it has Sade's DNA, blood or DNA. And then I think the theory is that Max drove Sade's car and dismembered her. That Max did that. With what instruments? And you'll hear from medical examiners in this case, that at least one medical examiner who will testify about the sheer force that would be required to remove human limbs. That's no easy task. It's not the kind of thing that you do with a little Swiss Army knife. It's the kind of thing that you do with things like bone saws that they use in autopsies, no evidence of which Max has ever been in possession of or ever researched anything. They looked at everything about Max: internet history, text message history. His text messages with Sade weren't deleted. They looked through his search history. Has he researched how to cut up a body or how to kill someone? No, absolutely not. No evidence of that. You would expect that if she died at his house, as they are suggesting, that there would be blood and DNA in that home. another thing that wasn't mentioned in opening. At Warmont Park, Sade's body, as you heard, a leg wash is located at Warmont Park. As law enforcement was looking through that area, they found bloody gloves. Now, these gloves played a central part in law enforcement's investigation because those gloves are sort of the quintessential evidence of a dismemberment or a murder. They have blood on them, they're plastic, sort of what you can picture, plastic gloves that you would wear, they're the clear type. And law enforcement, what they do is they try to determine, because they're certain you don't find bloody gloves near the scene, very close proximity to a leg. Certainly these gloves play some role in this crime. And so they look for any connection between Max and these gloves. They go to a place he volunteered at. They go to former places where he's worked. You'll hear that Max has worked at various bars in Milwaukee. He was a bartender is a bartender in the community. In that they looked at these gloves, these bloody gloves that were found by the leg, in that these gloves did not have Max Anderson's DNA on them. None. 1 in a quadrillion, or whatever the statistics are. They're not ever anything that he wore. And with respect to Sade's DNA, it's uninformative. Could be, could not be. Not able to rule it out. And not once do these gloves ever connect to Max, ever. Now, person that's seen him wear gloves like this, they don't match with the place he volunteered at. They don't match at any of the restaurants and kitchens that he's worked at. No connection. Sade's burning car. We know that the car is lit on fire near 30th in Lisbon or 31st in Lisbon, and you'll do with that what you will. I'll say this. The question is going to be, did Max light that car on fire? That's how you get to guilty or not guilty on the arson. Was Max the one who lit that car on fire? I find it interesting, and I hope you will too, that when we look at DNA evidence and we think about the importance of that type of evidence, the reason why it's so crucial is because we know from our human experiences that people can be wrong. We know people can be mistaken. We know that people can believe they saw something when they didn't see something. So I'm going to ask you, all of you, to implore you, study the evidence closely. When you're done with this trial and you take this back in the jury room, study everything very, very closely with a fine-tooth comb. Because eyewitnesses can be wrong, but the way we either prove or disprove it is we collect DNA swabs and we send things to our crime lab and we test them to see, does this link the person to an item? There is no accelerant or flammable liquid that connects to Max, nothing from his clothes where they can say, oh, this jacket he wore had gasoline or lighter fluid on it. But most significantly, they swabbed the exterior door handle of Sade Robinson's car. Her DNA is on her exterior door handle. Max's DNA is not. This is the same car that is burning in that area of 31st in Lisbon. And a person can be, we know from jury selection, in the wrong place at the wrong time. So what of all this video evidence that you just heard about in opening, that there's, and I told you as well, hundreds of hours of video footage that's pulled from Capitol Drive, Lisbon. Interestingly, you will hear, as Mr. Vance Curzan just told you, that when Sade left Max's house, her car actually went to Commerce Street in the Lower East Side, actually right past where she lives. You'll hear that. But what's important about the video evidence, all the footage that they pulled from every, and you'll learn a lot in this trial, the amount of cameras as you can imagine exist, double it or triple it, what you might think is out there. Poll cams that the Milwaukee Police Department keeps throughout the city. Ring doorbells you'd never know are hidden in a certain spot. Convenience stores that have a camera on the side. All of this video, all the hundreds of hours of video of when Sade's, and I say 100-hour collectively because what you're talking about is all these videos that go back hours and they examine all of them. Not one time on any of the video footage do you ever see Max Anderson driving Sade Robinson's Civic, ever. You can see the car, but you can't ever conclude that he is the one who is driving this vehicle. It's a pure speculation. And his phone never leaves his house after Sade goes home. What would one expect to see after an offense like this? What would you expect to see happens with Max Anderson? Perhaps changes in one's appearance. Perhaps they flee town. Perhaps they're acting different and nervous and unusual at work. Nothing changed with Max Anderson's routine after he and Sade had their date together. Continued to go to work. You'll hear from coworkers that managers and coworkers that saw him. He continued going to his jobs. He didn't change his appearance. He didn't cut his hair. He didn't concoct some plan to leave town. He didn't try to talk to the downstairs tenant to concoct stories. None of that. And that's because he wasn't responsible for any of this. There'd be no reason for him to do those things. And when law enforcement did their investigation and began looking into things and looking for her blood and looking for her DNA, they were presented with the fact, and looking for Max on video driving her car, they were presented with the inescapable fact that all of it excludes him. And that's why you hear a phrase like common sense in voir dire and now. And I'm not telling you to ignore common sense, to be clear, not what we're saying. But when they emphasize a phrase like search for the truth, use common sense, it's at the exclusion of an equally, if not more important phrase, proof beyond a reasonable doubt. Justice sometimes is hard to administer. Finding Max Anderson not guilty because there is reasonable doubt is your duty, as hard as that can be in cases where we know that they're particularly gruesome. But Max had nothing to do with these crimes. And the law says it's not enough for him to look guilty or maybe be guilty, or there's a few bad things that look bad. They have to prove it beyond a reasonable doubt. And when you, as jurors, start to go into the jury room and examine these pieces of evidence, you will be confronted with nothing but reasonable doubt, and your duty is to return a not guilty verdict. Thank you.
All right,
Okay, at
y'all.
this point, we're going to pass out notebooks to you. When you get the notebook, put your number on the front so that we know to return it.
All right, y'all, we're going to jump over to Alessi because I did promise that we would watch Alessi's cross of this guy. So I'm going to jump over there for this, and then we'll be back to this case.
Term for it is basically you're going to have some type of,
and I'm going to speed it up too.
Reason. Robert Alessi, sir.
Robert Alessi. Nice to meet you.
Nice to meet you. Dr. Welcher, the area in which you engage can also include, and I believe you used the term on direct, forensics, correct? Do you engage in any forensic activity in your profession?
Yes, the general umbrella of you basically coming in, giving scientific evidence in court applies to forensics. So my main job is action reconstruction and biomechanics. And so that's what I do. Sometimes it doesn't involve court. When it goes to court, that's generally forensics.
Right. So you're here today. That is my question. You're here today, at least in part, with regard to forensics, correct? Because forensics is the Latin term for it is basically you're going to have some type of court or jury presentation. It's for law, correct? Would you agree with that? It's for law, forensics?
I mean, exactly the way you asked that, no. It's for engineering and it's for biomechanics. It's in the court of law. I think is what you're asking.
That's exactly it.
Okay, yeah, certainly for the court of law.
It ends up to a court of law, and forensics is a common term.
Yes, sir.
So it relates to, or it's used in, or it's suitable for a court of law, the analysis. You'd agree with that? It's a general principle?
Yes.
Not a trick question. Okay. And so in forensics, what you're doing, among other things, is you're applying the scientific method and principles in a criminal matter, correct?
Yeah, you're trying to apply as much as possible.
Right. And so the primary goal of forensic science is to uncover the truth and to provide objective evidence that can be presented in court.
That is generally correct. Again, there are elements, for example, this analysis that are relying sort of on subjective evidence, like the testimonial, the witness statements. So it's not solely based, but ideally you'd want it as much as possible based on objective data.
So you would agree that truth and objective evidence is part of the presentation in terms of information for forensics in a court of law?
Certainly objective information. Truth sometimes, again, can be subjective.
Oh, so you don't believe truth? You believe sometimes truth applies and sometimes it doesn't?
If you know for a fact it is true, but if you take someone's deposition testimony, you have to look at it relative to the evidence, and it's either consistent with the evidence or not.
Okay, so now let's go to your direct examination that you just went through.
Please.
Hopefully this is fairly straightforward. You have testified to, and it's varied a bit, a reasonable degree of engineering certainty. Is that correct?
Correct.
You've also, have you used the word sometimes to reasonable degree of scientific certainty?
I might have.
Right. So
I don't know.
in terms of your role as a biomechanical engineer and accident reconstructionist, is it important to engage in a critical analysis of the data?
Critical analysis? Yeah, I think it's important to have a critical analysis. You want to try and look at it from all sides, consider all possibilities.
So it is therefore important to try to review the data as objectively as possible. You had mentioned sometimes subjectivity comes in, but I understand the goal is to try to look at it as objectively as possible, correct?
Correct.
Now, you stated with respect to your conclusions early on in your direct testimony and your analysis that you don't, and I think I've got it quoted, you don't have a dog in the fight. Is that what you said, sir?
I did.
And that you, quote, don't care, end quote, about the outcome. That's what you made a point of saying in the beginning,
That is
correct?
100% correct.
Now you simply follow the data. Is that correct?
I try to do that.
You try to do that.
I'm not perfect. So
Okay.
I do my best. I believe I've done it here.
Okay. So in terms of, you've agreed that you apply the scientific method. So I want to see if you're in agreement generally so the jury can understand what the scientific method is. Are you familiar with NIST, National Institute?
Yes.
Yeah. So would you agree with this definition of the scientific method? The systematic pursuit of knowledge involving the recognition and definition of a problem, the collection of data through observation and experimentation, analysis of the data, the formulation, evaluation, and testing of hypotheses, and where possible, the selection of a final hypothesis. Is that a general fair statement of the scientific method?
So for forensics, you'd have to add in the testimonial evidence aspect of it. So those are testimonial, or things are in evidence. So frequently there's one or two versions, and you're trying to match which version is most consistent with the evidence.
Okay, adding that to what I stated relative to NIST, you would agree that evaluation and testing of hypotheses, and where possible, the selection of a final hypothesis is the scientific method, correct?
Generally, yes.
Is it correct that a proper biomechanical injury analysis utilizes a sound scientific methodology that's been subjected to peer-reviewed and a publication that's been generally accepted in the engineering community?
Well, I can't. So this, I've done my analysis here, biomechanical analysis. I can't submit this analysis to peer review. I'm not allowed to give this to people outside the court. So there would be no way for me to submit my analysis for peer review. So this occurs forensics all the time. The forensic analysis in court generally never goes under a peer review process. The methodologies underneath it, and looking at, like, for example, I think I referenced 25 papers in my report. That goes to the issue of trying to follow the science. 26.
So I think you may have misunderstood my question, sir. I was talking about your methodology, your biomechanical injury methodology. The methodology that you use and apply is to be subject to peer review and general acceptance in the engineering community. Is that correct?
So I have no way of publishing this analysis.
I'm
So
sorry, sure to
get
interrupt
peer,
you.
I need to,
Go ahead and answer your question.
You're asked peer reviewed, like you said, means I give it to my peers. I send it out to somebody to review for the scientific method. That's what the peer review process is. So I will gladly send this out to peer review with the court's permission, but I haven't and cannot do that.
Sir, my question is not your analysis here in this case.
Oh.
My question regards the methodology that you used here. Is the methodology, you said 26 references, right? My question is simply, is the methodology that you used for your analysis in this matter, is the methodology for a proper biomechanical analysis, should that methodology be generally accepted in the engineering community?
I think with the forensic application, yes.
Okay, that was my question, just the methodology. Thank you.
You're welcome.
Now, the scientific method that you've used in this case, part of the use of scientific method, the purpose is to avoid what is called bias in the scientific method, right? Not cultural bias, but just bias in terms of the application of methodologies and principles. You would agree that's a pretty fundamental purpose of the scientific method, is to avoid biases?
The purpose of the scientific method is to get the most logical and correct answer without bias.
Exactly. To do it apply the scientific method without bias being part of the application of the method, correct?
That's hopefully what you can do.
That's hopefully what you can do. That is the goal, right?
That is one of many goals, yes.
So are you familiar with the term confirmation bias?
I am.
And that relates, confirmation bias is part of a larger term. Are you familiar with cognitive bias?
Generally, I'm not a human factors expert, though.
Pardon me?
I'm not a human factors expert.
All right, biases are, don't you agree that cognitive biases are not just for one category? You would agree it applies to medical analyses, it applies to doctors doing studies, engineers doing studies, and other scientists doing studies?
So I'm not a cognitive expert. I think I would generally agree with it, but I don't want to step out of my lane. I'm not an expert on cognitive. I can talk to you about confirmational bias, if you like.
Let's talk about confirmation bias. Now, confirmation bias is actually when someone selectively gathers and interprets evidence to confirm one or another's beliefs, as well as neglecting evidence that contradicts those beliefs. Is that a fair statement of confirmation bias?
That is a statement. Yeah, it could be broader, but sure.
But you would agree that that is generally correct, what
Generally,
confirmation bias is. And an example of confirmation bias is not considering alternative hypotheses once an initial hypothesis has been selected, even though data and information might contradict the initial hypothesis. Is that an example of confirmation bias?
That could be, yes.
And confirmation bias is antithetical. It's against the scientific method. It's to be avoided, correct?
You would like to avoid it, yes.
Are you familiar with the term failure analysis?
Generally, you might need to define how you're using it for me.
Sure. So is failure analysis the enablement of a scientific examination of an alleged incident by beginning at the undesired consequences? Is that a fair use of that phrase?
I was thinking something different, like a piece of metal failing. I guess it could fall into that category.
Okay. And would you agree that the first question, or one of the first questions that are to be asked by a biomechanical engineer when conducting an analysis of, say, an injury, is how did this happen? Is that one of the first few questions that you ask?
No, that's usually the last question.
Oh, so for you,
So hold on a second.
okay, I'm sorry.
Generally, what you want to do is gather data. You want to know what injuries there are, what evidence there is, like, for example, on the vehicles. And then the very last thing you want to know or define is, given all that information, how did it happen? So that's the end.
I think you may have misunderstood my question. So I wasn't talking about the method or the process. I was talking about when you get to answering questions, whenever that is in the process. Isn't one of the questions, and maybe one of the first questions, how did this happen?
No, that's not one of the first questions. One of the first questions is, where's the damage? What are the injuries? What's the evidence? What black box or text stream data do we have? What physical evidence was at the scene? So that is certainly not one. It is a question, but that question is at or near the end.
Isn't every one of the questions that you just mentioned part of the data gathering?
Correct. But,
Okay.
but when you're gathering data, you're always asking yourself questions along the way, like, what is this? Where did it come from?
But you would agree that for you, at least some point, it's how did this happen, correct?
Yes.
And don't you ask that question to come up with hypotheses?
I generally have many working hypotheses as I'm working on the case. And then as the evidence comes in, I'm applying that to my hypotheses and either accepting or rejecting the hypotheses based upon the factual information.
Sir, how then is it just a matter of logic or a syllogism? If you don't ask the question, how did this happen, until the end, how do you then not get your hypotheses up front when, under the scientific method, you should be having different hypotheses up front? How is it that you ask the how did it happen in the end and not go through hypotheses in the beginning? Can you help me with that logic?
Sure, I guess I misunderstood. Like, I was trying to give you an answer to how it happened. So when you're answering how it happened, or you want to be able to answer that question, you want to make sure you've looked at the totality of the data, accepted, rejected, things as they came along, to be able to answer that final question, how did it happen? But along the way, like, for example, a right eye laceration, you want to know how that happened. So you look for the evidence of how that may have happened.
So you would agree then that questions of how it happened, formulating and identifying hypotheses, does and can happen toward the beginning of the analysis. It doesn't happen at the end all the time. Would you agree with that?
So the ultimate question of how did it happen happens at the end. The questions about the elements of what occurred to make it happen, those occur at the beginning, middle, all along the way.
You would agree that creating hypotheses occurs more toward the beginning than toward the end of the analysis. Is that correct?
There are probably more hypotheses in the beginning, but I am continually forming, looking at hypotheses, either accepting or rejecting them upon the evidence.
So you would agree that the creation of hypotheses does occur more toward the beginning of the analysis. You would agree with that?
There are more towards the beginning. The process occurs throughout the whole investigation.
Right. I'm asking about the hypotheses, sir. You would agree that the hypotheses occur more toward the beginning than the end, just the hypotheses.
So I don't know if you and I are saying different things. More hypotheses in the beginning because you have more questions in the beginning. You continue to form hypotheses as the data presents itself. So you don't stop the formation of hypotheses. It's just as you get more evidence, you window down the number of questions.
Maybe I can just this last question and make it clearer for you, sir. You would agree, not analysis, which you added, as I heard it to the last part, just hypotheses.
Mhm.
You would agree that even though hypotheses can be created and changed, perhaps all the way up to the end,
Mhm.
you would agree that it's important in the analysis to create at least some hypotheses, plural, in the beginning, correct?
Yes.
And once you create these hypotheses, would you agree that those hypotheses should be tested?
So if you take the word testing to mean testing compared to testimony, compared to physical evidence, yes.
And when you test those hypotheses, isn't it often the case that, particularly in your line of work, the one that most consistently produces the same injury will emerge as the mechanism of injury?
I guess it depends on the scientific evidence behind it. Again, sometimes we get very unique injuries.
So my question, sir, is this.
Mhm.
Isn't it the case that when you have multiple hypotheses,
Multiple hypotheses.
the one that most out of all of them, it's a relative thing, the one that most consistently produces the same injury emerges as the mechanism of injury? Is that a fair statement?
I think generally, again, it's on a case by case basis. You have to look at the science and the facts of what you're basing it upon. I think as a general premise, what you're saying is accurate,
Okay,
but there's exceptions.
fair enough. But as a general principle,
Sure.
with some exceptions, that's a fair statement, correct?
Yes, sir.
We're going to have several topics, sir, and what I'm going to try to do to make it a little clear is I'm going to say when I'm switching topics.
Oh, good.
So what I'd like to do now is switch topics.
Okay.
You're aware that the Massachusetts State Police has troopers who specialize in accident reconstruction, correct?
Yes.
And there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section whose sole responsibility is to engage in accident reconstruction. Do you know that?
I do not know that.
Do you know that there are troopers within the Massachusetts State Police Collision Analysis and Reconstruction section who engage in accident reconstruction?
Just based on what I've seen in this case.
Right, based upon what you've seen in the case, that's a fair statement.
And I just know that those people are doing it.
Are you familiar with a Massachusetts state trooper named Joseph Paul, P-A-U-L?
Yes.
And you
Well,
know,
I'm familiar with his reports. I don't know the man.
okay, familiar with Trooper Paul through his reports in this case, correct?
Correct.
And are you aware that he was assigned by lead investigator, former Trooper Michael Proctor, to be a constructionist in this case on January 29th of 2022, as evidenced by that report or those reports of Trooper Paul? Do you know that?
Well, you put a lot of things in there. I know he issued a reconstruction report. I don't know who told him to do it. So the first party question, I don't know, but I did see a reconstruction report from him.
You were retained, and so do you recall, is the date January 29th of 2022? Is that a rough time period of him being assigned, or you don't know when he was assigned?
Don't know. That might have been in his report, but I wouldn't have paid attention to when he received an assignment.
Do you know when the date of the first report of Trooper Joseph Paul in this case?
I can pull it up. I do not know off the top of my head.
You know that the date of the incident in question is January 29th, 2022, correct?
Correct.
Yet your firm and you were retained for this case by the Commonwealth 2.5 years after the incident in question. You were retained, your firm, on September 23rd, 2024. Is that correct, sir?
No, I believe we were retained a couple days before that.
A couple days. Okay.
Right.
So
Actually, I might be able to find out if you'd like me to look at the documents.
it's not all that important. You would say it's within a week of September 23rd, 2000. It was in September of 2024.
I believe it was in September, yes.
Right.
I would
So-
want to double check.
That's 2.5 years from the date of the incident in question, if I did the math right, correct?
Oh, I never thought about it. Yeah, approximately.
And as we just discussed, and you stated on your direct examination, you have no dog in this fight, correct?
Correct?
On November 5th of 2024, your firm Aperture was paid $44,500 by the Norfolk County District Attorney's Office to conduct work that was at least similar to the work of Trooper Paul, correct?
I have no idea. I don't get the billing or the statements.
Do you recall whether Aperture has, well, do you believe Aperture is working for free in this matter?
Oh, no, I don't believe that. No,
So you
we're an
would,
engineering company. We bill for our time.
so you know that Aperture is getting paid for its work in this case, correct?
We are billing for our analysis work.
Well, you're not just billing, you're billing and getting paid, correct?
So I have not seen any of the payments. I would assume that we're getting paid, but I don't know that.
Sir, you are a senior vice president of Aperture, are you not?
I am.
You would know, wouldn't you, if your firm was not getting paid for work since September 23rd of 2024, wouldn't you?
No, probably not. Usually it takes, 9, 10, 12 months of not getting paid before the accounting department reaches out to me.
Exactly. So you've been on this for 2.5 years. So if it would take 9 months or 12 months, if you weren't getting paid, you would have been notified by that by now, correct? According to your own answer you just gave.
I've not been on this case for 2.5 years.
I'm sorry, sir. Let me go back to the question of payment.
Hold on. You said I've been on this case for 2.5 years. I was retained in September 17th-ish of 2024. So that's what, less than a year ago.
Understood. I'm moving on to the next question because I want to move away from that discussion and just
Okay.
go right to the billing. You, as you sit here today, do not have a recollection of whether Aperture has been paid. Is that your testimony?
It has nothing to do with recollection. I'm not part of that process. We have an accounting department. I don't have any involvement in that.
Are you, so is your testimony you have no knowledge about any contractual relationship between Aperture and the Commonwealth?
Oh, no. I was sent a contract by the Commonwealth to sign. So I'm aware of the contractual agreement, but the day-to-day or month-to-month invoicing and billing, I'm not involved in that.
Okay, so you're aware there's a contract between Aperture and the Commonwealth,
I signed it.
and you signed it. And wasn't that contract obligating the Commonwealth to pay for the services of Aperture? Isn't that the purpose of the contract, in part?
In part, sure.
Yeah, it's a legal obligation of the Commonwealth. Your firm does work and the Commonwealth pays for it, correct?
That's the idea.
Right. And so you know about that contract because you signed it.
Correct.
Also, you testified on direct that there was a purchase of a Lexus exemplar for your testing.
Correct.
Who pays for that Lexus exemplar?
Aperture?
And is that then cost passed on to the Commonwealth?
No.
So you pay for the Lexus, you don't pass that cost on, correct?
So what we're doing is we paid for the Lexus. We're keeping it till the trial's over. we're selling it and charging the Commonwealth the difference in the price.
Exactly. That was where I was going, sir. So,
But they're only paying the difference. So, and in theory, if we sell it for more in California, then we'll reduce the bill.
okay, I don't want to speculate. I just wanted to see what the obligation was. So
The
if
obligation is the difference.
exactly. So the obligation is the difference. Are you aware that on April 5th, 2025, the Norfolk County District Attorney's Office amended your contract? Are you aware of that, sir?
I am.
And isn't it the case that that amendment authorized the amount of $325,000 to be paid to Aperture? Isn't that what that amendment contract states?
I believe that's correct.
So the Commonwealth is obligated to pay at least $325,000. And is that correct?
That is you're asking me a legal opinion now about a contract. That is my understanding of how contracts work, but I'm certainly not an attorney.
And on top of that, are you aware that Aperture has been already paid $44,510 for its work? Are you aware of that?
But the second time you asked me, no, I'm not aware of anything we've been paid.
And as you stated yourself, those amounts reflect, as you say, less than 6 months worth of work?
That's not what I said.
Well, no, my question is, you've been on the case, you said, since September of 2024, when we were talking about dates. You said that was about 6 months that your firm's been retained. Did I have your answer correct about how long you've been on it?
I guess it's closer to 8 months.
All right, so 8 months. So for 8 months of work, about $400,000. Is that correct?
So there's 3 offices working on the case. There's the Boston office, there's Mr. Burgess's office, and there's my office in Long Beach. I only know about the billing from my office.
But you signed the contract on behalf of all of Aperture, not just your office, correct?
That I don't know, but I definitely did sign a contract.
Would it refresh your recollection as to who you signed the contract on behalf of, whether it's all of Aperture in all offices, if I showed you the contract?
Sure.
May I put you on?
Yes,
May I put you?
yes.
Sir, may I say more?
Yeah, could you direct me so we're not wasting time?
Well, what I'd like to do, with the witness, Your Honor, is just ask the witness a question with regard to it.
Why don't you just take a look at that, Dr. Burgess?
Thank you, Your Honor.
And then when he's done, Mr. Alessi, you can take it back to the podium.
Yes, Your Honor. Thank you.
There you go.
I have a few more questions before I do that, Your Honor, for foundation purposes, if I want to do more than refresh.
All
Or
right,
would you like me to start with
So-
refresh?
go ahead and start with refresh. Go back to the podium, please.
Sure.
Thank you.
Thank you, Your Honor.
Dr. Welcher, does that refresh your recollection as to the contract you signed on behalf of Aperture with the Commonwealth?
So it lists the legal address as my office. So for my office, yes.
So are you saying that therefore, and did you see the amount that was in the contract? Did that refresh your recollection?
Oh, no, I didn't even look at that.
Do you recall the amount that of obligation that the contract relates to in this document? Do you recall that?
You just asked me that earlier, and I'm taking what you said to be true. So I was like $325,000. I have no reason to disbelieve that.
And is there Also, do you recall the total maximum obligation for the contract that's listed in the contract? You
No.
recall it? May I approach, Your Honor?
Okay.
And Dr. Welcher, I am now going to, you asked me last time, I hope this is helpful.
Please.
You said, please point to the applicable part so we can do it faster. I am now pointing to that part and see if you can just look at that and see whether this refreshes your recollection on the maximum obligation of the contract pursuant to this contract. Without saying what it is, just does it refresh your recollection?
No, but I don't have any reason to believe it's not correct. And that is my signature on it.
Right. And we got started on this conversation tying it to, well, we got started on this conversation with regard to a statement you made earlier in your direct that you didn't have any dog in the hunt. You recall that statement in the beginning of your direct testimony.
You misquoted me. I don't have any dog in the fight.
You don't have any dog in the fight.
Correct.
Thank you. Now, switching topics,
Okay.
you submitted an updated PowerPoint presentation, the one that you went over on your direct examination. You created that presentation quite recently, correct, sir?
The updated one was where I had redacted or taken out slides. So in terms of taking out slides, I did add one alternative path a couple weeks ago.
Okay, my question, sir, is this.
Mhm.
The updated presentation, we'll get to the changes later, but the updated presentation, you created just how many days ago?
I'm going to say weeks ago.
Weeks, 2 weeks?
I don't actually know without looking at the documents.
Well, was it more than 3 weeks ago that you created it?
I still don't know without looking at the documents.
Do you know when the trial started in this matter, sir?
I do not.
Assume the trial started approximately April 22nd of 2024.
Okay.
Did you create your updated presentation before or after April 22nd of 2024?
I don't know.
Do you know when?
Hold on one second. Dr. Welch, I'd ask that you not do.
Not look at,
anything.
okay, I was going to try and answer his question. My apologies. I will shut it down.
Thank you.
You're welcome.
If I may, Your Honor,
Yes.
continue. Are you able to determine when you created the updated presentation?
I think so. That's what I was attempting to
Your
do.
Honor, may he do that?
Yes, I'm going to see Counsel at sidebar while you pull that up,
Thank you,
please.
What's up, everybody? I can't believe I got my camera on today. It's probably because I don't feel like I look super crazy. But y'all know we are actually really watching the Sade Robinson trial. So we will switch back over to that. I did promise the Alessi cross of this gentleman because I knew it was going to be theatrical. Okay. Alessi is laying it down. Thus far, this man don't know. This man has his company. I think the people out there cutting my grass. Maybe this man has his own company. He just basically got him to say that he don't even know. Okay, Sade Robinson's on a 10-minute break. We're gonna go back over there because we stopped after opening arguments. So we're gonna go back over there and continue to watch while they are at their sidebar as usual. Share this tab.
Okay.
Yes.
Could you please be seated, state and spell your name for the record?
My name is Osir Storell, Rusterrell.
Please proceed.
Good morning, Mr. Terrell. Do you remember the evening in the 5 o'clock hour of April 2nd, 2024?
Yeah,
Why do you remember that time and day?
it was
Ooh,
pretty
I'm all in my
miserable.
nose.
It was raining like pretty bad.
Where were you?
I was over by the beach.
And where, are we talking about in Milwaukee?
Cudahy.
Okay, is there a particular park or area that that beach is associated with?
Warmont.
Warnemont Park?
Yes.
Okay, were you there with anyone?
Yeah, a buddy of mine.
Who's that?
Evan.
What's Evan's last name?
And you couldn't ask me that a million times.
And you don't know?
No.
Okay, so what happened at the beach that made you remember this day?
We were walking down there and there was a severed leg.
A severed human leg?
Yes.
Okay, where was that?
It was near the end of the trail down there.
Before we get into more details about that, could you describe what this area is like?
It's pretty, there's a lot of clay falling it down from the cliff nearby. So it's pretty iffy if you can even get down there sometimes. And that week it was raining pretty bad, like all week.
Okay, so you described the day that you were there as being pretty miserable in raining.
Yeah.
And you remember, do you remember that it was raining previously in the week?
Yeah.
Okay, can you describe, Warnemont Park's a big area, right?
Sort of.
Okay, can you describe the area and how you would get down to the beach area that you're telling us about?
So there's two ways you can go down there. You can start from Sheridan Park and walk down the trail that way, but you're still gonna have to climb over a lot of stuff. The other way is there's like a gate on the south side that you can go down, but the hill is pretty steep. And even when you get down there, you have to climb through a couple trees just to get to the area. And it was raining for the past week, so it'd be pretty miserable to do it.
The gate that you're talking about, does that, is that part of a paved road,
Yeah.
like a service road?
Yeah.
How did you become familiar with that area?
I've been going up and down that entire area for years.
If you were just in Warnemont Park, not down by the beach, would you necessarily be able to see this area?
Yeah, but there's a lot of trees in the way. You'd have to be like kind of at a weird angle.
And would that be like from the bluff area?
Yeah.
So you're down there with your friend, Evan, right?
Yeah.
Describe where you're walking when you see what you discover to be a human leg.
Kind of like the beach line, really rocky area. It was covered in clay and just stuff falling from the cliff. It's probably like this much ability to walk around the area.
Okay, and you're holding your hands out, maybe
Yeah.
a
Yeah.
3 or 4 foot, 3-foot spread?
Yeah.
Okay. And what drew your attention to that bluff area?
It was just the intention the whole time. There's no other way we couldn't go back just because the waves were pretty like extreme that day. So we had to go over there and we just had no choice.
What drew your attention to the leg?
It was a pretty narrow path, so it's kind of hard to miss. At first we thought it was like a mannequin leg, but then we got a closer look and realized what it really was.
How'd that make you feel?
It's kind of hard to say even now. I don't think it's really hit me, but yeah.
What did you do?
We went up pretty much immediately, called the cops, and that's all I really remember from that time.
The police department came, right?
Yeah.
And did you have contact with a police officer or a couple police officers?
Yes, but most of the time I was in the car.
Okay. Were you down with the police officers on the beach area?
No.
You told them what you told us here today.
Yes.
I don't have anything further. Thank you.
Cross.
Did you see any other people down by the beach when you were there?
No, it's just us that day.
That's all.
State anything further?
No.
Thank you, sir. You may step down. State your next witness.
The state calls Officer Zachary DeSmet.
Do you solemnly swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you could please be seated, state and spell your name for the record.
Name is Zachary DeSmet. First name is Zachary, Zachary. Last name DeSmet, Desmet.
How are you employed?
The city of Cudahy.
As a police officer?
Yes, ma'am.
How long have you been with the Cudahy Police Department?
4 years.
Were you working on April 2nd, 2024?
Yes, I was.
And were you dispatched to Warnemont Park that day?
Yes, I was.
Around what time?
It was in the afternoon, early evening, late afternoon.
What were you dispatched there for?
I was dispatched there for a call reporting that they found a human leg on the beach.
Warnemont Park, is that in the city of Cudahy?
Yes, it is. We have two parks, Sheridan Park and Warmont. They border each other.
So the Cudahy Police Department has jurisdiction over that area?
Typically, it's the sheriff's department that handles the parks, but if there's any imminent calls that come out or anybody that needs help immediately, we'll respond initially to stabilize the scene, and then it's usually turned over to the sheriff's department if needed.
Are you familiar with that area?
Yes, I am.
Can you describe the weather that day if you remember?
The weather was pretty rough. It was rainy, very cloudy, strong winds, especially down at the beach.
What did you do when you got there?
Excuse me. I arrived on scene traveling east on Pulaski Avenue, which comes from Lake Drive into the park. The water department is on the northeast corner of the intersection. Drive down, and then you'll come into with Sheridan Drive, and then there's another drive that leads down to the actual pump house with a gate. Arrived on scene, parked on Sheridan Drive facing north, and then observed two males in the field that would lead to the gate.
That location is in the county of Milwaukee, correct?
Yes, it is.
Describe I think what you described was like a service road with a gate.
Correct, yes.
Can you describe that further?
When you get, so there's the intersection, and then before you could turn right or south into Warnemont Golf Course or north onto Sheridan Drive. But then if you continue east, it's probably, 20 yards worth of road, a service gate, and then there's a gap in the fence where people can walk themselves.
Did you notice anything unusual about the service gate when you arrived?
I did. I noticed that it was pretty heavily damaged.
So that's not a service gate that's like open to the public, right?
Not usually, no. I think only our water department has access to that.
Was there anything else aside from the gate being damaged in that area?
Not initially when I observed, no.
But you said there were two individuals in a field.
Correct.
Were you able to identify those people?
Yes, we were.
Who were they?
It was Evan Millies and Osiris Terrell.
What did you later learn they were?
The people that discovered the leg down at the beach.
Was one of them the 911 caller?
Yes.
And did you have contact with them?
Yes, I did.
What happened next?
Well, I observed them to be, especially Mr. Millies, to be in a kind of a frantic state, obviously seeing something like that. They gave me a brief rundown that they think they found a human leg at the beach and wanted to show me where it was. So I had Mr. Terrell sit in the back of my squad car. I'm more familiar with Mr. Millies, so I had him take me down to the beach. We went through that side gate or at the opening in the fence where people can walk through freely. When you walk down, it's a steep hill because at that point of the park, it's very cliff-like. So there's the service drive down to the actual water pump house is very steep, so we walk down there.
Can you further describe that area?
Sure. So when you're walking down the service drive, like I said, it's very steep. It's wooded on both sides with a little bit of an embankment that goes up the sides of it. And when you get down to the bottom, it's actually brand new, renovated, I think last year or the year before. It's a pretty open area for vehicles to park. And then there's a building on the right-hand side that has a fence around it that I believe has 2 security cameras, barbed wire. It comes down to the lake. There's large rocks at the end of it where it immediately abuts with Lake Michigan.
What is that building?
That's the pump house.
Okay. And that is a Cudahy city-owned building?
Correct.
You said the newly renovated parking area, is that open to the public or is that for the pump house?
That's for the pump house.
Okay, so there's not another public access to that area, is there?
That's correct. There's not.
So can the general public drive a car down there?
No, they cannot.
Can you further describe, as you're going down there with Mr. Millies, how he directs you towards the leg?
Sure. So when we got down to the bottom, he had pointed me north from there. Obviously, there's a lot of debris on the beach, driftwood, rocks, etc. So I couldn't just clearly see it, especially with the distance. Now I am an evidence technician, so I know one thing that's really harped on in those trainings is keeping the scene secure and to not contaminate it as needed. So my initial plan was where there's the parking lot, there's kind of a steep hillside next to it where you can walk down. However, it was kind of sketchy that day because of the wetness. So my initial plan was I was going to have Mr. Millies stay up there. I was going to go down to the beach and then have him point me in the right direction as well as yell direction to me. I attempted to do that, but after, like I said, with the wind and the waves crashing after about 20 yards, I couldn't even hear him anymore. So I reapproached him, had him come down with me. At that point, I had him walk in front of me. He had a jacket on, so I grabbed the back of his jacket just to be able to direct him. Or if I saw anything that I thought was of evidentiary value, I could direct him or prevent him from destroying or stepping on it.
Can you describe, once you leave like the parking lot pump house area, is there a path? Is it like is there a clear way to get to the beach from there?
Not really. Like I said, there's kind of a hillside on the side that is walkable, but again, depending on the conditions, it can be kind of iffy. That day was kind of rough, but we were able to get down there. The beach at that part is primarily rock, smaller rock, but still kind of generally unstable to walk on. And then you'd have the lake or Lake Michigan on your right-hand side or the east side. And then on the west side would be a steep cliff, essentially, from Warnimont and Sheridan Parks.
As you and Mr. Millies are going through that area, what, if anything, do you see?
So, like I said, there's a lot of water coming down off the sides of the cliff, a lot of debris. The waves were crashing pretty heavily. While I was walking down there before that, Mr. Millies told me that the leg was actually located on the side of the cliff, or the side of the embankment, about 10 to 15 feet up. So as we were walking north on the beach, that's where I was initially looking.
So it was up from the water line?
Yes.
Approximately how far?
10 to 15 feet, he said, up on the embankment.
At what point do you see it?
We were walking probably for a little bit, probably about 100, 125 yards. And like I said, we were both looking left to the cliff, and he was estimating and saying that like it should be right around here based on some things that he had seen. And then as we continued walking, he got startled really quick. And I was like, "What's up?" And he's like, "It's right there." And so I had moved him to the side, and about 5 to 8 feet in front of us was the leg was located there.
And where was it relative to the embankment?
It was close to it, probably within 10 to 15 feet from the embankment.
Given the rain, was there erosion that was happening?
Yeah, there's some pretty severe, even you could see different streams cutting lines into the sides of the cliffs.
What did you do next?
At that point, I radioed my dispatchers and advised them that the leg was there, was confirmed, to request MCSO's response to shut down the scene. The only ways into the scene are from the Pump House Road and the S-curve down in Sheridan Park, which would be a significant walk, and then advise them on how to get to my location.
Before we go further in that area, can you describe how you would access that area from Sheridan Park?
From Sheridan Park, which is quite a ways north, probably at least half a mile, I'd say, or somewhere in that ballpark. You have to walk down a path. It's a steep path, but it goes down. It is paved down to the beach. Then you'd have to walk further south. You'd have to walk south quite a ways on that beachfront to even get to that scene.
What, when you located the leg, what were your impressions? What were you able to readily discern?
I could readily see that it was, I believe to be a black female, a leg from either a late teenager or, younger black female. The leg was short and had pink nail polish on the toenails.
What did you do then?
At that point, I had Mr. Millie's stay. I put him on a rock, a bigger rock there. I told him to stay there, not move, and he stayed there until the MCSO deputies Leon Martin and Michael Kruger arrived on scene, which at that point he was later escorted up there, back up the hill to where I would assume he would be interviewed further in depth.
So the sheriff's department joined you.
Correct.
In your walk with Mr. Millie's down the beach and in your observations in the area around the leg, was there anything else that you located?
I believe that on the way down there, Mr. Millie's made me aware that there was like a bra and maybe a t-shirt that were located, but he was unaware if it was related.
Then what did you do?
At that point, deputies Martin and Kruger took Mr. Millie's back up to interview him. Upon further investigation, I was looking at the leg that it was cut from the basically hip joint down to the foot. Other than that, the leg did not appear to be disturbed, and I observed the cuts on the leg to be clean and not intentional, or intentional, I mean.
That the cuts were or were not intentional?
Were, that they were straight, not jagged, not torn.
Did you move the leg at all?
Yes, I did. I had to move it 2 or 3 times just because the time of the day, the waves were getting, like I said, we were getting some pretty good waves and they were moving further and further inland. So 2 or 3 times I had to move the leg further west to prevent it from being taken by the water, which was documented on body camera as well.
How did you do that?
I grabbed it by the ankle with my left hand and under the thigh with my right hand, physically picked it up, moved it about 5-10 feet, set it down in the same way that it was laying, and then advised my dispatch to log that it had been moved.
Did it appear to have been in the water or decomposed?
It did not appear to be decomposing. It appeared to be fresh just based on my experience with other deceased humans. And there was a lack of blood. I didn't really see much blood on it at all, which also could be attributed to the rain that had been coming down.
That beach area, how would you describe the area in general?
It's usually pretty calm. We don't really ever get calls there mostly. Anything, it's usually like a dog complaint or someone just kind of loitering. But it's a beautiful area. It's not frequently traveled. It's hidden, secluded. Like I said, that was the second time I've ever been down there for an actual call.
Thank you. I have nothing further.
Cross?
How long have you been a police officer?
4 years.
Okay, with Cudahy the whole time.
Yes, sir.
And Warmont Park is entirely within the geographical area of Cudahy, right?
Yes, sir.
And we have, would you agree with me that the park itself is 248 acres?
Sounds about right.
It has an 18-hole golf course,
Yes.
has a dog park.
Yes. Further south, much further south, the dog park is, but yes.
Right, because Warmont Park stretches along the coast of Lake Michigan, basically, right?
Correct, from about Pulaski Avenue down to College Avenue.
Exactly. And so there's walking trails, right?
Yes, there are.
And you said there's a dog park also at Warmont Park, right?
That's correct.
And isn't the Oakleaf Trail, doesn't the Oakleaf Trail run through Warmont Park or into Warmont Park?
It does go through it.
Right, there's trails you can run on from Cudahy in Warmont Park and head north if you wanted to, right?
Yes, there's one paved path that goes to the park for the Oakleaf Trail.
And there's even races that go through there. There's the South Shore Half Marathon, for example, that runs through that area, right?
There have been, yes.
So the park, when you say secluded, you're referring to that little beach area, but the park itself is not a secluded park, right?
That would be correct, yes.
In fact, it's a heavily trafficked park with lots of activities, right?
Yes, that part of the park where the pump house is located isn't as traveled as the other sections, but yes.
Right. And I think I heard you say before that a person, if they wanted to, can walk along the beach north to south or south to north. Didn't you say that?
Yes, I did.
In other words, where you find the leg, if a person had wanted to, they could walk up and down that beach north if they wanted to.
Yes.
Okay. And in fact, there's other parks that even connect in with it. There's Grant Park to the south, isn't there?
Yes, there is.
And Pulaski Park to the west,
Yes, but it doesn't really connect much.
and even Sheridan Park to the north, which you testified to, right?
Yes.
Thank you, that's all.
State?
Nothing further.
Thank you, officer. You may step down. State your next witness.
Deputy Leon Martin.
Do you solemnly swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
If you could please be seated, state and spell your name for the record.
Name's Leon Martin, Leonmartin.
How are you employed?
Deputy Sheriff with the Milwaukee County Sheriff's Office.
How long have you worked for the Milwaukee County Sheriff's Office?
4 years.
You assigned to patrol, basically?
Yes, sir.
All right. Were you working back on April 2nd, 2024?
I was.
And what was your shift that day?
Second shift patrol.
What is second shift out in hours?
2 p.m. to 10 p.m.
Okay. Around 5:30 in the evening that day, were you dispatched to a call for service at Warnemont Park?
I was.
Is that at or near 5400 South Lake Drive in the city of Cudahy, Milwaukee County?
That's correct.
What was the nature of the call you were responding to?
There was a report of a possible human leg found on the beach at Warnemont Park.
And that was information conveyed to you by dispatch? So
Correct.
essentially you know what you're going
Correct.
towards? Okay. When you arrived on scene, were there other law enforcement already there?
There was.
Members of the Cudahy Police Department?
Yep.
Okay. What did you do when you got there?
I walked down. Initially, I parked at the top of the hill that leads down to the pump house. Was directed down the hill by other members of the Cudahy Police Department. Walked down the hill and was kind of flagged over to the area where police officers from Cudahy Police Department were already there.
This area that you walked down to would have been the pump house that is on the shores of Lake Michigan. Fair?
That's correct.
When you got down there, were you guided to where this body part was recovered?
I was.
And were you wearing a body cam at the time?
I was.
I'm gonna have you take a look to your right if you can. On the screen here, I have what's marked as exhibit number 10. Do you recognize that?
I'll stipulate that's his body cam.
I'll play a clip from this first. This is exhibit number 10. The video is titled SUSP-5 Martin. I'm going to play a short clip here. All right, I paused it at 8 seconds, started it at 0. Can you orient us right now? Where are we?
So we're at the bottom of the hill. Right now I'm facing north, looking down towards the beach.
All right, and on the left side, there's that steep cliff embankment. If you went up on the top of that, that's where the park would be, correct?
Correct.
You are at the end of the service road here?
Yes,
And did you have to climb down anything to get to the location where this video picked up?
I did. There was large tree branches and like other foliage and whatnot that was in the way.
Not somewhere a vehicle could get to, fair?
Correct.
But you indicated earlier that you had walked down the service road, and at the end of the service road, what's there?
There's like a barrier, like a traffic barrier, and then the lake is there. So it's like a roundabout, so you can turn around and drive back up the hill.
So vehicles can essentially get all the way down to essentially the shoreline, but could not get down to where you are right now in this video.
That's correct.
What do you have to do to get down to where you are in this video?
I had to climb over a couple of large trees and just other like rocks and whatnot.
And how far did you have to walk to get to the leg?
That was about estimated, probably about 100 to 150 yards.
Where I have this video paused, you're basically at the start of that walk. Is that fair to say?
That's correct.
Okay. I'm gonna play it until 4:10. And there's no audio right now. When does the audio pick up?
Approximately 30 seconds.
That because that's how your body cameras work?
Correct. When you activate your body cam, it plays 30 seconds before you actually activate it.
Thank you.
Yeah. I just cleaned my boots too, dude. Fuck, man.
Stand by. I have the on-call sheet. I'm trying to figure out what we can do.
Take that. All right. What's up, man?
So this is Evan Millies. We've dealt with him before. Sometimes mostly a good guy. He's gotten in this trouble a couple times, but good dude.
Okay.
So they walked down the S curve from Sheridan, started walking south just for fun, rough day on the beach. As they were walking, see that leg right there?
Yeah.
Said that it was up about approximately where the end of that stick, that branch is.
By the bushes right there.
Yeah, bushes. Said that they saw it up
So it's
there.
like up on the hill, kind of?
Yeah.
Okay.
So said that him and his buddy who's in my squad right now walked out, called us, and then when we came back, it was about, I don't know, maybe 7 feet east.
Find a rock.
I moved it just for evidence purposes.
Okay, so they just swept away?
Yeah.
Okay.
And I documented it well on body cam with different angles of where it was. And
okay, cool. All right, we got What's your name again, bud? Evan. Evan? Okay, Evan. How long were you out here?
About probably an hour.
An hour?
Yeah.
Okay. You usually come this way?
Yeah.
Yeah? It's the first time you seen anything here? Yeah. It's the first time you seen anything like this?
Yeah.
Yeah? Okay. All right, Evan. Just hang tight. Don't go anywhere, okay?
Yeah.
Thank you.
That is 100% correct. Copy, thank you.
All right, hang on, Evan. We'll talk to you some more, okay?
And they dipped out up the water pump ways and then called us.
At least they called.
Paused your body camera at 4:09. The objects right here, that's the length, correct?
Correct.
Now, as we were watching that video, you're able to see the waves there were pretty violent. Is that fair to say?
That's correct.
And it was a rainy day?
It was.
Did you observe any blood or any kind of thing like that near the leg?
I did not.
Or near the area where he had originally indicated the leg was found?
That's correct. There was no blood around the area or on the hill where it was initially found at.
What did you observe about the leg when you saw it?
The toenails were painted with pink nail polish. Based on the size of the leg, I could estimate that the person that the leg came from was rather short. The leg didn't appear to be decomposing in any type of way. So I was estimating that it had been placed there relatively, short time ago.
The other member of the sheriff's department that we saw in there.
Mm-hmm.
So the person you first talked to, that was Officer DeSmet, correct?
Correct.
The other member of the sheriff's department, who was that?
That's Deputy Michael Krieger.
Did you and Deputy Krieger canvass the scene or search the scene?
We did.
What did you find?
Nothing else of evidentiary value.
No other body parts, correct?
That's correct.
Was the medical examiner's office called to the scene?
They were.
Did they come?
They did.
Did they take possession of the leg?
They did.
Throughout that time, were there other members of your department who responded as well?
There were.
Did you search other areas, not just on the shoreline that we were watching on that video, but other areas of the park as well?
That's correct. At the top of the bluff that was on the left side of the video, that's a wooded area. Myself and multiple detectives and other MCSO personnel searched the wooded area and didn't find anything else.
I have no other questions.
Cross?
Good morning, officer.
Good morning.
So I just want to make sure I understand from where the parking lot is to the beach. So you said it's kind of like a wooded area?
Not necessarily. There's a steep slope, like a driveway to access the Warnermount Pump House. It's not necessarily a parking lot. It's just a service road that leads down to the pump house.
Okay, so to get from like the parking lot where the pump house is to the beach, is that flat or is it slanted or what's the terrain look like?
So it's like deteriorated from time and weather. So it's a steep hill that kind of goes down.
Okay, so it goes from parking lot, steep hill to the beach.
Correct.
And we could see on the video, it looks like the beach is quite small.
It is.
It's basically cliff, a little landing space, and then the water.
That's correct.
Is it always like that, or do you not know?
I'm not too familiar with that particular beach. That was my first time actually being on that portion of the beach.
Okay, and you said that you didn't observe any blood or anything.
That's correct.
Did you observe any drag marks as like a body was dragged?
I did not.
Did you you said you didn't locate any evidence of evidentiary value?
That's correct.
So you didn't find like a saw?
No.
You didn't find an axe?
No.
Or any sort of knife?
That's correct.
And it looks like you're walking through, it's a pretty muddy area. It looks like it's made of maybe like clay.
Yeah, or mud or like sand and whatnot. It's not like a normal beach, like Bradford Beach or whatnot.
Okay. I have nothing further.
State?
Nothing else.
Thank you, Deputy.
Thank you, Judge.
Does anyone need a bathroom break on the jury? If you do, raise your hand. Okay, we're going to take a 10-minute morning break and then we'll come back and continue the testimony. Please leave your notebooks on your chair or on the bench in front of you.
Yep.
Any objection as to how the instructions were read into the record from the state?
No objection.
Testimony given this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You can please be seated, state and spell your name for the record.
Joanne Donner, Joann Donner.
Good morning. How are you employed?
With the Milwaukee County Sheriff's Office as a detective,
How long have you been with the Milwaukee County Sheriff's Office?
just under 25 years,
And how long a detective?
8.
Through your work as a detective, have you investigated homicides before?
I have,
Okay. Were you working as a detective back in April of 2024, specifically around April 1st and 2nd of 2024?
I was,
Were you dispatched to the area of Warnemont Park in Milwaukee County
I was,
on April 2nd?
that is correct.
In the evening time?
Approximately 6 p.m.
All right. And the nature of the call was for what?
for a severed human leg.
Can you tell us why the Cudahy Police Department contacted your department?
The Milwaukee County Parks are the jurisdiction of the Milwaukee County Sheriff's Office.
I have up on the TV screen, if you can see that from where you're seated, exhibit number 1. Do you recognize what exhibit number 1 is showing?
I do. It's an overview of the Sheridan and Warnemont Park lakefront area.
I would move exhibit number 1 into evidence.
Any objection?
No.
It's received.
And I'm going to show you now exhibit number 443, which is on the screen hopefully soon. All right, there we go. Can you see that?
I can.
And we're looking at another map, correct?
That is correct.
It's a map of Milwaukee County.
Correct.
I'd move 443 in. It's the PNG file on the disk. It's a disk.
Any objection?
No.
It's received.
All right, and as we're looking at 443 here on the northern end of it, it kind of cuts out all the way at the top here. We see Silver Spring Drive, correct?
Correct.
That's not the northernmost tip of the county though, right?
No, it is not.
Okay, and I'm gonna zoom. There we go. All right. Back, if we go all the way to the south side of the map, we've got County Line Road. It's essentially where Racine County starts, fair?
That is correct.
And then if I'm zooming back up, on the right side, we have Lake Michigan, correct?
Correct.
And zooming in all the way over here, this is the location of Warnemont Park, right?
That's correct.
Okay, so we're sort of in the southeastern corner of the county as we're talking about what we're about to talk about. Fair?
That's fair.
All right. Going back to exhibit number 1. I think this TV just takes a little longer. Sort of on the left side of the map here, what is this road?
South Lake Drive?
Okay, and we've got South Sheridan Drive that kind of runs through the park here, correct?
That's correct.
And the street, the southernmost street on this map is East Pulaski Avenue, correct?
That is correct.
East Pulaski Avenue comes and hits Sheridan Drive, and then this location, this road right here, what are we looking at? What is that?
That is the service drive to the pump house.
Okay. For the Cudahy Water Department.
That's correct.
The Cudahy Water Department is located where on here?
On the corner of Pulaski and South Lake Drive.
Right here?
That's correct.
All right. So this is the location of the Cudahy Water Department, but they also have this building that we've been talking about, the pump house, which is where my finger's pointing right now. Is that right?
That's right.
The lower right-hand corner of the map. Right above the Cudahy Water Department, we've got, it says Cudahy City Hall.
Correct. It also houses the police department.
So the police department and local government is in that building.
Correct.
The building north of that?
The high school.
All right. Where is, strike that, is there a gate when you get to the end of Pulaski Drive, heading east? Where is there a gate that takes you down to the pump house?
There is. It's right about where the M and the O are in Warnemont.
All right, where I'm pointing here?
Yes.
This road that would go down to the pump house, that's the only way you could get a vehicle down there. Is that fair to say?
That is correct.
Okay. And this stretch of shoreline right here. Is this the stretch of shoreline that you were dispatched to that day, April 2nd, 2024?
Correct.
Was the human leg that was found there, where was it located? If you could approximate on this map.
Would you like me to show you?
If you could.
Approximately right here.
Okay, so let the record reflect the witness is pointing towards the shoreline, right about halfway up the page.
Any objection to that?
No.
Thank you.
Where would the entrance from Sheridan Park be?
It would not be shown here on this map. It's further north.
Okay. I'm changing it to Exhibit 443. So above, we see Warnemont Park here, and above that, that would be Sheridan Park, correct?
That's correct.
All right, and so it'd be up this road from Sheridan Drive, fair?
That's fair.
Okay. When you first got down to the shores of Lake Michigan at Warnemont Park on April 2nd, did you encounter Deputy Krieger?
I did.
All right, that's Krueger for the record. Were you kind of briefed on what had happened prior to your arrival?
I was.
What was the, albeit limited, information that you were given at that time?
I was to inform that there were 2 citizens that found the severed leg on the beach area and called Cudahy Police Department. From there, Cudahy called us due to its jurisdiction. Our 2 deputies then confirmed that there was a leg, secured the scene, and called for CID, Criminal Investigation Division, to respond.
And you were the detective from CID who responded?
That's correct.
Were there other detectives who eventually responded?
There were.
But essentially, the scene investigation, you were going to take over that, correct?
That's correct.
Okay. All right. After being briefed by Deputy Krieger, what did you do?
I initially just kind of did a once over of the overall area to get an idea of what it was that I was dealing with. The conditions were very poor. That lower area next to the pump house was under construction. They were going to be paving a certain area and laying grass, but at that time it was gravel and a lot of mud and muck. I changed into boots and was guided by Deputy Krieger down the beach. To get to that area, there is a very narrow tree line, and then it's a precarious, steep decline. It's short, but it's very steep, that you have to actually hang on to trees and roots or you'll lose your footing. From there, it was about 100 to 150 yards to the location of the lake. That terrain was rocky. The rocks varied in size from pebbles all the way up to probably the size of cantaloupes. It was not an easy navigation to get to.
When you walked that 100 and 150 yards, what did you see?
There I saw what appeared to be the right leg of a Black female. Based on the condition, it appeared that it wasn't there for very long. I did not see any visible decomposition. The skin was very smooth, free of blemishes. I didn't see any noticeable scarring or any tattoos on it. The nail polish was a bright pink color, and it appeared that it might be from a younger woman.
What about its appearance did you take note of, if you want to elaborate on why you say that it appeared to be from a younger woman?
Just the condition of the skin. It had a very youthful appearance to it. It was not crepey. There was, like I said, there was no decomposition, so it was in very good condition.
What were you able to discern, if anything, about the size of this human?
At one point, we had to move the leg again due to the waves crashing up a little too close to it. Deputy Krieger picked it up upright with the foot to the ground and the thigh upwards. And I noticed that the leg appeared to be a little bit shorter than I was, and I'm 5'3". It also, size-wise, looked similar to my weight. At that time was 170 pounds.
Did you notice an obvious line where it had been dismembered from the body?
I did.
What did you observe about that?
When the leg was being moved, the fold of skin and flesh had moved away from the bone. You could see that it was severed below that top ball of the femur. It looked like it was a tool mark. It was very smooth all the way up to the end, and then it looks like it was snapped. It reminded me of a tree branch that you're sawing and you get so far and you're like, "No, just gonna break it." It broke off and it was like a piece, jagged piece at the end. I noticed that the skin had kind of a long zigzag pattern to it, which is usually indicative of cutting rather than pulling to be ripped apart. That's why I was able to determine that it probably was not from like an accident, a boating accident, or anything like that.
Did you bring a camera?
I did.
Did you take photos of the scene as well as of the leg?
I did.
I'm going to show you exhibits 2 through 9. And I'm going to bring them up on the TV screen. But first, why don't you page through 2 through 9 and tell me if you recognize those.
I do. These are the photos that I took.
Not all of them, correct?
No, I took more than this.
Okay. I moved 2 through 9 into evidence.
Any objection?
No.
They're received.
All right, Detective, I'm gonna bring up exhibits 2 through 9 on my screen here. If I bring one up that is not one that's in front of you, tell me. Okay, thank you. All right, let's start with, this is gonna be exhibit number. Is this exhibit number 2?
It is.
Okay. What are we looking at?
This is a view of the beach shoreline area looking north.
Okay. The waves over here, they were pretty substantial that day.
They were in growing.
And through your experience with working with the sheriff's office, do you have any familiarity with the shores of Warnemont Park?
I do.
Do the tides change?
They do, dependent on the weather.
All right. And this weather on this day was what?
It was rainy. There was mixed sleet that day. The winds were really high. It was not a pleasant day.
And then off to the left side here is the leg.
That's correct.
This exhibit marker here, someone from your department put that there, is that correct?
That's correct.
Okay. I'm going to move to exhibit 3. What are we looking at here?
This is taken from the same position as exhibit number 2. I just rotated and now we're looking southbound.
For purposes of sort of giving a visual as to how far you had to walk?
That's correct.
All right. And so I'm going to zoom here. There's 2 people. These would be investigators or people that were there on scene when you were doing your investigation, correct?
That's correct.
What are we looking at over here that I'm circling with my mouse where this wave is crashing into?
So that's where the bottom of the hill where the pump house is. There's that kind of paved area. Well, at that time it was not paved. And they have a break wall, and then there's the large boulders that go down into the lake. Just to the right of that is that rather steep embankment that I had to crawl down to get to the shoreline.
All right. So would that be where my mouse is right now?
Yes, it's a little hidden from view. Yes.
This sort of right angle here that I'm highlighting with my mouse, is that the pump house?
It is,
And that's kind of over the bluff there, over the cliff.
correct.
Okay. So when you, and the service road would be also right by that pump house, correct?
Yes.
Going to go to exhibit 4. What is this?
This would be in, again, the same location. I'm just now looking west and up the bluff, just to demonstrate how steep that is as well.
And at the bottom, it's angled, but at the top here, it kind of actually gets vertical. Is that fair to say?
Correct.
One would have an extremely difficult, if not impossible, time trying to get down here from the top of that cliff, right?
Definitely.
Okay. Next exhibit. What are we looking at?
It is another picture of the leg.
Next exhibit. What number is this?
Number 6,
What are we looking at?
that is the top thigh portion of the leg.
And this is what you were describing before. What did you note about how it was cut?
You can see, if you mind, if I can get down to point.
You may.
Thank you.
It's this large zigzag motion that led me to believe that it was an instrument
That did the severing and not being ripped.
You said an instrument?
Correct.
And then you had also mentioned that part of what you were able to observe of the leg made you believe that an instrument stopped being used. Is that correct?
Yes.
Well,
On the
describe
bone
that again.
portion, yes.
Okay.
It's not visible in this photo. The flesh is covering that portion up again, but it does look smooth, like when you would cut a bone with a knife or saw.
Next exhibit. What number is this?
Number 7, and that shows her pink toenail polish.
All right, zoom in on that. This is exhibit number 8. What is this?
This is again, the top of the thigh portion where you can again see the rather Z-like jagged serration marks.
And lastly, exhibit 9.
Again, just showing the location of the leg. At this point, it had been moved a few times. Still laying in the same position, like still facing the same direction, just had to move it closer to the embankment there.
Do you recall about how far up the leg was described originally to have been when Evan and Osiris found it?
Probably be about 10 to 15 feet. It'd be right about where that bush is in the photo, that dark spot.
Where I'm circling?
Correct.
Okay. Did you assist with other investigators in searching the other parts of that coastline?
Correct.
And I'm specifically talking about down by the water, not up on the cliff.
Just in my travels back and forth between my squad and to the leg, I would search as I would go by to look for anything else. I did not find anything else.
Were other members of your department out there searching as well?
Yes.
And where nothing else was found?
No.
About how far up and down the coastline were people searching?
I do not know how far they went to the north, but I do know that they did also go to the north of the leg location, but we did search rather extensively from the leg to the south.
Okay. Did you make a request of the Coast Guard?
I did. I asked to see if they could come with their searchlights to scan the bluff area we were starting to lose light at that point. They denied our request due to the weather.
Was the area of the bluff searched nevertheless?
It was.
And how about up above the bluff in the wood line? Were investigators also heavily searching that area?
We did. It was due to have a snowstorm that night, and I was worried about losing any potential evidence to a snow cover. That's when Detective Colehop and Detective Bacon also responded to the scene, and along with the deputies on the scene and Officer DeSmet, we all started to comb that upper area. It's a lot of very narrow paths, I guess. They're just worn down between the tree line and that parkway area that you see. We went through there extensively trying to find anything else and did not find any other evidence.
Okay, I want to actually bring back up, I want to say this is going to be exhibit number 3 on the screen. Do you see that?
I do.
Okay. Now, obviously, you came down here and were able to walk to where you were standing. You walked in a northern direction to get to where you're standing when you took this picture. Is there a way to walk? Is there a path essentially that would get you down over to the other side of the pump house, or is it kind of rocky and treacherous along there?
It is. It's similar to that on top of the bluff area. The path south of the pump house is very narrow and it's just dirt. I did not go any farther south just because I didn't feel it was safe.
No other body parts were located in the area of Warnemont Park, is that correct?
That's correct.
The medical examiner's office came and took possession of the leg?
They did.
Was it assigned case number 24-02296?
It was.
And their role was to conduct an autopsy of the leg at that time, right?
That's correct.
In addition to looking for other body parts, did you look for any other items that you thought might have some value?
I did.
And did you take note of anything?
I did not.
Okay. Any clothing found?
There was a t-shirt and a bra, and that would have been very close to that initial tree line where you'd have to walk down. The bra was under driftwood and kind of covered with sand. The same with the t-shirt. It was up and off a little ways. They appeared to have been there for a while.
They were soaked?
They were.
Okay. And you say appeared to have been there for a while and they were covered by like driftwood, you said?
Debris, sand, and pieces of charred wood.
Did it appear they were naturally covered by that stuff or like someone tried to bury them?
Naturally.
Okay, so your takeaway essentially was that you believe those had been there for a while.
Correct.
Is this a location where you've seen other stuff like that since you've been back there after this date?
Nothing really clothing wise. It appears that there might be a place that kids like to go to have fires right next to the parking lot area. That's where the charred wood is. Sometimes you'll find beer cans and things like that, but that's the only things that I've really found since I've been there.
And you're specifically talking about this area sort of right by where that pump house service road ends, is that correct?
That's correct.
And that's the location where this bra and shirt was found?
Correct.
The following day, April 3rd, 2024, were you contacted by the Milwaukee Police Department?
I was.
What was the nature of that contact?
I was asked to call an officer, Nora Burlow, that she had taken a welfare check the prior night for a Sade Robinson who had been reported missing by a coworker.
Was there another report to Milwaukee Police regarding Miss Robinson?
There was. Officer Burlow told me that she noticed this welfare check because it was an area that they don't often get called to, being Sade Robinson's apartment on North Commerce. When she opened the call up, she noticed that there was an associated call for a burnt out car earlier that morning, and that really piqued her interest, and that's when she went to the apartment.
In response to learning that information from the Milwaukee Police Department, did you look into Sade Robinson's demographics?
I did.
And did Sade's description, through what you were able to find, seem to match the description of the leg that you had recovered at Warnemont Park?
It did, according to the DOT demographics. She appeared to be the same height and weight and skin coloring of the leg.
Just a few other questions about this topic, Detective Donner. In the days, weeks, time period after April 2nd, when you first went to Warnemont Park, were there other searches of the park involving canine units?
There were.
Do you know how many?
I don't know the specific number for Warnemont Park, but I believe we had a total of 8 canine searches in various different areas. We had ground penetrating radar, as well as a specialized unit that does water searches as well.
Who is that?
That's Bruce's Legacy.
It's
a
the organization?
volunteer group.
Okay. And they came out to the location that we see here in Exhibit 1 and searched the coastline near where the leg was found?
They did on a couple of occasions, yes.
Do you know exactly how many, or do you just know it was more than one?
I believe it was 2.
Nothing found?
No, nothing was found.
Was a drone unit ever flown around this area to try to find more body parts?
It was for a better view of the bluffs, yes.
What did that yield?
Nothing.
And were dive teams used to go into Lake Michigan near this location to attempt to locate more body parts?
They were.
And was anything ever found there?
No, there wasn't.
The area depicted in Exhibit 1, that shoreline, how many times have you been there?
Probably a couple dozen since April 1st of last year.
Do you ever see anybody else down in that area of the shoreline where the leg was found?
Objection relevance.
I'll allow it. You can answer it.
Not on the shoreline portion. On the upper portion, I would see people walking their dogs, but not actually down by the lake.
I have no other questions at this time. This is a witness I would recall at a later time for a different topic.
Understood. Cross-examination?
Thank you, Detective. Good morning.
Good morning.
You said that in the times you've been there, you've noticed a spot where kids hang out, and you said something about noticing beer cans. Did I hear that correctly?
That's correct.
And that's near the parking area by the pump house is where you're describing that?
Correct.
You say kids hang out. Did you ever have contact with kids that were hanging out there, or you're just using that as a generalization based on what you see?
I spent 15 years on our parks unit in various forms, from mounted patrol to working in a squad. And when we would get called down to that area for smoke, that's where they would always be. And they generally were underage.
Okay, so you're talking people under 21 is what you mean?
Correct.
By underage. And this time when you went there, so it was April 1st?
Or April 2nd, I'm sorry.
April 2nd was the first, when you went there for the leg, right?
Correct.
Was that the first time you had been to Warnemont Park, or in your 15 years prior, had you been there on other occasions?
I've been there on other occasions.
Okay, so when you're saying a couple dozen times before to the jury, are you talking since April 2nd, couple dozen times in the last year, right?
Yes.
But then many times before that?
Yes, enough to be familiar with it, yes.
Got it. You said the conditions that day, obviously we can see the photos, windy, stormy, waves, all accurate description, right?
Correct.
Eventually, at some point, 2 gloves were found, were they not?
Yes, I did not do that, but yes,
Okay, you weren't involved in that.
I was not.
You weren't called to the scene to recover those?
I was not.
So you played no role in any glove recovery?
No,
You just know about it as the lead detective.
correct.
Now, the day, April 2nd, when you were there, you said you called in a canine search. Did you do that?
No, not on that day. It was, I do believe, the next day.
April
that we-
3rd.
Yes,
In the canine search, just so the jury understands, is a cadaver dog, you could call it, right?
that's correct.
In other words, you can give the dog a scent and it knows to look for human scent, right?
That's correct.
Blood and things like that trigger this dog,
Correct.
as opposed to looking for animals.
That's correct.
And the canine dog was used the next day and found nothing.
No, not that, to my knowledge, they did not find anything.
Were you involved in the canine handling?
I was not.
The ground penetrating radar that was used, did you use the ground penetrating radar?
No, I was not present for any of the searches. Generally, the way it works, I then become the orchestrator of the investigation, and I rarely go back out.
Got it. So so questions about what Bruce's legacy did or ground penetrating radar, you're not there for that.
I was there for one of Bruce's legacies.
Those are the underwater divers that look for things.
Not actual divers. They have sonar equipment that they put underwater that have cameras.
Now, let's focus on April 2nd when you were there that day. We saw when the state was showing you pictures of the beach line area. Could you pull up the pictures again, Ian? Okay, so this is Exhibit 3, Detective Don. Does that look familiar?
Yes,
Do you have the actual printed photos?
I do.
Did I just have those?
Mm-hmm. You're welcome.
So Exhibit 3, on Exhibit 3, we can see all the way down the beach line towards the pump house. Is that fair to say?
That's correct.
And if I heard you correctly, if I heard you correctly before, I thought because of the conditions, you were deprived of bringing in Coast Guard personnel, right?
That's correct.
So you can make a request, but it's not honored because it's too dangerous.
Correct.
So the search that was conducted on April 2nd is essentially of that shoreline down to that pump house. Is that fair to say?
Correct. And on the top of the bluff.
And the top of the bluff. South of the pump house, not that day.
Not that day, no.
And that's primarily due to the conditions, I assume.
Correct.
As the lead detective, you are aware of the fact that these bloody gloves were found south of the pump house on a later date.
Correct.
Those are all my questions for this topic. Thank you.
State.
Nothing further.
Thank you, Detective. State your next witness.
Frank Miller.
Sir, if you could please remain standing and raise your right hand. Do you solemnly swear that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? So
Yes, I
help
do.
you God? Thank you. If you could please be seated, state and spell your name for the record.
Francis Miller, Francis Miller.
How are you employed, sir?
I'm currently semi-retired and working for a consulting firm, managing the Cudahy Water Utility part-time. Prior to that, up until December 31st of 2024, I was the water superintendent for the city of Cudahy. In the last 4 years, I was the director of public works and water for the city of Cudahy.
All right. So you worked for the Cudahy Water Department for your career.
Yes, sir.
And even after retiring, you're working with them again?
Yes, I am on a part-time basis.
All right. I got what's marked and entered as Exhibit 1 up on the TV screen next to you. I trust you're able to see that from where you are?
Yes, I can.
And I take it based on your answers to those questions about where you work, you recognize this area?
Yes, it's an overhead view of the Cudahy High School and Pulaski Avenue that heads down to the city's water pumping station on the shore of Lake Michigan.
The building I'm pointing to here, that would be,
That's the city's water treatment facility at 5110 South Lake Drive.
all right, and then the building down here, that's the pump house.
That is the city's pump house. It pumps fresh water from Lake Michigan to the treatment plant.
All right. To get from this building, the water treatment facility,
Yes,
all the way to the pump house,
yes.
you'd go down Pulaski Avenue, what would you encounter?
At the top of the hill, just after the intersection of Pulaski Avenue and Sheridan Drive, there's a large gate, a 2-section gate that's locked to prevent vehicles from going down to that pump house.
Who has the keys to that lock?
Cudahy Water Department personnel, Cudahy Fire Department, and the Cudahy Police Department.
I want to take you back, sir, to around April 1st and 2nd of 2024. Around those days, specifically on April 2nd, did you come into contact with the Cudahy Police Department regarding your gate?
Yes, I was contacted. On April 1st, we had a contractor doing some paving along the lakefront at our pump house. The morning of April 2nd, an inspector who was going down to look at the job called me to tell me that overnight someone had rammed the gate going down to the pump house. He sent me a couple pictures. When I looked at the pictures, I called Cudahy Dispatch, asked if it were possible to have an officer meet me at Pulaski Avenue to fill out a police report, standard for us to be able to file an insurance claim.
Was that an unusual occurrence for the gate to be smashed?
Yes.
Okay. Do you recall about the time that you reported that to the Cudahy Police?
Somewhere around 9:30, 10 o'clock in the morning.
On April 2nd?
On April 2nd, Tuesday.
And to the best of your knowledge, April 1st, going into the night of April 1st into April 2nd, no issues with the gate?
There were no issues with the gate when the contractors left approximately 4 p.m. on Monday, April 1st.
That gate and that road, would that essentially be the only way to get a car down to the pump house?
Yes, it is.
It's kind of a steep downhill decline, correct?
It's very steep and there's no other access.
Sir, can you take your microphone and bend it like this? That might, if you just bend it down like that, it'll stop the whistling.
Oh, I'm sorry. Is that better?
We'll find out.
Okay.
Thank you.
Yep. When you went out to the gate, what did you observe?
The gate had been hit really, really hard. It's a large industrial fence gate. The post that it was in had been moved and there were plastic car parts like you would see from the front of a car that had a collision laying around on the pavement.
I'm going to show you some photographs, sir. I'm going to start with exhibits 13 through 26. Just page through this and tell me if you recognize any or all of those photos.
I recognize many of the photos. Many of them are similar to photos I took. I may have taken a few of these. There's like 1 or 2 photos here that I'm not sure if I've seen before.
Sure. Why don't you pull out the ones you know you've seen before?
These are the ones I've seen before, sir.
All right, so, you recognize these as being from the area of the pump house gate? I don't know what's causing that.
I don't.
Do you recognize these all from being from the area of the pump house gate from that time?
Yes, I do.
All right, so I'm gonna move in at 13, 14, 19, 20, 21, 22, 23, 24, 25, and 26, Your Honor.
Any objection?
No.
Those are received.
Take these. And I'm gonna ask to publish.
Go right ahead.
Thank you. Exhibit 13 here on the screen. What is this? Or what did it appear to be when you were there and saw it?
Looked like it came from the front end of a car, the plastic front end pieces around your headlights and stuff. It looked like it was a piece of that.
And you saw those pieces yourself?
Yes.
On scene?
When I stopped to look while I was waiting for the Cut APD to show up, I saw them myself.
Maybe try putting it back up. Maybe I was wrong.
We'll figure it out.
Maybe it's my voice.
Now, obviously, this isn't the only photo of the parts we're gonna see, but before we go further, was there something about these parts that led you to believe what kind of vehicle it was?
Several of them, when you looked on the inside, were marked Honda. And if you did a quick internet search on your phone with some of the part numbers, it popped up with models that it possibly could have been, and the Civic popped up quite a bit.
The Civic.
Honda Civic.
Exhibit 14. This is one of those pieces you discussed with the Honda.
Correct.
All right, that's written at the bottom.
It's written on the bottom in the black plastic.
And so you did your own searches of those.
It was natural curiosity while I was waiting for the police officer to show up.
Exhibit 19. What are we looking at?
That's looking down Pulaski Avenue, heading east towards the lake. And at the top of the photo are the gates that were struck.
Okay, so behind you would be, behind the photographer here would be Sheridan.
Would be Sheridan Drive, and then if you keep going west, Lake Drive.
And this is the broken gate.
Those are the broken gates.
Is this how you first saw it when you went out there?
No, it's not. That's how our utility staff pulled those apart to try and get some idea how we could secure the road for the evening that night.
How did they appear when you first saw them?
When I first saw them, the gates were together. They're normally latched with a large chain that keeps both sections together. Those gates were caved in. The poles, the posts on each side, right and left, that hold those gates were both shifted and loose in the ground, so the gates were kind of collapsing.
All right, were you able to discern whether a car would have been able to get through there
A car was not able to get through the way I saw the gates when I got there,
when you saw them?
when I saw them.
Okay. Let's look at the left side of the frame here. You see what I'm circling with my finger?
Looks like the plastic car parts.
Are these the parts that you saw?
Yes.
Okay. Different view of similar vantage point. Exhibit 20. There's a forge on the left, correct?
Correct. We have a construction project going on for several months.
All right. 21.
The
Different angle.
same area.
Do you know if that's where is this where you originally observed the car parts, or did somebody sort of gather them up and move them there?
Those look like they've been moved over from where I originally saw
Where did you originally see
them.
them?
They were more scattered on the road when the first time I showed up when I saw them.
Near the gate or somewhere else?
Near the gate and kind of to the left from our view, but near the gate.
Exhibit 22. Another Honda part, correct?
Correct.
Exhibit 23. Another Honda part with what appears to be like a product number.
Yes, and that's one of them that I did a quick search on. It popped up with Honda Civic.
Okay, so one of these numbers here in the middle, you were able to search that number on the internet and find out that it likely came from a Honda Civic.
Correct.
Exhibit 24. Another piece of Honda parts.
Yes.
25. Zoom out a little bit here.
That picture looks like what the area looked like when I pulled up with car parts scattered around and the fence askew.
Okay, so this is more of what you first saw when you got down there that morning.
Correct,
And in the foreground there are some of those parts there.
correct.
Exhibit 26. Just another view of the gate.
Another view of the gate. That may have been taken from my car. I'm not sure. It almost looks like my dashboard.
What's the number on that one?
This is exhibit 26.
Thank you.
Other than what we saw in the photographs there, were there other noticeable car parts? And by noticeable, what I'm asking you, sir, is you were able to identify what part of the car they belonged to?
Nothing that I can recall. Everything I saw seemed like it came from the front end of the car and were the black plastic parts that we've discussed already.
Okay. So you specifically believe these have come from the front end?
That's my belief.
What made you believe that? Just from what you searched?
It just seemed like it made sense that they look like they're parts from the front end of a car that you typically find if you've ever hit a deer or something. It looked like the same thing. It looked like someone just hit the gate with the front end of their car. It's a dark area.
All right, I'm going to show you exhibits 216 through 223. See if you just recognize what is in those photos, and if so, set them aside.
Yes, I recognize them.
They all appear photos taken at or around that date?
Correct. They look like they're taken at that site at that time.
Okay, I'd move 216 through 223 into evidence.
Any objection?
No.
They're received.
We'll go through these. Smash gate, correct?
Yes.
217.
It's another picture of the same gate before any of my people touched it.
218.
That's the picture of the post that holds the gate up.
That's the post you were talking about before?
Correct.
Okay. 219 shows sort of the whole post, correct?
Yes.
And then 220, a Honda part,
Yes, correct.
221,
Another Honda part.
222,
Another car part that's, I couldn't identify that as Honda or not. It doesn't have the markings on it, but it's another car part that was there.
look like it would be from like the front of a car.
That's what I would think, but I'm not an auto body guy.
That's fair. What makes you think that though?
It just seems, it looks like it'd be a headlight or a marker light from the front of the car.
All right. And last one, 223, another car, correct?
Correct.
Does the Cudahy Water Department have operational surveillance cameras?
Yes, we do.
And were you familiar with how they operated?
Yes.
Okay. Did there come a time where someone from the sheriff's office came to you to try to retrieve video from your cameras?
Yes, Wednesday morning, we were contacted by the sheriff's department and Cudahy PD, and they explained they were going to send a sheriff's detective over to review the footage we had from our cameras.
Did that happen?
Yes, it did.
And did either you provide them with video or they recover video from you?
They gave me a specific date and time frame that they wanted video for, and we copied the video to a hard drive and delivered it to the Cudahy Police Department.
All right. the cameras you had, there were cameras both from the
filtration plant?
filtration plant here as well as the pump house.
Correct.
And you provided those videos to law enforcement.
Yes, sir.
Do you recall whether or not those cameras were accurate to date and time, or were they about 30 minutes off?
They were off. There'd been a power outage, and we didn't notice it until the officers were reviewing the film that we didn't update the time on the DVR.
Okay, so it would have, the power outage would have set the time back, so it was about 30 minutes off?
Correct.
And that was something you discovered, that it was 30 minutes fast when you were reviewing it with the law enforcement?
As the officers were reviewing the video, we noticed the dates, the timestamps didn't make sense. We looked at the current timestamp compared to the current time at that moment and realized how far they were off.
I have nothing else.
Cross?
There's nothing hidden about this driveway, you would agree, right?
No, it's the public who lives in the area is aware it's there.
I'm sorry?
People who live in the area are aware it is there.
Comes right off of Sheridan Drive, right?
Correct.
And Pulaski runs right into it.
Correct.
And that's the reason there's gates there, because you don't want the general public just going on down there, right?
Correct.
What year did those gates go up?
Those exact gates went up sometime in the mid-2000s, but there has been some type of gate there for as long as I've worked for the utility, since 1990.
Okay, and if a person wanted to by foot, for example, they could sort of finagle their way around the side of that gate. You would agree with that, right?
Yes.
That's all.
State?
Nothing else, Judge.
Thank you. You may step down, Mr. Miller. State, do you have a quick witness?
No, I do have another witness. It's not going to be quick, though.
You want to start, maybe? 10 minutes?
I think it would be a good time to pause.
Yeah?
Yes.
Okay, then we'll begin our lunch break. We're going to kick back up this afternoon at 1:45. Remember, those admonitions become even more important.
Mr. Alessi's question.
Thank you, Your Honor.
Could you give me the question again, please?
Yes. When did you create the updated presentation that you reviewed in your direct testimony?
So that addition I made was taken out. It wasn't in my direct
Sir,
testimony.
If you can just hear my question, it's this. The version of the presentation that you put on the screen, when did you create that version? I'm just looking for a date.
So to answer your question about the version on the screen, I created that yesterday when the judge asked me to take off some of the headers. So yesterday.
Okay, good. Now, the version before that you created yesterday, when did you create that version?
The day before.
And then the version before that one, when did you create that?
I mean, I save it every day.
Understood.
So every day.
So you've changed the presentation every day since when?
No, I don't think I've changed the presentation every day.
That's my question. My question is, how many times have you changed it within the last 2 weeks, your presentation?
Let me try and cut to the chase here.
Sure.
That slide was added on May 13th, and then it was taken out before I presented it here. So it was not in my presentation here.
Right. So thank you for that answer. So
You're
here's
welcome.
the question. Your first version, as I understand it, of the slide presentation was January 30th, 2025. Is that correct?
Correct.
When was the next time after January 30th, 2025 that you changed that presentation?
May 13th.
Assuming the trial started April 22nd of 2025, you changed your PowerPoint presentation during this trial, correct?
Correct.
And how many times did you change your presentation after April 22nd of 2025?
Well, the last time they changed it was like 10 minutes ago. So in response to various discussions, I've been making continuous changes to it.
I want to make sure you finish your answer, so I didn't
No,
interrupt you.
I'm not sure how much granularity you want to that answer.
Right, so you created on January 30th, 2025, you made your,
13th.
pardon me?
Oh, the original one, sorry,
Yeah.
January 30th, modified May 13th.
Right, if I could finish my question, and I might be able to shortcut this, thank you. So you created the original one on January 30th, 2025, you made your first amendment May 13th of 2025. And then before you sat for your testimony, which was yesterday, correct? That was the first time you sat for your testimony.
That is correct. I was here yesterday.
Days get foggy when we're in a courtroom, but it was yesterday. How many times had you changed your presentation from January 30th, 2025 until when you first walked in the courthouse yesterday?
Do you mind if I count?
Not at all.
So there was the May 13th change. Half of that was in response to objections from the defense. I had to add all the paths to where everything was. Then when I got out here, Mr. Brandon asked me to take out references to evidence about statements that I was not allowed to present. So that would have been within the last 3 days. And then I've modified it a couple times today based on rulings from the judge.
Okay, let's break that down. You said half of the changes you made on May 13th related to what? Because I want to know about the other half. that
Sure,
you
there was
didn't
two
state.
changes. I added the extra path of 138. And then I was told that the defense was having problems with my PowerPoint. So I had to go in and add the paths to every single slide about where the evidence came from, because they were saying I didn't provide everything, and I had provided everything.
All right, so
That was the second half.
got it. I want to go to the first half, sir.
Sure.
And I'm going to try to shortcut this. And
Please.
if I'm not clear, you just let me know. I want to talk about the first half. You called it, I didn't hear it. It was like, did you say path?
Path.
P-A-T-H?
Correct. The path Miss Reed was driving.
Right. What you made the change for May 13th, that first half, that wasn't something that was triggered by the defense. That was something irrespective of the defense, correct?
It was based upon her statements. Is she part of the defense?
All right, so that's what I wanted to get to. You changed the first half based upon statements you allege that Ms. Reed made. Is that correct?
Speak. I changed one slide. There was 130 slides originally, or something like that. So half of the changes on that day, which was one slide, I added one line to the bottom of the previous slide.
Did you consider that change significant?
No.
Well, then why did you make it in the middle of trial if it wasn't significant? Why didn't you just leave it off and then discuss it in terms of testimony?
So A, it ultimately was left off. B, because it was insignificant and I didn't need to have it. So the way it got presented was exactly the way it was before May 13th. So it didn't change anything.
But it was significant enough for you to make a change to your presentation, correct?
So my goal is to be as accurate as possible. So when I saw the path that I gave, the way she could drive, I gave the possible paths. That was one of the possible paths that hadn't originally been included. So in striving to be as accurate as possible, including as much information as I could, I wanted to make sure I included that.
So you were striving. The clip that you used to make the change, you say you made the change based upon a clip you observed with regard to Ms. Reed. Is that correct?
I believe that, yes, that is correct.
Do you know that clip has been in existence for months?
I don't believe I got it until April.
So a clip that has been, assume the clip's been in existence for months. You just got the clip.
Dr. Welch, I have to ask you
Oh, I'm
not to
sorry.
refer to
I'm
that,
trying
so
to
just
be helpful.
Close your
Yeah,
computer.
let me
and-
close it. Sorry. I was trying to answer his question.
So I'm going to ask you to close the top.
Yeah, that's probably a good idea.
Just flat down. Thank you.
Thank you, Your Honor. So assume the clip that you said was the basis for changing your PowerPoint on May 13th after the trial started had been in existence for months. You just got that clip, you say, in April?
I believe so, yes.
What was tell me the circumstances by which you got the clip. Did you ask for it?
I was told there was a new interview.
Okay. Who initiated the conversation about the new interview?
I don't know if it was Mr. Brannon.
It was someone associated with the prosecution?
Yes, I wouldn't have known about it.
Exactly. So somebody affirmatively communicated with you when about this clip?
I need to look, but I remember it being about mid-April,
Mid-April.
if I'm thinking of the correct clip.
What were you asked to do, if anything, with regard to that clip?
When I got the clip, I wasn't asked to do anything.
What did you do with the clip once you got it?
So they then indicated there was this suggestion of an alternative route. So then I looked at the alternative route description and added the alternative route.
So it was suggested to you by the prosecution that you look at the clip and they pointed out that there was an alternative route they wanted you to look at?
So I took it to be, we have additional evidence. Please look at the additional evidence and add it to your analysis.
On the topic of additional analysis by Aperture, while this trial is going on, are you aware of Mr. Burgess submitting a report dated May 8th of 2025 in this case?
Yes, I received that report on May 8th.
Right. And so you were aware of the creation of that report on May 8th because you got a copy of it, right?
Correct.
Were you aware that Mr. Burgess was intending to submit that May 8th report to the Commonwealth?
Yes, we'd had a discussion before that he had found new information that changed the timing.
Oh, he had found new information. What is your basis for saying he found new information as opposed to the information always existed? It's just it was pointed out to him that that should be looked at. What's the basis of your understanding that he found new information?
Objections to the question. I'm going to allow the question, but you have to ask it differently.
I will, Your Honor. Thank you. What is the basis for the statement you made that Mr. Burgess found new information?
I guess it was his meeting and our discussions. He indicated that he had found new information.
Did you ask him, what do you mean by new?
No, I took it at what it said.
So do you, as you sit here today, have any basis to say that that information is new as opposed to it's always been in existence?
Yes.
What is that?
What he told me.
Oh, so you relied upon the representation of Mr. Burgess. You didn't have any independent document to determine whether in fact it was new.
I don't quite frankly care whether it's new or not. I just care what's in the data, whether it's new, old, I don't care. It's not relevant to what I'm doing. I don't say this is new data, this is old data. I just care what the data is.
Sir, has Aperture ever submitted a report, a changed report in the middle of a trial to your knowledge?
I have no idea.
Do you know whether Aperture has ever submitted an amended report in the middle of a trial? You said you testified in federal and state courts. Can you recall one instance where Aperture has submitted an amended report in the
Aperture is like 290 people. I can only speak for myself. I have certainly done amended analysis. Only certain courts and certain legal systems require reports. But for example, rebuttal, analyzing testimony that comes up in court, getting trial transcripts, I very frequently have come up with new analysis during the trial.
Sir, my question is, as you sit here now, can you state one court case where you or Aperture has submitted an amended report in the middle of a trial?
I cannot speak for Aperture. I can only speak for myself.
Can you answer, speak for yourself, sir. Can you then for yourself recall any instance where you submitted an amended report in the middle of a trial?
Amended reports? No. Amended analysis? Yes.
Thank you.
You're welcome.
Mr. Lessie, is this a good time for a break or
It-
5 more minutes?
It's a good time, Your Honor.
Okay. All right, folks, why don't we take our morning recess again? Dr. Wilkie, right behind.
Great. Love to do the rest.
Welcher, we left talking about the amendments you made to your PowerPoint presentation. And in terms of the amendments, are you aware that the defense counsel received your amended PowerPoint presentation at 3 p.m. on Memorial Day? Are you aware of that?
No.
And you began testifying the day after yesterday, correct, sir? Day after Memorial Day?
I testified yesterday.
Yes. Are you aware of any activity in this trial of any kind before you testified yesterday?
Again, as I mentioned, I've been getting random emails, and then I've been seeing it pop up on my news feeds as well. But once I was aware of the reclusion, I made sure to not review any of that. But as recently as last night, I got an email that said biomechanical engineering job, or like applying for a job. And I opened it up and it was some internet troll.
Sure. I'm asking about emails from the prosecution.
Oh, no, there's been no emails about what's been going. I mean, there's been scheduling, when am I going to come, things like that.
How then was it determined that you were going to be able to amend your power presentation if you weren't communicating with the prosecution?
I mean, they asked me about the witness statement of 138 right around May 13th.
How did they ask you about that, sir?
I don't recall if it was a Zoom meeting, a phone call.
So there was a communication with the prosecution. Might have been by Zoom, might have been by another method, but there were communications while this trial is going on relative to you amending your PowerPoint that ended up with an amended PowerPoint on May 13th. Do I have that correct?
I believe so.
I'm going to switch topics.
Okay.
One of the goals of Aperture's analysis and reconstruction was to determine the location and timing of certain text stream events, correct?
Correct.
EDR data.
I'm sorry, my role.
Your role, yes. EDR, and just for clarification, EDR is Event Data Recorder, correct?
Correct.
So I'm going to refer to that, as you have before, as EDR, Event Data Recorder.
Sounds good.
EDR data does not show the location associated with a text stream event, correct?
In this particular vehicle, it does not.
And the EDR data for this particular vehicle, namely the Lexus SUV, also does not provide the time associated with a tech stream event, correct?
Not at the time of this event.
So the answer is no, correct?
That is not correct.
So let me ask the question slightly different way. The EDR data does not provide the time. The EDR data for the Lexus SUV that you've been talking about does not provide the time associated with a tech stream event, correct?
That is correct.
Instead, every tech stream event is associated with a particular key cycle on the vehicle, right?
Correct.
There can be multiple tech stream events in a single key cycle, right?
Correct.
And every time you start the car, this one you push the button, that's a new key cycle, right?
That will cause a key cycle.
And the EDR data indicates the number of seconds into the key cycle that the particular event occurred, correct?
The EDR data, no.
So EDR data gives you no information about the number of seconds into the key cycle that a particular event occurred.
You're confusing EDR data and tech stream.
I'm not, sir, I'm just
Oh, you're not?
asking a question.
So
If it's yes or no, I'm fine with that.
EDR data will, depending on the vehicle, sometimes it has information about GPS date and time. Sometimes it has ignition cycles, which are a little bit different than key cycles, which is why you frequently have different ignition cycles versus key cycles in EDRs compared to tech stream.
So let me ask it a different way.
Okay.
The tech stream data
Mm-hmm.
indicates the number of seconds into the key cycle that a particular event occurs.
Yes.
Is that correct?
That is correct.
In order to properly determine the location and the timing of a tech stream event, it's important that you correctly identify the trip that is associated with a particular key cycle, correct?
I think I'm going to say yes, that tech stream tells you the trip.
I'm just asking if it's important that you correctly identify the trip associated with a particular key cycle. And do so by determining, in order to properly determine the location and timing of a tech stream event.
So the tech stream tells you the trigger event and it tells you the key cycle. So I'm not determining that, I'm reading that from the tech stream data.
Okay, so in order to properly read, to use your verb, the location and timing of a tech stream event, it's important that you correctly identify the trip that is associated with a particular key cycle. Is that a fair statement?
I think that's a fair statement.
If you associate the wrong trip with the wrong key cycle, then your estimate of when the tech stream event occurred will be wrong, correct?
It can. I mean, you need to take the totality of the evidence in the tech stream with the mileage, the overall timing into account.
So are you saying, sir, that if you have the wrong trip with the wrong key cycle, you can get the correct tech stream event?
No, not necessarily. Again, you have to take the totality of the data.
My question is with regard to if you have the wrong trip with the wrong key cycle, then your estimate of when the tech stream event occurred will also be wrong. Isn't that just a matter of logic, sir?
So again, the tech stream event tells you the trip and it tells you the time. If you're saying I'm, say, associating that with the wrong infotainment information or vice versa, then that would be wrong. But the tech stream data tells you how much time is associated with each trip. There's no difference there.
If you associate the wrong trip with the wrong key cycle, then your estimate of where the text stream event occurred will be wrong. Is that correct?
You can't associate the wrong event with the wrong key cycle because it keys in the key cycle with the event.
Let me try it a different way. Your analysis or anyone's analysis in conclusions regarding the timing and the location of the text stream data are only as good as your ability to correctly associate a key cycle with a particular event. Is that an accurate statement?
No.
Or so
Again, you need to take the totality of the data. So that is one element. You need to look, for example, at the mileage. You need to look at the timing of the events. So this is considered a tool in the analysis process. You need to look at the totality of data to see how it matches up with the physical evidence.
So are you saying that you can have an incorrect key cycle with a particular trip, but you can still get accurate timing and location of text stream data?
So again, you don't get incorrect key cycle with the trip. The trip and the key cycle are coded in by the text stream. If you are attributing an event to the wrong trip, which has a fixed key cycle, that could be a problem.
Exactly. So if we could go, if Your Honor, if we could publish a slide, please, that is in evidence.
Okay.
Thank you.
Where do we look?
Unless he didn't walk them into a trap.
Slide number.
I've got slide 9. Mr. Wolk, yes, I've got the correct one. Thank you, Your Honor. So I'm going to use the acronym VCH that you've used on your, do you recall using the acronym VCH on your direct testimony?
Yes, sir.
And VCH stands for Vehicle Control History, correct?
Correct.
You viewed the vehicle control history on September 23rd of 2024, correct?
In addition to the PCS data.
You viewed the vehicle control history on September 23rd, 2024. Yes?
That is yes.
You took photographs of the vehicle control history, including key cycle 1167?
Correct.
And in this screenshot, we can see 4 text stream events that
Actually,
are...
can you zoom in on the key cycle?
Oh, sure.
Because I think when I got to, no, scroll. So when I got to it, you can see it was that key cycle 1264. The blue highlight was the last file that was written on key cycle 1167.
Right.
So to answer your question, I got it at 1264.
So if we can go back so we can see the 4 text stream events, I just want to reestablish the foundation here. In this screenshot, we can see 4 text stream events that are associated with key cycle 1167, correct?
Correct.
But isn't it true, Dr. Welcher, that there were actually 10 text stream events associated with just that one key cycle 1167?
Correct. I gave you the original files.
Right. So you are aware that the Commonwealth had maintained up into your firm's engagement that...
Are you saying there's no basis for the question? All right, I'm going to allow the question and I'll hear it.
You are aware that the Commonwealth has maintained up until your engagement in September of 2024 that all text stream events associated with key cycles 1164, 1165, and 1167 occurred while the Lexus was in the custody of the Massachusetts State Police at the Canton Police Department.
So the objection sustained. You need a foundation, Mr. Lessie.
Sir, as part of your work in your review of the many documents that you referenced on your direct examination, did you review the text stream events associated with the Lexus SUV?
I reviewed the one I downloaded.
Pardon me?
I reviewed the one I downloaded.
Right. And did that what you download include key cycles 1164? Did it include that?
It did.
Did it include 1165?
It did.
And did it include 1167?
It did. It did not include 1166.
I didn't mention 1166, sir. I only mentioned 1164, 1165, and 1167. I purposefully skipped because I didn't understand you had reviewed it. So here's my question. You therefore, based upon the fact that you reviewed them, and you said it's important to understand timing, etc. That's very important in your forensic analysis, correct?
Yes, sir.
So let's go to the timing question and you understand where the Lexus has been at various points in time. You testified to that in direct, whether it was at the Canton Police Department, whether it was being towed, correct?
In addition to having Mr. Burgess analysis of the data.
In addition to Mr. Burgess analysis, so in that analysis contained locations of where the Lexus had been.
It contained where it had been and also include date and time, when it was turned on, when it was turned off.
Exactly. So not only did you have all the locations, you had dates and times associated with the location where the SUV, the Lexus SUV had been, correct?
Correct.
Now to the question. Based upon that review, that knowledge, that understanding, those bases, you're aware, and you've reviewed, by the way, Trooper Paul's reports, correct?
I have.
There were two reports of Trooper Paul. There was his original CARS report and then a supplemental report that were listed in the documents you reviewed. Do you recall that?
I don't recall that, but I'll take your word for it.
I don't want you to have to take my word. Do you recall, sir,
No, I
that there
don't.
were do you recall that there was a report of Trooper Paul?
Yes,
Okay, and you read that report, I assume, sir.
I did.
And it would be important for you to read that report and read it carefully because it addressed the subject matter that you were addressing, correct?
No, I did my own independent analysis. As a matter of fact, it'd probably be more important that I don't do that to avoid confirmational bias.
But you did read Trooper Paul's report.
Of
correct?
course.
So you therefore are aware that the Commonwealth has maintained up into your engagement.
Yeah, I'm going to see a sidebar on this.
May I, Your Honor?
Yes.
Thank you. Are you aware that over the course of the Commonwealth's and your investigation into this case, that the theorized time of the alleged contact of the SUV?
So there's two words, just strike theorized.
Okay. Thank you, Your Honor. Are you aware that over the course of the Commonwealth's investigation and your
Hold on, Mr. Leslie, court reporter copy.
Thank you. I will.
I'll object again to the question that's coming.
Can I
Go
begin
ahead
my
and
question?
ask an appropriate question, Mr.
Sure. Do you have knowledge whether there is one time or more than one time for the Commonwealth's position, as you know it from reading documents that you said you've reviewed, that there are different times alleged for the incident to have occurred at 34 Fairview?
Objection.
Sustained. You can ask the question, remove part of it.
I'm sorry, Your Honor?
You have to remove part of that.
Okay, understood, Your Honor. Do you know whether there is more than one time that has been proposed by the Commonwealth for the impact alleged to have occurred at 34 Fairview?
Objection.
Sustain.
I'm going to ask for an instruction.
I'm not giving the instruction now.
Dr. Welcher. In terms of the analyses that you have reviewed in this case, is there one time that you understand there to be for a hypothesis for the time of the impact at 34 Fairview?
Objection.
I'm going to see you again, folks. I'm sorry about this.
Now y'all saying that he got hit by a car, but y'all evidence can't say when or what time he was actually hit, and you don't want him asking that question, which is crazy. Your objection, I mean, the question and the objections are creating reasonable doubt within me, because at the end of the day, what time was he hit? And let me line that up with what everybody else said they was doing around this time. That's what the jury needs. Clear.
May I, Your Honor?
Yes.
Thank you. I'm going to move to, for the moment, we'll come back to the other topic a little bit later. As we discussed earlier, you've got on various documents, you're a biomechanical engineer, but I've also heard you make reference to biomedical. Can you just tell me what you consider yourself, sir? Is
Sure.
is biomechanical engineer something you consider yourself to be?
Sure. My degrees are in biomedical engineering. The discipline within biomedical engineering that I practice is biomechanics.
Right. And so is it accurate to say that you are a biomechanical engineer?
Yes.
And you say that much in your report, correct?
And the CV and resume I gave you.
Right. Now, in your report, and Your Honor, I have no issue if he refers to the page of his report.
Do you have a paper copy or do you need your?
I do.
If you, sir, could turn to page 9 of your report.
Okay.
And on page 9, you state, as a biomechanical engineer, I have no opinion on any aspect of, and I think you're referring to Mr. O'Keefe's, medical treatment or medical diagnoses. I have conducted an accident reconstruction and biomechanical engineering analysis of this matter. Did I read that correctly?
Did.
In that statement, I assume, given you wrote it, is a fair representation of your professional role in this case?
Yes.
And you go on to add on page 9, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. Did I read that correct?
You did.
And on your direct examination, is it correct that you stated as a civil engineer, you made an analogy, you assessed the cables and beams of a bridge as you would assess the cables and beams of a bridge, you assessed the human anatomy, you made that analogy, correct?
The analogy that bones are my bridge elements, cables are muscles and ligaments.
Right. And you stated that it's the job of a biomechanical engineer to quantify the force acting upon a person to determine the cause of their injuries, correct?
That is part of what we do.
It's part of, but it is therefore something that a biomechanical engineer does, correct?
Given sufficient data, yes.
So you know do you know what a force calculation is, sir, when I refer to that term?
I believe so.
What do you believe it to be?
Well, force is usually a physical measurement, but you can also use Newton's second law, which is force equals mass times acceleration.
That's exactly what I wanted to get to. Newton's second law is, and sometimes referred to as the second law of motion. And in the second law is force equals mass times acceleration. correct?
Correct.
And just sort of like simple algebra, sometimes you have one or more of those, but I'm focusing on when you're trying to determine, sir, you're pulling something out.
Calculator. I thought you were going to ask me numbers, do calculations.
All right, if we're going to do that, we need to do it with the court's permission. So
Sorry.
if you feel you need to do that, just let me
You
know.
can just leave it right
All
there.
right.
So I just want to get the principles down first. So Newton's second law, force equals mass times acceleration, and force is oftentimes what you're trying to calculate in a force calculation, correct?
Calculate or measure, yes.
Yeah. And Newton's first law is the law of generally inertia. An object at rest tends to stay at rest. Object in motion tends to stay in motion. We're not talking about that in force. We're talking about Newton's just second law, correct?
You asked me two questions. Newton's first law is generally, as you said, it could be at rest or at constant velocity, but yes.
Okay. In that, Newton's second law is generally just a mathematical calculation, correct?
Yes.
So what I'd like to do is to turn to page 11 of your report. And on page 11, you discuss the force calculation in conjunction with the part of your report where you discuss your experiment where you dropped a test dummy backwards, correct?
Correct.
You determined that a fall of 69 inches, at that fall, Mr. O'Keefe's head would have accelerated with 458 G's of force.
That's what we actually measured.
Right.
In the test.
And can you tell the jury what is meant by G's?
So G's is a measure of acceleration. If you use the acceleration is measured in feet per second squared. If you divide it by 1G, which is 32.174 feet per second squared, that gives it to you in G's. People often heard about fighter pilots losing consciousness at 6 or 7 G's, basically because your blood's getting sucked away from your head, not because you're being impacted. But G forces, or G's as they're more properly called, is a measure of the acceleration. It's just whatever the acceleration is divided by what we all feel when we're standing here, which is 1G of gravity.
And you estimated Mr. O'Keefe's head weight of approximately 15.7 pounds. You used a percentage. Is 15.7 about right for the mass of,
yes.
of the head? So if we apply Newton's second law, we keep F force open as the unknown. We take and apply the mass, which is 15.7, multiply it by the acceleration. You end up with a force acting upon Mr. O'Keefe's head of 7,200 pounds. Do I have that right? That's right out of your report.
So that math is all correct. Falling backwards onto a hard surface from his standing height will give you approximately 7,200 pounds of force.
In that 7,200 pounds is the previous unknown F in the Newton's second law equation, correct?
Correct.
So now we have an answer for F, 7,200 pounds. Now you then go on to note that the applicable scientific literature states that a fracture to the occipital bone, and just to review, the occipital bone is the back of the head right here, right?
Correct.
So you then, as I understand it, you go to scientific literature and you concluded that a fracture to the occipital bone can occur with an average force of 1,634 pounds from a fall distance of 40 inches, correct? I'm sorry.
How many inches?
40. That's in your report?
Well, you mixed two things together. There was stuff that reported force data. You had those numbers correct. A range of between 1,150 and 2,150, a mean of 1,634 pounds. And then it says, and a drop distance as low as 40 inches.
Right. And is the number 634 pounds a proper number for an average force?
Did you say 1,634 pounds?
1,634.
Yes.
Okay. So what I want to do is see if this is correct. So if you can get a fracture of the occipital bone in an average force of 634 pounds.
No. 1,634.
I thought that's what I said. If I did, I missed.
Oh, I'm sorry. I just heard 634.
No, 1,634.
My apologies.
And you compare that to the 7,200 pounds of force that you calculated, surely you're going to have a fracture of the occipital bones through that calculation in that comparison, correct?
Correct. Falling on a hard surface can definitely fracture your skull.
So I'm not getting at the manner. I'm just applying the Newton's second law. Newton's second law doesn't look at manner, does it? It just looks at force equals mass times acceleration. Newton's second law doesn't look at the surface, does it?
So it's a function of the surface. The A value is a function of the surface you hit.
So you're saying acceleration depends upon the surface?
Yes, of course.
Okay, all right.
For an impact, it does.
Now, let's go to the study you cited. Injuries to pedestrians in real accidents in their relation to collision and car characteristics. That's in your report, correct?
What reference number?
May I, Your Honor, grab the report?
Yes.
Thank you. If you can, it's in your report, sir. If you can find it, I'll do it in parallel with you.
I can't believe he just said that. That is crazy.
Is it number 25?
That's the one I think it is. I just want to check your report.
Would you like me to actually pull up the paper?
No.
Okay.
Just want to get to the. That's it. Number 25. We're talking about the same one. Now, isn't it true that this study states that head injuries are the most common injury type for motor vehicle collisions, constituting more than 61% of all injuries sustained from motor vehicle collisions?
Or could the witness see the document that's being referred to?
Do you have your report in front of you?
I have my report, but reference 25 is not in the section he's referring to.
Why don't you show it to him, Mr. Leslie?
I do not have with me a copy of the report he cites in his reference. He did. Can I ask another question? Your Honor?
Yes.
Thank you. Dr. Welcher, on your direct testimony, did you not discuss the percentage of pedestrian injuries and relate it to heads? Did you not, on your direct, talk about percentages of injuries that are head injuries in impacts of pedestrians with cars?
Yes, I did.
Okay, so you came up with a number. What I'm trying to do is to compare that number to the number in the study that you cite. If you don't remember, that's okay. We'll just move to the next question.
Can I go to my slide?
Whatever you can use to determine what was the percentage that's in the study that you cite in footnote 25 of your report.
Sure. That was also from my presentation that I gave. It's 61.5 for all injuries, 12.7 for fatal injuries.
Thank you.
You're
So I'll
welcome.
repeat my question and then we'll get it in logic. So that study states that head injuries are the most common injury type from motor vehicle collisions, constituting slightly more than 61% of all injuries sustained from motor vehicle collisions, correct?
That number is correct. You're quoting a sentence. I would want to pull the paper up, but the number is correct.
Okay, so doesn't this article also state that of all head injuries sustained by motor vehicle collisions, only 12.7 of them are fatal?
That does, yes.
Did you mention that only 12.7 are fatal on your direct examination?
It's circled with a red box on my slide.
Did you mention that on your testimony on
I
direct?
thought I did.
This article was published back in 1979, correct?
I believe that's correct.
It's 46 years old, therefore, if I did the math correct, right?
That sounds correct.
Are you aware that given advancements in science since 1979, advancements in medicine, advancements in technology, the currently understood most common injuries as a result of pedestrian motor vehicle collisions are injuries to the lower extremities?
I'd have to see the study. It wouldn't surprise me. Car technology, especially, for example, with pedestrian safety systems, has caused autonomous braking. So you're getting fewer higher severity crashes, which results in a higher propensity for lower extremity injuries. It's the higher extremity crash that causes the head to either slap into the hood or the window and or bounce off, to where if you get the lower severity crashes, you can still maintain a standing posture. So it wouldn't surprise me if that's accurate.
So you would agree that as of January 2022, the most common injury as a result of a pedestrian motor vehicle collision is one to lower extremities?
No, I wouldn't necessarily agree with that date. And again, you have to look at frontals versus rears.
So you can test that the most commonly understood injury as a result of a pedestrian motor vehicle collision is injuries to lower extremities.
Hey, that's about a source.
So I'll allow the question.
So I'd want to see the data. Again, most cars, for example, this Lexus has a pre-collision system in it that will start to apply the brakes if it senses a pedestrian at the front of the car. And so for frontal collisions, it's transitioning, taking what were head injuries, because they're more severe, higher speed crashes, making them lower speed crashes and shifting the injuries to the lower extremities. Just like airbags shifted the head injuries away from the severe ones, and we started getting more or higher ankle and lower leg injuries. So the change in the technology, but for backing, that may not be the case because you have different geometry on the vehicles and you have different safety systems.
I'll try it a different way.
Mm-hmm.
Do you have knowledge, as you sit here today, whether the most common injury from a motor vehicle accident is to the lower extremities?
I'd have to look at the literature. I have the article I gave you.
So the answer is you don't know the answer to that question. Is that correct, sir?
I don't know it off the top of my head.
All right. Newton's second law analysis that we went through, force equals mass times acceleration, where we came up with the 7,200 number. You didn't discuss that calculation on your direct examination, did you?
I don't think so. We didn't discuss a whole bunch of those things that were that wasn't necessarily an opinion, that was a sub-opinion or basis for my opinion.
You didn't discuss that Newton law calculation on your direct examination, did you, sir?
So in a way I did, because I said my drop testing shows that you can do this. So I didn't quote that number, but we are going through the specific numbers now. But I absolutely did say, as a matter of fact, I showed a video of my drop testing and talked about how falling onto a rigid surface, a hard surface, can cause a skull fracture.
Did you discuss on your direct examination applying 15.7 of the head weight to 458 Gs and come up with a number of 7,200? Did you do that on your direct examination?
Those specific numbers, no.
Thank
the general
you.
concept of the drop testing and what it showed, yes.
So instead of that calculation, you referred to a flow chart comparing injury characteristics of flaws versus blows. Do you recall doing that on your direct?
So you asked me two questions. You said instead of, so that's no, it's not instead of. They're two completely different topics. So no, I didn't do that instead of.
Okay.
I looked at a force analysis, then I looked at 3 peer-reviewed publications that were attempting to differentiate whether an injury is associated with a fall or a blow, an assault, and they came up with a metric for doing that. Those things are completely separate.
Let's ask it this way. Did you, on your slide presentation that you presented to this jury, did you put the inputs into F equals M times A in your slide presentation with the numbers we talked about of 15.7 for the M and 458 for the G to come up with 7,200? Was that anywhere on your slide presentation?
So the slide presentation showed the 458 Gs. The rest of it was not on there.
Thank you.
You're welcome.
You also indicated that the laceration above Mr. O'Keefe's right eye is consistent with the shape and height of the fin on the top of the Lexus SUV. Do you recall that?
Correct. It's actually properly called a spoiler.
And so you would call it a spoiler instead of a fin?
Correct.
Fair enough. We'll call it a spoiler. You visited the scene at 34 Fairview, correct?
I did.
You stated that you like to visit the scene while you're working as an accident reconstructionist so you can get a better understanding of the data?
I'd use the word like, but we want to go to the scene to see the scene.
When you visited 34 Fairview, did you go into the garage at 34 Fairview?
No, I actually didn't set foot on the property.
You didn't set foot on the property?
No, I stayed in the street. It's my understanding there were new owners.
Did you consider the scene limited to the road?
So the access I had was to the road. The laser scanners and the photographs will extend further, but I didn't have access to the interior of the house.
Oh, so you didn't access the entire scene, correct?
In my opinion, I did access the entire scene. I didn't physically step 7 feet onto the grass to the point of rest, but I stood and photographed where that was. I didn't want to trespass.
Where did you understand the body of Mr. O'Keefe was located?
I know it was 7 feet in from the grass. I've seen cruiser cameras showing people around a body. It's slightly north and slightly south and a little bit west of the flagpole.
But you didn't access that part of the scene that you just described, correct?
I absolutely did. I took photographs of it. I didn't trespass and stand at that exact location, but I stood right there. We scanned the whole thing. The scanner uses a laser beam that goes out, 150, 200, 300 feet. So we scanned all that stuff.
Did your scan topography?
Yes.
Then you know that there is a berm raised above street level, correct? If you did the scan.
Correct.
Do you know the height of that berm?
I believe it's 4 inches.
Nowhere in your report, when you're comparing the height of Mr. O'Keefe to the spoiler, do you account for that 4 inches of the berm, do you?
So yes and no. As I indicated, we don't know exactly where the point of impact is, whether he was completely in the road or up on the berm. But for example, where the tire spins on the Lexus, that could be where she's driving up on the curb. And so then that tire will be at the height of the curb. So if he's standing on the higher part and the right rear tire of the Lexus goes up there and spins, then that would be at the same height. We don't know the exact point of impact. So I don't know whether he was on the road or in the street. Excuse me, on the street or on the side of the road.
Exactly, but when you did your depiction on your slide, and you remember you had the ruler, you measured the height, did
Absolutely. Yep,
Where was it? It was you? Was it you in that slide?
it was.
Where were your feet?
No.
Hey, Sonya. All right, y'all. So we're gonna actually go back to Karen Reed until they actually start the proceeding. So I don't know how long it's gonna take for them to start. I don't want us wasting time. We got a lot to watch today.
On the ground.
Not on the berm, correct?
Correct.
Okay, so you
All right.
chose
Once
the
they start the
measurement,
proceeding,
which
I will
was the
switch
ground
over to
to
Garland.
the top toward the spoiler, and you took a measurement. And you said that that approximates the height of Mr. O'Keefe, correct?
Of the laceration of Mr. O'Keefe.
Exactly, because what you were doing was you were trying to determine and present testimony on whether or not that laceration could be caused by the spoiler, and to do so, you had to take measurements, correct?
Correct.
So, you chose to place Mr. O'Keefe in your simulation on the ground. You didn't choose to put him on a berm that would be 4 inches higher, did you?
Nor did I put the Lexus 4 inches higher. I didn't do
Correct.
either one of those.
So the point is, it's certainly possible that if there's 4 to 5 more inches, that would take that eye out of the ability to be hit by the spoiler. Isn't that correct?
No, because if it's 4 to 5 inches higher and he leans his head down or reacts to it, again, we don't know the exact position of his head.
Did you, in your slide yesterday, describe the possibility that his head could be down? As I understand it, you're positioned in that photo just like this. You're not positioned like that in any photo you presented to the jury, were you?
trying to make it clear. We don't know his exact body position at the point of impact, nor do we know the exact position on the ground. So, which is part of the reason why I haven't tried to exactly simulate this, because we don't have enough parameters to do that. So I don't have that information. I'm showing the geometry relative to someone of Mr. O'Keefe's height.
So you don't have the information to do that.
Mayor, I want to clarify, I did 45 years to serve 20 years in confinement with a balance on probation.
Right, yeah, that's what I. We're on right now.
Who am I sending it to?
Miss Warlick. And I guess, does the state need it? Oh, we ready? Okay. All right, so is the state gonna go first? And I don't know what the recommendations are at this point, so if y'all could let me know that as well.
Yes, Your Honor. Good morning, Your Honor. Today we're here regarding sentencing for Mr. Diddy Burlington. Yesterday, Mr. Johnson pled to count 1 of this indictment, which is conspiracy to commit the Racketeering and Corruption Organization Act. Count 42, participation in criminal street gang activity. Count 49, which is aggravated assault, murder, reduced to aggravated assault. Count 50, participation in criminal street gang activity. And count 54, possession of a firearm during the commission of felony. Those charges are total exposure of 85.
Right.
As you heard yesterday, Mr. Bronson is currently on probation, indictment 15 SC 138894 for crimes associated with the April 28, 2015 drive-by shooting of Adele Avenue and Drew Drive. He received a total sentence of 15 years to serve 5 years in confinement. That probation ends on December 27, 2029. The state brings that up, Your Honor, because as a general condition of probation, Mr. Bronson was not to violate any criminal laws. And as a special condition of that probation, he was to have no direct or indirect contact with any YSL members, no contact with any gang members, and no gang-related social media.
All right, and is the state seeking to revoke that probation?
Not at this time, Your Honor. And while we're not here for a probation revocation matter, the state thought it was important for this sentencing court to be aware of what Mr. Bronson was required to do, because he has failed to comply with any of those conditions. Instead, Mr. Bronson chose to continue to associate with YSL gang members, to include Shannon Stillwell, Kenneth Copeland, Jeffrey Williams, Khalid Adams, Jaden Myrick, Pontavious Greer, and that's the name of few. He then engaged in a conspiracy to attack a rival gang member, Rashawn Bennett, who was stabbed in the Fulton County Jail. That incident ultimately led to a retaliatory shooting that killed Christian McMiller and Darius Ford. And that murder led to another retaliatory shooting in which the state believes that Mr. Bronson was a part of, which was a retaliatory shooting that killed Mr. Chanel Drakes on March 14, 2022. After Mr. Drakes was murdered, it was Mr. Bronson on his social media post that said, "We got you, boys." And this was only hours after the murder. And the state believes that was to indicate that he, along with Shannon Stillwell, avenged their friend's death. And even after that murder, it was Mr. Bronson talking with other gang members over the phone while certain individuals were in custody to get protection for fellow YSL gang member Miles Farley. It is the state deciding its recommendation, Your Honor. The state has taken into consideration a number of different factors. Mr. Bronson's previous criminal history, Mr. Bronson's involvement with the YSL gang from 2015, his continued gang involvement even while on probation, and Your Honor, we have certainly taken into consideration the results of the previous trial that we had before Your Honor. Given that, Your Honor, it is the state's recommendation that for count 1, RICO, 20 years to serve in confinement. Count 42, participation in criminal street gang activity.
which would be 20 years to serve, concurrent with count 1. Count 49, aggravated assault, 20 years to serve, consecutive, 20 years to serve concurrent with count 42 and count 41. Count 50, participation in criminal street gang activity, 20 years to serve consecutive to count 1, but on probation. Count 54, possession of a firearm during the commission of a felony, 5 years to serve consecutive to count 50, for a total sentence of 45 years to serve with 20 years in custody. As a special condition of that probation, Your Honor, he's to have no contact with victims or co-defendants, no criminal street gang activity, no association with criminal street gang members, no firearms or gun replicas, no gang paraphernalia.
Hang on.
If he has not obtained his GED, be in school or gainfully employed, and any Fourth Amendment waiver, including social media. The state did have, just as some evidence in sentencing, Your Honor, these are items that were presented during the first trial, but some of the social media posts that led up to the murder of Mr. Brinks, Your Honor. And I'm showing it to the country. Your Honor, the first 3 states exhibit 1, 2, and 3 are pictures of Mr. Garlington with YSL Associates Christian McMiller prior to his death, Your Honor. The third one is Mr. Garlington seen with his head towards the camera with previous co-defendant Antonio Sumlin. State exhibit number 4 is a post by Mr. Shannon Stillwell, which was a few days before Chanel Brink's murder, which says ain't gonna be the only one crying. And then state exhibit 5 is the exhibit that I referenced earlier, which was done only hours after the murder of Chanel Brink's, in which Mr. Garlington posted, "We got y'all boys." Yeah.
You may. Any objection to those?
And Your Honor, we do not have any victim impact statements for this sentencing hearing, and so with that, we conclude.
All right.
And Your Honor, I want to clarify, I did 45 years, served 20 years in confinement with a balance on probation.
Right. Yeah, that's what I understood it to be. Thank you. Good afternoon.
So we were grateful for the negotiations that we were able to get to, at least partially. We couldn't get there on the numbers, but at least we got there on the charges. The state's indicated what they took into consideration in making this law, I guess kind of balancing what we were requesting. But I do want to just run through a little bit of Mr. Garlington's situation and juxtapose it to the other defendants. And then at some point, like, better understanding from the outside of the indictment, the charges and the posts. As it pertains to the charges here and in the indictment, I don't believe I even find anyone that's alleging that he was a leader. And at some point in that 2015 incident, which is why he is on probation, he did cooperate with law enforcement. He gave a statement. They were questioning him about 2 shootings. He thought that they were only asking him about 1, and he did admit to his involvement in that one. His original sentence, I believe, was 10 to 2, and then ultimately he was resentenced to 15 to 5.
Mhm.
do want to point out that that probation violation was his revocation. Wasn't for him committing a new offense. It was for him being associated with a gang member. I don't have the case off the top of my head, but a 2024 case. And this was concerning the overly broad terms that pertain to child molester sentences. Said that it's overly broad to put that sentence, do not have any contact indirectly or directly with children. Right? I don't know.
Yeah, I think it was more that the condition that said stay away from anywhere that a child might be was overbroad, but I know the case you're talking about.
Yeah, and so same situation here. I believe it might be but I want to highlight the most out of there that he was not engaged in committing a criminal offense. He wasn't subsequently charged for anything, and that revocation took place in 2020.
Mm-hmm.
We don't have him down for any other incidents until 2022, and that's where I would like to direct the court to his 2022 situation. Of course, here's an overview of the charges. Of course, we're aware of the RICO and what the overt acts are. Most of the overt acts concern pictures, posts, and conversations amongst friends. Then we turn to the jail incident. During the time of the jail incident, Mr. Garland was out of custody. There was conversation between Mr. Myers and Mr. Adams. We went through most of this yesterday. That's on the Zoom.
Mm-hmm. Right.
But he didn't. What wasn't necessarily within the text message was there was a confirmation from him saying, "Oh gosh, did you guys get this done?" Or "Wow." There was no request from him to make it public. Throughout the course of this, we've heard that the gang members seek recognition and acknowledgement, and most of the time they post their wins and whatever's happened. There's no evidence of that, and it's seeking to say, hey, post this, let them know that this happened, let them know that I was involved here. He's not bragging about it. There's no evidence of him taking credit for it. And there's no evidence that he paid for it. I think that the state's theory was that he was involved in some sort of payment for this incident to take place. And the evidence just doesn't support that. In fact, from the incident reports from the jail incident, it seemed like they had gotten into an argument, Mr. Myrick and Mr. Bennett, before this happened. Mr. Myrick had been wandering around for a while. I'm going to attach just a snippet of that. He'd been outside they were both in protective custody. He'd been outside himself. And then at some point, Mr. Bennett was let out. So Bennett had time to do his jail or his video visit in peace, and then some sort of argument ensued, and that's when they got into it. As it pertained to what happened with the Drinks case, I'm sure the court heard, but I just want to reiterate just this part.
I remember it.
Okay, I need to play it, Your Honor. But as it concerns Mr. Garlington, still we have no direct evidence of him being at the location. We don't have evidence of him being in the car, so DNA. Not that that's like a big deal because again, there was very little evidence found in the vehicle to begin with for any. There's no evidence that they had planned to do this. And the post that was made after, and I get what the state would like for Mr. Garlington's intent to be behind that post, but it had nothing to do with Mr. Brinks. I don't think We Got Y'all Boys is just like a general statement of support. They were going to the studio that day. I'm not sure what inside jokes they might have shared. But I just am hesitant without there being other evidence to infer nefarious intent to a post that's so general in that nature. Of course, the video that the court is aware of doesn't even support, even if there was a reach to put him in the car, it doesn't support. Now, there isn't enough circumstantial evidence placed in there. There was enough from their FBI situation with the cell phone, but even with that, there's conflicting evidence as to the cell phone tower. At some point, early March, there was a wiretap placed on Mr. Garland's phone. The FBI compiled this location data based upon his cell phone records. However, the wiretap is getting real-time locations of incidents. So this is what the FBI's looks like, and it's tracking. And the shooting takes place around 10 p.m. So they got his time located from 9:30 until about 9:59 around here. What's interesting with the cell phone, the wiretap data, is that it shows that he's traveling up I-85, and where his cell phone peaks up, it bounces from one tower to the next. Where it ends up is north and I think it's north and east. North of 20, east of 85. And so that incident location takes place west of 85 and south of 20. So then 9:48, it's only pinging up in that direction, which is more indicative of that he was traveling up 85 north separately, whatever, and then came down. And that is consistent with him being found on the highway, not necessarily in that location. That real-time data at no point puts in where the location of the incident was or the gas station. But again, circumstantial evidence can go either way. And so Mr. Garlington was willing to take the risk on that case to Alfred plea. But I would like the court to consider the sentences of other individuals in this case based upon their leadership role, Mr. Garlington's lack of leadership role, his cooperation, no evidence that he directly harmed anybody in this one. For a lot of the previous defendants, there was no direct, or maybe there was enough guilty enough presentation of evidence of direct harm, and his prior felony conviction. So what we would ask the court for is a global 40-10 and credit for time served with the balance suspended, and how we envision that would be 20-5 on count 1, credit for time served, balance suspended, count 42, 10 years probation, consecutive, count 1, count 49, 20 years probation, concurrent with count 1.
How many?
20. Count 50, 10 years probation consecutive to count 42, and count 54, 5 years to serve, balance suspended, credit for time served, balance
54. It looks to me like that adds up to, let me read that back to you. What the recommendation is, y'all are recommending 20, serve 5, balance suspended on count 1, 10 probation consecutive to count 1 on 42, 20 probation concurrent with count 1 on 49, 10 probation consecutive to 42? Is that what you said, or to 49 on count 50?
It was consecutive to 42.
Okay, that's what I thought you said. And then on 54, 5 to serve consecutive to 40 to 50 and suspended.
That throws me off. I think it was supposed to be the 5.
I don't know. What is it? What are you suggesting? Trying to understand what your recommendation is.
I think the 5 was to serve concurrent and then
54 has to be consecutive, right?
I'm sorry, it does have to be
Oh man, she's sounding real unconfident.
So that would really be 45, right? To serve. And you said 45 serve 10, but I don't see where that's coming from.
I'm sorry, it's 45 serve 5 because I didn't give out the weapons charge.
All right. Anything else you want to present?
Yeah, sure. I know what that is. Family members to speak. What we envisioned was not to just come in here and blindly ask the court to give him probation without employment. I don't know what the court's take is on this, but a lot of this seems to be the situation where we have back and forth. Something happens to someone, and then we have something happen to someone else. We're trying to minimize his involvement going forward and his need to engage in other criminal activity.
Well, there's never a need to engage in
Yes,
criminal.
correct.
I want to rephrase that.
What, or the perception, right? So what I've seen here is, without throwing anybody else under the bus, other individuals still carrying weapons under a presumed, that I'm presuming that would be the reason why, is that you feel that you are somewhat at risk, despite that being against the terms of your probation and against
the
what you're
law.
lawfully allowed to do. I don't even want the feeling of that, and I think the best way to alleviate that risk feeling is to remove Mr. Brown from these situations and to have a plan going forward about what he's going to do with his life. He and I have spoken extensively about it. Of course, one cannot make plans from inside the jail to an extent. A lot of his plans involve leaving the state entirely, which I support. That would alleviate a lot of the risk.
Okay.
It's not just a risk for him, but as we've seen in the facts here, it becomes family members, other people, friends that become unintended targets of these various acts. On short notice, we weren't able to lock in a lot of provisions for what he could do and what we hope he's going to do. But I do want his family to at least discuss with you about the plans that they have, so that the court understands that we're not just saying, hey, just let him go, we'll hope for the best. No, we have some plans.
Okay, have you discussed with the family what those plans
I
are?
have,
Okay, well, why don't you let me know what they are?
So generally speaking, his aunt is a business owner. She owns a number of businesses. And so she's able to employ him. It's like, one is like a lawn care service. She's got several contracts for that.
Is this local?
Not local in Atlanta. I think it's Metro Atlanta. Is that correct? Yeah.
Pretty local. Okay. What other ideas?
So that would just be the first one.
Yep.
I would like for her to speak about who she reached out to out of state. So she's got other relatives out of state that she was able to speak to. I wasn't able to speak with them directly, so that's why she went to the court to allow her to communicate directly about what those plans are.
Okay.
Would you like me to go over?
And the state provide what the statute for aggravated assault is on that lesser on 49.
OCGA 16-5, that's 21.
Thanks. 49, yeah. You have this. Okay. Yes, and they've null prossed 40, 43, and 51. 43 and 51. All right, we're back on the record, and I have taken into consideration the state's recommendation, the defense recommendation, the evidence that's been presented. I also am obviously aware of the evidence that was presented in the other trial, and I have taken a look back at the sentences that this court imposed for co-defendants from the prior trial, including co-defendants who were charged with some of the counts that Mr. Garlington is currently charged with and has entered an Alfred guilty plea to. Also taken into consideration his prior record as well as the prior records in the other cases in which this court sentenced. Also, other than one of the sentences imposed by this court in the first trial, the sentences that were imposed were joint recommendations, and I've taken that into consideration as well. The sentence for count 1, which is the RICO count, is going to be 20 years to serve 5, the balance of 15 probated. Count 42, the sentence is 20 years, serve 5, balance probated, concurrent. The sentence on count 1 reduced, I'm sorry, not 1, count 49 reduced to aggravated assault under OCGA 16-5-21. Is that what you said, 21? Okay. Is 20 years to serve 5 with the balance probated, concurrent with the other sentences. And I'll note in that regard that one of the defendants charged with that set of crimes was found not guilty, and 2 others, the state decided to null pros the counts against them. In count 50, the sentence is 20 years, serve 5, balance probated, concurrent. And then the sentence for count 54 is going to be 5 years consecutive to count 50. And it can be suspended upon successful completion of probation. So that's essentially 20 years, 5 to serve with credit for time served, 15 years probated, followed by 5 to serve, which can be suspended and will be suspended as long as the probation is successfully completed. Special conditions of the probation: no contact with any of the victims in this entire indictment or with any of their family members. No contact with any gang members from any gang whatsoever. No gang paraphernalia, no gang associations, no guns, no replicas of guns. You need to secure full-time employment within the first 6 months after you're released from probation. You need to sign a social media waiver and a Fourth Amendment waiver. And that is going to mean that during the entirety of your probation, law enforcement at any time they want to can look at your social media posts, can search your person, can search your home, can search your car with or without probable cause to ensure that you do not have any gang paraphernalia, any guns, any drugs, anything you are not supposed to have. You need to secure your GED, which I know you told me yesterday you were working on it and had gotten to parts of that already. Go ahead and get the rest of it within the first year of your probation. And I am going to require that you stay out of Fulton County for the entirety of your probation. All right, that is the sentence of the court. I hope that, as I have said with the other defendants whom I've sentenced, that this has been an opportunity for you to realize that the direction that your life was going is not a good direction, and that you are determined at this point to turn your life around and make good decisions from here on out. Associate yourself only with people that are going to help you to stay on the straight and narrow. So you've got a little bit of time left to serve before you're released. I think a couple of years at least, but go ahead and do that. You can be working on your GED and on job skills while you're in prison. Good luck to you. And I hope not to ever see you again, because if you violate your probation, you're coming before me. So let's make that not be a thing. Okay. All right. Good luck to you.
You want me to add that, Judge?
What?
In violation.
Back to me. Yeah.
Laceration to the eye from the spoiler by your own answer that you just gave, correct?
So it was done properly. We don't have absolute information to say where exactly he was. I'm pointing out that the physical evidence, the height, matches the height of the laceration. That is one data point of many data points.
So you would have to at least concede that the level of his eye could be non-contacting that fin or spoiler, because you don't have information as you just described.
Sure, it could be from contacting the ground.
Pardon me?
It could be from contacting the ground. It could be from other things.
But you don't have the information necessary to conclude with any certainty that Mr. O'Keefe at the time of impact had a level of his head in an upright such that it hit that spoiler. You don't have that information, correct?
We don't have that level of certainty. We have that the height and geometry matches.
And you didn't take into consideration the berm, and you didn't mention the berm at all when you were discussing this measurement with the jury yesterday, correct?
That is not correct. You asked me two questions. I absolutely considered the berm. And the second question, when I presented to the jury, I mentioned the berm when we showed the picture of the shoe in the snow, but that was it.
That's my question. I'll ask it a different way. When we were talking not about finding a shoe in the snow, and you mentioned a berm, I'm talking about when you did the measurement of whether or not the laceration could be caused by the spoiler. You didn't mention accounting for berm height when you discussed that measurement with the jury, did you?
That is correct.
Likewise, you didn't present any Newton's second law analysis regarding the front of Mr. O'Keefe's head with respect to whether his head was contacted by that spoiler, did you?
Correct. Again, it was a glancing hit. We wouldn't be able to do that.
Oh, so it's a glancing hit to the front of the head is your hypothesis?
This whole pedestrian impact is a glancing hit.
So you can have your arm to the side like this, with the back of the vehicle coming like this, and you could glance the right eye with the arm out. Is that what you're saying?
That's what my picture shows when I'm standing next to the car. I could probably find the slide for you.
So you didn't do a force analysis to determine how much force would be applied assuming a contact with the right eye, did you?
That's correct.
And force analysis is what biomechanists do, correct? That's what a biomechanist does?
That is part of what
they do.
So I lined up his anthropometry relative to the known height of the vehicle.
You attempted to line it up. That's one method, but another method is to apply Newton's second law like you did to the back of the head when he fell, correct?
Correct, if we had more information.
Mr. Leslie, why don't we break here?
Thank you, Your Honor.
So jurors, your lunch is here. We'll see you in 15 minutes.
Rise for the jury.
Goodbye.
Good afternoon, Dr. Welcher.
Good afternoon, nice to see you again.
Same. We had left off talking about some examples of Newton's second law and the application of it in the parlance of force equals mass times acceleration. And I now want to continue on with that discussion. It is correct that you can conduct a force analysis on any part of the body, correct?
I mean, it's more difficult on internal with live people. Like if you wanted like my appendix, I really necessarily couldn't.
Let's talk about the musculoskeletal system, the outside bones. You can conduct a force analysis
So your
on
bones
any
are on
bone.
the inside.
Sir, if I could finish my question, please.
Okay.
You can conduct a force analysis on any bone in the body, correct?
More or less, yes.
So the force analysis I use as a synonym with Newton's second law is not exclusive to the head, correct? You can do it on other bones in the body, correct?
Correct.
On direct examination, your direct examination here, you did not present a force calculation representing what you allege to be contact between the vehicle and Mr. O'Keefe's right arm, did you?
Correct.
And nowhere in your report do you present a force calculation for Mr. O'Keefe's right arm, do you?
Correct. We didn't have enough information to do it.
We're going to get to that.
Okay.
Now, given that you stated that, quote, determining the effects of physical forces on the human anatomy, end quote, is the job of a biomechanical engineer, you must have conducted several force calculations related to accidents involving humans in your career, correct?
Hundreds.
Hundreds. Now, you didn't present a force calculation in your materials, as you've stated on direct, with regard to the arm, and I'll include in the right arm going from the shoulder all the way to the tip of the hand. Okay, so that's my definition of a right arm. You didn't present any force calculation on that part of the body of Mr. O'Keefe, did you?
Correct.
Assume, and we're going to apply Newton's second law. Assume Mr. O'Keefe's hand weighed 7 pounds. So that's the M in the F equals MA.
That's not a good assumption.
Well, what number would you like to apply for an M for the hand of Mr. O'Keefe? I'll take any number you got.
Just the hand?
Just the hand.
Oh, the whole arm of Mr. O'Keefe weighs approximately 12 pounds.
Okay, fair enough. So the whole arm is either from the shoulder down to the tip of the fingers is about 12 pounds, right?
Correct.
Okay. So assume that the Lexus SUV was traveling at 20 miles an hour. All right? Under your theory going backwards, 20 miles an hour. And the third variable I'd like to give you is to assume an impact window of 10 milliseconds.
Okay.
Can you calculate the G's of force from that data?
You need more information.
Well, let me ask you this. What more information would you need?
So we talked about the glancing impact.
I'm talking about a force calculation of an impact, not as to whether it's glancing or not.
So you want a direct head-on impact in the arm, not a glancing hit to where the Lexus comes in, hits the arm, and they continue off together?
I'd like to start with that, but just so we can hopefully expedite it for the jury.
Okay.
I'm going to want to get to what you have depicted in your diagram of holding the arm out. And that's not a glancing impact. Is that, sir, with the right arm in parallel with the back of the Lexus?
Yes, it is. So really I'm sorry, let me finish, please. What you're concerned about is where the center of mass is. With the center of mass out towards the corner of the car, that becomes a glancing contact. So you don't have a center of mass contact, you have a glancing contact.
Okay, fair enough. So let's start the first force calculation.
I need my calculator.
I'm going to let him use his calculator.
Sure.
Okay,
Tell me when you're ready, sir.
go ahead.
So let's take a scenario where it's a center of impact.
Center of mass.
Center of mass impact, right?
Okay.
Impact to the right arm.
Okay.
Let's start with that one.
Okay. And you want me to use like a 10 millisecond?
Yeah, be conservative. Yeah, let's use a 10 millisecond for
Okay.
the impact window.
Something's going on. Wait a minute, y'all. I don't know what's happening. Something's happening. I don't know what's going on. This is why I gotta get a new laptop, y'all. This is why I need a new MacBook, because clearly it's running its course. This fool. Okay. I'm trying to get. I'm sorry, y'all. I'm having technical difficulties over here today.
Okay, question?
What do you get for F of force in the F equals M times A calculation?
About 2,188 pounds. I made a triangular crash pulse assumption.
Right, and if you took the milliseconds in half, become less conservative, would you end up doubling the 2188 number?
If you cut it in half, you would double, yes.
Exactly, through a simple mathematical semi-algebraic application of the numbers, correct? You
Correct.
divide.
We're doing a little simplification in terms of the crash
Yes.
pulse shape, but generally, yes.
Right. So, but let's take the conservative number, the lower number, 2188 that you came up with. Do you know from the literature, as you did with the head, you went to the literature and said, this is how much pounds of force, you would get to have to cause a break at the occipital bone. Do you know from the literature how much force it would take to break an arm bone?
I have an idea, yes.
What is your idea?
So for a distributed load, such as this, not a concentrated load, you're going to need somewhere between, I've seen, and this is for cadaver tests, a low of like 2,500, maybe a little lower, to a high of 7,000.
Sir, you have switched, haven't you? We're talking about center mass impact. Did you in your calculation just switch to a side swipe impact to do your calculation?
No.
I'm asking about a center of mass impact. How much force would you need? Let's start with the hand. Maybe it's a simpler one. Do you know how much force it takes to break, any of the hand bones, you know what I'm referring to, the phalangeals?
Yes.
The metacarpals, and the carpals?
Correct.
How much pounds of force do you need to break any one of those bones?
Actually, I didn't find any distributed loading on the amount of force. I don't know.
Well, no, I understand, but I'm asking, do you know from the literature, not a calculation? Doesn't the literature tell you? Can't you go to the literature like you did with the head and you say, okay, to break the occipital bone, the literature says you need a minimum amount of force of this. I'm asking you the same question for the hand. If you don't know, it's okay, but do you know what the literature says for how much force is needed to break a bone in the hand?
So for a distributed load across the hand, there are distributed load tests that show you need over 300 Gs on the arm to do that. So it would depend on the mass of the hand.
What is the range of force that you would need to break a bone in the hand? Do you know from the literature? If you don't, that's okay.
I could probably figure it out.
How long would it take you to figure it out? Do you know from the literature what that number is?
Not off the top of my head, no.
Is 300 to 400 pounds of force sound right from the literature that it would take to break a bone in the hand?
For a distributed load,
Yes.
such as the taillight, no.
No, not a distributed load. A load from a motor vehicle going backwards.
Right, that's a distributed load.
Right. So you're saying 300 to 400 pounds of force would not be enough to break any bone in the hand. Is that your answer?
So for a flat distributed load, like hitting the taillight, you're gonna need higher.
How about another part of the back of the vehicle?
I guess if you hit on the very corner and it wasn't a distributed impact, like if you had a more concentrated impact,
Yes.
that could increase or decrease the amount of force required.
How much would it decrease it from the number you gave?
Depends on what you're hitting, what it's made out of.
The
contact
Lexus
area.
SUV, let's assume, I'm sorry.
Can you repeat the question, please?
Absolutely. Thank you. Let's assume we're talking about this Lexus SUV,
Mhm.
right? But let me back up. You don't know where exactly, under your theory, that there was contact. You don't know, you testified to on direct. You don't know exactly where that point of contact is.
Correct.
You don't know.
Except it's on the taillight.
Well, you're saying it's on the taillight, but you didn't observe any impact yourself personally, right?
Did I see Miss Reed's Lexus?
You didn't see the impact, correct?
That is correct.
So, and there is no firsthand witness that saw, under your view, that a collision occurred. There's no witness to say where the arm was, correct?
There's no person that saw it.
Right. And you have chosen a point of contact, okay? You chose that for your analysis, correct?
Correct.
And you picked that location, but it's also possible that under your theory that a collision occurred, that that arm could have been impacted any part of the back of the vehicle. That's possible, isn't it?
That's not probable, no.
I'm asking, is it possible?
Anything is possible. I don't deal in possibilities, I deal in probabilities. It's not probable.
So, but you don't know exactly where the point of impact was. correct?
So within the range of the light and the exact angle of the hand, no, I don't. What I do know is at the rear tail light area.
So your assumption is that it had, that because there's a tail light that is altered, it must have been by Mr. O'Keefe's arm. That's your conclusion, correct?
My conclusion is there are tail light fragments, a broken glass, lacerations to his arm, and his DNA on the back of the vehicle in the area of the taillight.
Sir, and Your Honor, I'm going to move to strike the DNA part of that answer for obvious reasons.
I'm not going to strike it.
Okay, so you're making assumptions. You're taking what you view to be certain data, and you're coming to a conclusion, but that is based upon circumstantial information, correct? Is that fair?
Are you calling like pieces of the taillight at the scene around his body circumstantial information?
Sir, let me go to the force and go back to the force analysis. Let's go back to the numbers. I want to stay on, if we can, just the calculation. So let's go back to the minimum amount of force you understand from the literature that it takes to break any bone in the arm from the finger up. Let's start with a hand. What's the minimum amount of force that can be applied to break a bone in the hand?
So it depends on the loading. So I don't actually know. In terms of the forearm, I can tell you there's data that shows up to 300 Gs of loading, you will not get fractures. There's one up to 750 Gs showing no fractures for a male of similar height and weight of Mr. O'Keefe.
Thank you.
You're welcome.
So let's take those numbers,
Okay.
okay? You said 300 and 750. Did I hear it correctly?
You did?
Okay, that's the numbers you gave that would break a bone, correct?
So the 300 actually didn't break any bones, I believe. The 750, the one example, didn't break a bone, but as you got above 350, you started to break bones.
So
300.
you got above 350,
300.
above 300, yeah, because that's what I thought you said the first time. You got above 300, you start to get breaking bones, correct?
Correct.
And so if you take that 300 number and compare it to the 2,188 pounds of force, you have 7 times the amount of force necessary to break the bone, correct, in the force analysis?
No. If you take 300 Gs times a 12-pound arm, you get 3,600 pounds. The calculation you asked me to run earlier gave you 2,188 pounds.
Right.
So you are 1,412 pounds above the force required. Like the tolerance is 1,412 pounds above the force you would say get in a 20-mile-an-hour impact in terms of the fracture forces.
Let's do it this way.
I'm sorry?
Let's do it this way.
Okay.
The force that you calculated from my hypothetical of this Lexus SUV going backwards, you came up with the F number of 2,188, correct?
I'm sorry, I didn't, what was you said?
2,180.
You said dyslexic? Or do you say Lexus? I didn't understand what you said.
The Lexus
My apologies.
SUV that you've been talking about.
Gotcha.
Okay?
I didn't hear it.
You came up with a number for F for force of 2,188. Are you changing that number?
Nope.
Okay, so let's go with your number of force from this vehicle of 2,188. I'm just simply asking, how much force does it take to break a bone in the right arm of a human being? How much force, not acceleration, how much force does it take to break a bone in the right arm?
Sure. So somewhere between 2,500, the one cadaver tested the distributed load of someone of similar size and weight, and actually close in age to Mr. O'Keefe, showed
Now you said all those words.
about 7,000 pounds of force to break it.
Let's go to the hand. Do you disagree that the literature shows it only takes 300 to 400 pounds of force to break a bone in the hand? Do you disagree with that?
Your question's too general. I can't answer your question. It depends on the loading. If I take my pencil, which has a very fine point, and jam it through my hand, I can jam it right through my hand because it's a very small point. But if I distribute the load and a broader load, such as hitting a taillight, it takes much more force because the load's distributed across it. It's like if I sit on the corner of my bed. I might sink in this far when I sit on the corner of my bed, but what happens when I spread my load out, when I lay on my bed like this? I don't sink in as far. Has my weight changed? And weight is basically force. No, but I've distributed it over a larger area. So for a given force, you get less sinking into the mattress. So if you hit a broad surface like a taillight or a wall like this, it takes much more force than if I were to take a singular small round object and jam it into the hand. That hurts. This does not.
Okay, if you can hear my question, if it's unclear, you tell me. For not a pen, not your bed, but for a Lexus SUV of 6,000 pounds, is there any part of the back of the Lexus in any manner where you can get a break to the hand from 300 to 400 pounds of force?
Any part on the back of the Lexus?
Yes.
Probably.
Okay. So probably, your words, you can get a break to the hand from just between 300 to 400 pounds of force. That's what you just said, correct?
So you're taking the totality of the back of it, like if you got it stuck in the bumper?
VANDERTIE.
How are you employed, sir?
I'm currently employed as a detective for the Milwaukee County Sheriff's Office, having been so employed for just under 10 years, with 3.5 years as a detective.
And were you in your role as a detective then back in early April of 2024?
Yes, I was.
Were you involved in an investigation regarding a leg that was found at Warnemont Park on April 2nd, 2024?
Yes.
The day after the leg was found, Wednesday, April 3rd, 2024, were you contacted by someone from the Milwaukee Police Department?
Yes, I was. That was Police Officer Nora Burlow.
what was the general subject matter about her contact to you?
Sure. Police Officer Burlow explained to me that she was conducting a citizen check or a welfare check of a 20-year-old black female who had been last seen on April 1st, 2024, prior to going on a date, an apparent date. And then on April 2nd, her vehicle was found burned under suspicious circumstances, or the vehicle that she had been known to drive was found burned under suspicious circumstances.
Did she identify the person to you that she was concerned about?
Yes.
Okay. Who was that?
Actually, that was brought up later during a briefing with the Milwaukee County Sheriff's Office, our Investigative Services Bureau.
Understood. Who was that missing person that the welfare check was regarding?
Sade Robinson.
Her date of birth?
I don't have the exact date of birth, but she was 19 years old at the time.
Okay. May 10, 2004. Does that sound right?
Was in May of 2004.
So Officer Burlow said 20-year-old, but you now know that Sade was 19 at the time. Is that
correct? Based upon records that I've reviewed.
All right. Thank you. Did you also, upon communicating with the Milwaukee Police Department, as well as during briefings, learn that Sade's phone was not working in some capacity?
Yes, individuals had attempted to contact her without success. The phone had been going to voicemail.
Were you provided with a phone number for Sade Robinson?
Yes, Detective Joanne Donner had conducted some investigation and identified a possible phone number for her.
That possible phone number was 414-510-4769. Is that correct?
That is correct.
On April 3rd, when you became involved in this investigation after you were contacted by the Milwaukee Police Department and briefed, did you follow up in any way regarding Sade Robinson's phone?
I did.
What did you do?
Initially, I identified that telephone number, 414-510-4769, was attributed to Verizon Wireless. I queried a couple databases that I've used in the past for doing that. Once I identified that phone number was Verizon Wireless, I initiated an exigency request to Verizon Wireless for cellular records around the time. The purpose of that was to attempt to identify possible locations where this missing person may have been, where this missing person went, and who this missing person may have contacted or been in contact with.
So this exigency request that you're making, that essentially means you're asking for those records from the phone company without a warrant. Is that right?
Correct.
And why did you opt for an exigency request here?
Initially, based upon the circumstances, there was a missing individual whose vehicle had been located burned under suspicious circumstances, in addition to a leg being found in the park. At that time, we didn't necessarily know who that leg belonged to, nor would we know exactly who that leg belonged to for a period of time. Individuals had attempted to contact this missing person numerous times without success. That was not regular, or that was not in her, I guess, nature to not answer her phone. And so that was initiated.
Okay. Sometime in the weeks after April 3rd, did you follow up with Verizon Wireless with a warrant to get certified records from that phone company regarding Sade Robinson's phone number?
Yes, I did.
I'm going to show you Exhibit 282. It's a disc and it's clipped to a piece of paper. Do you know what that is?
Yes, this disc contains the records from Verizon, including the certification attached concerning telephone number 414-510-4769. This is the number that was listed before.
And you made that disc, correct?
Yes, I did.
So you served a warrant on Verizon. They responded by sending you the certified phone records, and that's what's on that disc.
Correct.
they sent it to you electronically, fair?
Correct.
Okay. And that certification, that piece of paper is also on the disc itself, correct?
Yes, it is.
I would move 282 into evidence, Judge.
It's just one it's just one exhibit for both of them?
One exhibit for
Got it.
both of them, I can staple together.
That's okay. Any objection?
No.
Received.
So Detective, you had said one of the reasons for this exigency request for those records was to see if you could figure out locations where her phone might have been. Is that fair to say?
Yes.
Did you in fact get that information in some form through that exigency request as well as through these certified records?
Yes.
I'm going to put 282 in here. Just give me 1 minute. Remind me again, what was the reason why you were worried about these locations? What did you think that was going to help you and your colleagues do?
So ultimately, we were trying to locate the missing person, Sade Robinson. I know that in today's day and age, most people have cell phones, right? And a lot of times people have cell phones with them. I know that cellular companies provide law enforcement with information relating to the cell sites and the cell site usage for those cellular accounts. And that would help us narrow down potentially where she was, where she had been, additional locations for us to follow up with video, witness interviews, etc.
Possibly even helping you find the phone itself, correct?
Yes.
All right. I'm going to put up on the screen, this is on Exhibit 282, an Excel spreadsheet. The beginning of the title, I'm not going to read the whole thing. The title begins with subscriber_MTN. There are a number of things on this disk, correct, Detective?
Correct.
And in fact, if I pull up the file log here, we're looking at all of the records that they gave you, correct?
Correct.
Okay. There are numerous Excel spreadsheets. This subscriber_MTN, this would have been the subscriber information for that phone number that you got from Verizon Wireless, correct?
Yes.
What does it say about who the subscriber to that phone number is and where they live?
The first name listed is Sade, last name Robinson, under address line 1858 North Commerce Street, apartment 309, and city, Milwaukee, state, Wisconsin.
Okay. In these records, as well as the exigency records that you received, did you also get from Verizon Wireless text message content?
Yes, I'm aware that Verizon Wireless maintains SMS, short message service, or text message content for approximately 5 days.
And when you reviewed the exigency records, did you locate text messages from April 1st, 2024 in those records?
Yes, I did.
Were there outgoing texts from Sade's phone on April 1st?
Yes.
I'm going to pull up a different document on Exhibit 282. The beginning title of the Excel spreadsheet is SMS content. SMS stands for what again?
Short message service.
All right. And a lot of these records that we're looking at appear like this. Is that fair to say?
Yes, they do.
All right. This, if you just take a glance, looks like gibberish in a spreadsheet, right?
Lots of numbers and letters on a spreadsheet. Yes.
All right. But if we look closely here, column A that I'm looking at over on the left side of the screen here, that shows what? You can get up if you can.
Okay.
Judge, may the witness get up?
Of course, feel free.
Column A, is the header of column A is titled message arrival.
All right. And then if we go across, we get all the way over here where it says originating MDM and terminating NDN. That would be columns I and K, correct?
Correct.
What are those?
Originating MDN would be the sending telephone number in the conversation, and the terminating MDN would be the receiving telephone number in the conversation.
All right. If we go over to column L, what is that?
It's titled message content.
And is this where you're going to see the actual substance of the text messages that were sent?
Yes.
All right. Did you locate a text conversation that appeared to be the last text conversation that Sade Robinson was actively engaging with another number?
Yes, the parent text conversation in the 4 p.m. And early 5 p.m. hour on April 1st, 2024, between her number, 414-510-4769, and the other number, the 262-416-4874 telephone number.
Okay. That 262-416-4874 number, did you also follow up and request exigency records or any kind of records related to that phone number?
I personally did not. Special Agent George Reiner through the FBI did request exigency.
Okay. Did you then later after that request records from that phone number?
Yes.
Through a warrant?
Through a search warrant.
And you received certified records?
I did.
Okay. I'm going to go direct your attention right about here. You see the message I've highlighted there?
Yes.
Okay. This message, if you go over to what time it was sent, what are we looking at?
The timestamp here is 4/1, April 1st, 2024, 17:15. 17:15 is military time for 5:15. However, I know that Verizon records for these SMS content messages are stored in Eastern time or provided in Eastern time. So we, being in Central time, would subtract 1 hour from that time to make it our local time.
All right. So that would mean this message was sent at what time?
It would be at 4:15.
And the content of the message over here in column L, or excuse me, column M is what?
States, where are we meeting?
And who sent that message to who?
That message was sent from the 414-510-4769 number to 262-416-4874.
All right. And why don't you, starting with that message, go down and tell the jury what the exchange is between those numbers moving forward in time from that text message.
So after the first text message, where are we meeting? The reply from, or actually the next message is again from 414-510-4769 stating I can do 5.
So that those two both came from Sade's phone.
Correct.
Okay. The response from the 262 number is what?
Response is downtown somewhere, question mark.
Okay. How does Sade respond?
Okay.
How does the 262 number respond to that?
House on 3rd, question mark.
How does Sade respond?
Perfect.
And that message, the perfect message, was sent at what time?
Local time, 4:28 p.m.
Back over to column M. The 262 number sends 2 consecutive messages to Sade reading what?
Okay, I'm going to shower quick. I'll probably get there more around 5:15. And then, are you hungry? Question mark. I need to stop at Twisted Fisherman to pick up my W-2 from last year, and he could eat there first.
How does Sade respond to those two texts?
Okay, and yes.
Then,
Then, are we eating at the Brock House or the other place?
and how does the 262 message number respond to Sade's question?
Let's eat at Twisted, I'm feeling seafood.
How does Sade respond to that?
Yes, I love seafood.
What does the 262 number say next?
Sounds good, I'm about to leave, I'll be there soon.
Okay. I don't know what happened there, but the TV went out and then came back and then went out again. All right, we're back. After the 262 number says, sounds good, I'm about to leave and I'll be there soon. Actually, before I ask my next question, that message is sent at what time?
4:54 p.m.
And then there's this odd looking response after that. Do you know what that's about?
I don't know the exact content of the message, based upon the various symbols and characters. I believe it to be some sort of emoji or other characters that can't be necessarily translated into the SMS content system.
On an Excel spreadsheet. Okay. After that, there is a text from the 262 number Sade that says what?
Just got to Twisted.
And that text message was sent at what time?
5:11 p.m. Central Time.
On April 1st.
Correct.
Subsequent to that, Sade responds with what?
Okay, are you inside? Question mark.
And the 262 number responds what?
Yes.
All right. And then after that, as we go down, are there any other outgoing text messages, SMS messages from Sade's phone?
Can you grab the microphone and pull it closer to you? I guess there's some difficulty in hearing you. Thank you.
Can you please repeat the question?
Sure. The question I have for you is after Sade asks the question, okay, are you inside? And then receives the answer of yes. Does she engage in any other outgoing messages after that?
I do not believe she engages with any other individuals, no.
Okay, and so I want to direct your attention to line 451. There seems to be an outgoing, some kind of message from Sade at that time, correct?
Correct.
And it looks like it is gibberish in response to a text message from True Religion. Is that right?
Yes, it appears to be a targeted advertisement or an advertisement sent to her device, and it appears that an automated message was sent from her device back to the telephone number that sent the advertisement.
Other than that one, are there any other messages that you saw in the records, both the exigency records and these records, that showed Sade texting, sending outgoing text messages to other people?
No.
So the last conversation in the records is Sade's conversations with that 262 number you had mentioned before.
Yes.
That okay, are you inside text that Sade sent was sent at what time?
Local time was 5:18 p.m.
And it appeared to you that was the last outgoing text she sent, correct?
Yes.
You can have a seat, Detective.
Thank you.
Thank you. So at this point, that information about the text messages, you originally had it through the exigency records, although we just looked at it from certified records, right?
Correct.
So it appeared to you that the last person Sade was texting was that 262 number, correct?
Yes.
Did you subsequently look up in any kind of databases to see if you had that number listed to any person?
Yes.
And did you find a number that your records suggested that phone might belong to?
Yes.
And what was the name of that person?
Maxwell Anderson.
Are you aware of whether or not your department arrested Maxwell Anderson on April 4th of 2024?
Yes.
Have you reviewed the photograph from that arrest?
It's actually April of, yes.
Okay.
Yes. Can you repeat the date?
Sure.
Please.
Let me put it this way. After you went through these records and you
Yes.
linked up that phone number to the name Maxwell Anderson, did your department arrest Maxwell?
Yes.
Have you reviewed the booking photo from that arrest?
Yes.
I'm going to show you exhibit 445. Is that the photo you saw?
Yes, it is.
I would move 445 into evidence as published.
Any objection?
No.
It's received. You may publish.
You see that person in court today?
Yes, I do.
Could you identify where that person is for the record by indicating where they're seated and what they might be wearing?
That individual is seated at the defense table, wearing a blue, appears to be flannel, blue and black checkered flannel shirt.
I'd ask the record to reflect that the witness identified the defendant.
Any objection?
No.
Record will so reflect.
You subsequently got not only exigency records, but also through a warrant, certified records from that phone, correct?
Yes.
Did you do any similar practice to figure out what phone company serviced that 262 phone number?
Yes.
What was it?
AT&T.
I'm going to show you exhibit 281. What is exhibit 281 if you know?
Exhibit 281 is another disk that I produced containing files from AT&T concerning telephone number 262-416-4874. And it also includes the certification of certificate of authenticity of domestic records pursuant to Federal Rules of Evidence 902 sub 11 and 902 sub 13.
All right, so that again, like the Verizon records, it's a disk of the certified records, and the piece of paper that is the certification is also located on this.
Yes.
I would move 281 in.
Any objection?
No.
281 is received.
Thank you. Just give me 1 second, pull up the document I need. Similar to the phone records servicing Sade Robinson's phone, there's information in these records about the subscriber for that 262-416 number, correct?
Yes, there is.
Okay.
It would be the file labeled report CT.
Report CT, all right. I've got on the screen now from exhibit 281, the file titled report CT. I think, Judge, this TV is about to turn off.
We'll see if we can help.
All right, we're back. There is specific user information on this page pertaining to the number 262-416 4874, right?
Yes,
And that would be the phone number that Sade, the last phone number Sade was texting.
yes.
And who does it say is the contact name for that?
The contact name for that particular telephone number is Max Anderson.
What is Max Anderson's date of birth?
11/26/1990.
So at the time, he would have been 33?
Yes.
Okay. Did you also come to learn when you were trying to go through these various phone records and make the exigency requests for those records that Sade Robinson was known to have a Life 360 account?
Around that time, yes.
Did you ultimately serve a warrant upon Life 360 to get those certified records?
Yes.
Can you tell the jury, just generally speaking, what Life 360 is?
Life 360 is a mobile application that can be installed on cellular devices. It's primarily used for location sharing services. So if you would like to share your location with your family members or friends, at any point in time, they can essentially see where you are. You can provide them updates as to your location.
I'm going to show you Exhibit 283. Do you know what that is?
Yes, exhibit number 283 is a disc containing the records I received from Life 360 Incorporated.
Similar to the phone records we've discussed, are they certified?
Yes,
Is that what the piece of paper that's attached to the disc is?
yes, including the certification of records for these records that I received.
Just see if that microphone you're standing in front of is on, and if it's not, the one actually next to it, I was thinking, and if that one's not on, can we turn it on? Because there's a difficulty hearing you, is what I'm being advised. So I guess when you're approaching the bench where you're at, it's difficult for you to be picked up. So if you could, I guess, just position, this picks up the DAR, so it's not amplifying your voice, but if you could go near your table and put the mic to the side, maybe, that'd be great.
I'll do my best.
Thank you.
Thank you, Your Honor.
No worries. Sorry
Um,
about that. Could you re-ask your last question? I think it was relative to the certification of the last exhibit being Life 360.
Thank you. That piece of paper that's attached to the disc, that would be the certification for those records, correct?
Yes.
I'd move 283 in.
Any objection?
No.
283 is received.
And then Detective, lastly, I'm going to give you Exhibit 284. When you got the cell phone records, you got some other records from those phone companies about their cell towers, correct?
I received a cell site database for AT&T from NDCAC, which is the National Domestic NDCAC, which is the National Domestic Communications Assistance Center. That those certified cell site lists from AT&T were provided from NDCAC. The initial cell site lists from Verizon were also from NDCAC, and then a few weeks later, I received certified cell site lists directly from Verizon.
Is that what Exhibit 284 is?
Yes,
And that's, again, a disc you made based on the stuff you got from those companies?
correct, pertaining to those companies.
I'd move 284 in as well.
Any
And-
objection?
And what else? I don't think I moved 283, so I'm going to move that as well.
You already did.
You did.
283 is in.
I don't object.
284 is in as well now.
these phone records that we discussed for Max Anderson's phone, as well as Sade Robinson's phone, and then those cell site records could further be used to map out approximate locations of where those phones would have been at various times. Is that a fair statement?
Yes.
Were you able to do some version of the same thing with just the exigency records?
Yes.
Okay, so the exigency records, you got that text conversation we had talked about where they talk about going to Twisted Fisherman around 5:15, is that right?
Yes.
And then you also got some information about phone location.
Yes.
Can you describe, related to Sade's phone, what information you were able to get?
So for her device specifically, we were able to get call detail records. The exigency records included what Verizon states is RTT, or real-time tool. That is a type of engineering data, includes the cell site that was utilized, also the sector or the direction in which the antenna was facing, and also a distance from the cell site. In addition to the real-time tool data, we also received call detail records, which includes telephone calls, who made the call, or to which number the call was made, or the calling party number to Sade's telephone number, cell site that was used at that time, duration of the call, and then the text message content as well.
All right, and with that information, actually, before I ask that question, it'd be fair to say, based on that last text conversation that she had, that it appeared she was planning on meeting up with someone at Twisted Fisherman, specifically Max Anderson, correct?
Yes.
Did you then use that location information that you just described to try to figure out if that could tell you whether it appeared she actually went there?
Yes.
Where is Twisted Fisherman, first of all?
Twisted Fisherman is located at 1200 West Canal Street in the
Okay.
city and county of Milwaukee.
All right. What happened when you looked up that location information?
It appeared that her device traveled to that location, or in the general area of that location, in the late 4 p.m. hour and early 5 p.m. hour on April 1st, 2024.
And from there, in a general sense, can you tell us what information you had relative to the phone location of Sade's phone?
Yes. The device remained in that general area until approximately 6:30 p.m., at which time it traveled north and east to the general area of Dukes on Water, which is located at 158 East Juneau Avenue in the city and county of Milwaukee.
After that area of North Water Street, then what?
Around 9 p.m. or shortly after 9 p.m., the device traveled south and west from that location.
During your initial, when you were initially trying to figure out who the 262 number belonged to and learned that it may belong to Max Anderson, did you also learn of an address that was believed to be belong to Mr. Anderson?
Yes.
Was that 3161 South 39th Street?
That is correct.
That'd basically be between Oklahoma and Euclid on South 39th Street, correct?
In that area, yes.
After leaving Dukes on Water, did the phone move to, or appear to move to, a location around Mr. Anderson's?
It did.
What about after that?
So from approximately it arrived in that area about 9:20 p.m. or shortly thereafter. It remained in that area until approximately 12:45 or shortly thereafter on April 2nd, 2024.
After that?
After that time, approximately 12:45, shortly thereafter on April 2nd, 2024, Device moved north and east to the area of downtown Milwaukee.
And after that?
The device was in the area of downtown Milwaukee and north of the area of downtown Milwaukee, general area of the Milwaukee River, and Kern Park, Pleasant Valley Park as well, in the mid 1:30 a.m. hour or shortly thereafter.
Pleasant Valley Park and Kern Park, those would sort of border the Milwaukee River, is that correct?
Correct. They're adjacent to the Milwaukee River.
In the River West neighborhood?
Yes.
Okay. I'm going to pull up Exhibit 443, which has already been admitted. Just need 1 second here. All right, Detective, can you see this map?
I'll have to get up just because of the glare on the screen.
All right, and just to recap, I probably should have had this up when we were going through it first, but this area right here, West Canal Street, this is about the location of where Twisted Fisherman is, correct?
Yes.
Okay,
Can you pull that mic over if you're going to stand there? Thank you. Go ahead.
so after leaving that location, it appeared the phone had gone sort of in a northeast direction over in the area of Water Street and Juneau. Is that what you said before?
Yes.
Okay. Kind of right up in this area here where my mouse is. Do you see that?
Yes.
All right. And again, we're talking generalizations. Is that fair to say?
Correct. This is all based on cell site location information. So cell sites, direction of the antenna. Yes.
Okay. And to be clear, that information was not giving you a pinpointed location of the phone.
That is correct.
Then after that, I think you indicated it goes down to the area of Mr. Anderson's residence, 39th in Oklahoma here, correct?
Yes.
All right. And then it moved up towards downtown, and I think you said by the 1:30 hour near this area in River West, Pleasant Valley Park, correct?
Yeah, it was approximately 1:30 a.m., shortly after 1:30 a.m.
All right. Picking up from there, where does the phone appear to go from those exigency records that you were looking at?
From approximately 2 p.m. to until 2:10.
2 p.m.?
Or 2 o'clock in the morning, I should say, 2 o'clock a.m. Until 2:10 or 2:12 a.m. The device moved west.
All right.
To the area of approximately West Capitol Drive and Fond du Lac Avenue.
Okay. So
or just
this
east
street
thereof.
this street here that I'm highlighting
Yes.
with my mouse? Okay.
Yes.
And then does it double back east?
It does.
And then what?
Doubles back east, and then travels south.
Towards where?
Towards the Mitchell interchange.
Around what time?
Approximately a little bit before 2:30 or 2:30 in the morning.
All right. Then what?
It would have traveled west.
Do you want to point out what you're talking about?
So it travels south, and then it travels west to the area of I-41 or I-894 and approximately South 76th Street at that time.
And what is that time, by the way?
Approximately 2:34 a.m.
All right, then does it double back east?
Yes.
And where does it appear to go from there, if you want to point out?
The device travels east, south, and then east again.
Where?
So east in the area of I-41, I-894, south in the area of I-41, I-94, and then east in the area of College Avenue.
Okay, and that'd be just south of the airport, which I'm circling here with the mouse, correct?
Correct, in that general area.
And what time does it, and what does it do next and at what time?
After traveling east, it traveled to the area of Warnemont Park, or Sheridan Park and Lake Michigan.
All right, and if I zoom in
Shortly
on,
after, arrived in that area shortly after 2:50 a.m.
shortly after 2:50 a.m., the phone appears to be around the area of Warnemont Park here, correct?
Yes.
And does it continue moving or does it appear to stop for a period of time or be in one location for a period of time?
For a period of time from 2:50 in the morning, yes. It
All right.
was in a particular area, not moving substantially.
Not moving substantially, okay. Until when?
Approximately 4:30 in the morning on April 2nd, 2024.
So it appears to be in an area consistent with being at Warnemont Park from about 2:50 to approximately 4:30.
Yes.
And then what happens?
The device traveled north and west a short distance.
Point out what you're talking about?
Sure. To the area of State Highway 794 and East Howard Avenue. Which would be in this area. There's a cell site in that particular area. The last records were just before 2:40 a.m. on April 2nd, 2024, using a cell site in that location.
You said
At that
2:40 is the last record?
4:40, I should say.
Okay.
Sorry.
Just to recap, when it's in this area that's on the screen now, arrives what appears to be consistent with the area of Warnemont Park around 2:50, remains stationary for until about 4:30, and then moves slightly north and slightly west.
Correct.
And then do the records stop?
Correct.
Just to be very, very clear about this, what you're just describing, number one, you're not saying that it's telling you the exact pinpoint location of the phone, correct?
Correct.
And this is just a general summary of the locations, fair?
Correct.
What was the purpose at the time for, what were you going to do with this information at the time that you were getting these records initially as exigency records?
So these were, again, locations that investigators could look for follow-up pieces of information, attempting to locate Sade and attempting to locate additional video, evidence or interview individuals who may have been in those particular areas at those times.
Okay. When you were analyzing these records, where you said you had mentioned an FBI special agent before, correct?
Yes.
Who was that person?
George Reinerth.
It's Reinerth for the record. Did he sort of work with you to get the locations we just discussed?
Yes, we worked together on that.
And did you subsequently yourself, working with Special Agent Reinerth, more formally map out those locations?
Yes.
And did you turn those records over to him for him to map out as well?
Yes, I provided the records that I received from Verizon and AT&T and also Life 360 to Special Agent Reinerth.
think this kind of goes without saying, but those locations, you passed that information along to Detective Donner as well as other investigators to conduct follow-up in those areas, correct?
Yes, Detective Donner, other investigators from the Milwaukee County Sheriff's Office and other investigators from the Milwaukee Police Department.
I have no other questions. Thank you.
Cross?
Thank you. Good afternoon, Detective.
Good afternoon.
Okay, so I just want to start with just backing up why you requested these cell tower records. So you requested cell tower records because typically people have their phone on them, right?
Correct.
And when you have your phone on you, it's constantly tracking your movements via these satellite towers.
The phone is attempting to connect to the tower with the best signal, yes, if it were to need to make a phone call or a data connection.
Okay, and you can use that location information for every time the phone's connecting to that tower to kind of track the path of someone's movement, right?
Correct.
And so if you're trying to pinpoint where someone was at a specific time or a general area, you can read these records and determine where in the general area they would be.
You can determine the cell site that was used, the direction from which the antenna is facing, and then also possibly a distance from the actual antenna that was used.
But it's not real precise because you can't pinpoint exactly where someone is.
Correct.
You can't pinpoint how long they're in that specific area because it's a range, right?
Can you ask the question or rephrase the question?
Based on the cell tower data, are you able to tell where someone is for a certain duration of time?
In relation to the other records, we can get an approximation, a time frame.
Okay, but it's an approximation, it's not precise.
We know when the records were generated, but we'd have to consider it in relation to other records.
Okay. And you might be able to tell a general area where someone is, but you don't know, the records can't tell you why the person is in the specific area, correct?
Correct.
And it can't tell you what that person is doing in that location, correct?
Correct.
And it can't tell you who that person is with, if they're with anyone.
Correct, unless you have other information that goes along with that.
Okay. And so the state showed us this, I guess, spreadsheet that had all these numbers. I think they described it as gibberish, right?
Correct.
Do you manually look at that, or do you ever put that into a system to kind of make it easier to read?
There's software that we use to make it easier to read. It can be mapped manually, but use software.
And so you got all these records before Mr. Anderson was ever arrested, right?
Correct.
And so
the exigency records.
Okay. And so you review these records and you look at what past, conversations Ms. Robinson's phone had with other people, right?
For a period of time, yes.
And I guess we looked at some of the, you read through some of these text messages that Sade's phone has with Max's phone, and they start this conversation, you said, at 4:15 p.m. on April 1st, right?
I would have to look at the exact timestamp, but yes, that sounds correct.
Okay, and they're texting back and forth. Where are we meeting? And Sade says I can do 5, right?
Correct.
And they talk about where they might want to meet. Broad House on 3rd, and they ultimately decide to meet at Twisted Fisherman, correct?
Correct.
And in the outgoing message from Max's phone, it says, I need to stop at Twisted Fisherman to pick up my W-2 from last year, right?
Yes.
And you know what a W-2 is, right? It's a work document.
Yes. It's a tax-related work document.
So one can conclude that Max most likely worked at some point, right?
Yes.
And he wanted to bring Sade there, a place that he's known at because he worked there, right?
Yes.
It wasn't some obscure location where, you know, Max didn't have any contact with, right?
I didn't know any previous contacts, but based upon the context of the text message content.
What cameras are we going to be looking at from the Cudahy Water Department?
There is one camera that is on the water department building that faces, or that is on the south side of the building, and it faces southeast.
Does it show Pulaski Avenue here?
It does.
All right, continue.
It also captures into the distance of Warnemont Park. That's the only camera recovered from the actual water department building.
There's another camera that you recovered video from here, correct?
Yes.
Are there actually multiple cameras from that pump house?
There are two cameras.
What directions do they face?
One is on the north side of that pump house, and it faces north, capturing a sidewalk, a gravel parking area, and the tree line that heads down to the beach.
What does the camera that faces south depict?
The camera that faces south, southeast, it depicts Lake Michigan and the sidewalk.
All right. The videos we're going to watch today, are we going to watch any of the videos that face south?
No.
Why is that? Did you find anything on them?
There was nothing of evidentiary value, just the lake.
The Cudahy Police Department that I'm pointing to right here, where are the cameras that we're going to watch from there?
There are two cameras. One is on the east side of the Cudahy Police Department, and it faces east, and it captures the large open field area, as also with Pulaski Avenue, and approximately where the gate would be for the pump house access road.
What's the quality of that video?
Very poor.
Okay, grainy?
Very grainy.
Nevertheless, you can see lights though, correct?
Yes.
All these videos we're discussing are from the middle of the night, fair?
Yes, they are.
Then, is there another camera from the police department that we're gonna watch?
Yes, we'll have one other video that was recovered. That camera is positioned on the west side of the building, and it faces southwest, capturing Lake Drive.
And then the high school, what does the high school show?
The high school also had two cameras. One is facing on the south side of the building, and it faces south. And it captures a very wide frame of Pulaski Avenue, the entrance to Warnemont Park, and the pump house access road.
All right, I'm gonna start with Exhibit 27, which is the Cudahy Police Department video. Judge, I would ask if jurors wanted to stand up at this time, would the court allow that?
We can pull this TV closer to the jurors, I think. And that might help. That one has to stay at the edge of this table, so I can't bring it that much more forward.
Are you able to see this?
I can always move my position, sir.
And I guess if anybody at the backside wants to come closer to this one, you could. Or if you can see, okay.
All right. This is the Cudahy Police Department video. On the bottom, it looks like there's a date and a timestamp, correct?
That's correct.
And what can you tell us generally about the accuracy of that date and timestamp?
On the camera that's facing east, it's probably about a minute and 20 seconds fast than the actual confirmed timestamps that we were able to get.
All right. So right now I have the video queued up. The title of the video begins 2 CUPD East. We are looking towards Lake Michigan, is that correct?
That's correct.
And where are we going to be wanting to look when this video plays, and what are we going to be seeing? If you could describe that for the jury.
At the top of the video feed, you're going to see a white shed.
Okay.
In the area of that white shed, you will see a pair of headlights or taillights from the vehicle that you'll be able to see traveling east on what is Pulaski Avenue.
All right. And by going east, it's going away from this camera, correct?
That's correct.
Not across the screen where my mouse is doing right now, right?
Correct. That would be Sheridan.
And where you see those lights, you've obviously been here yourself, fair?
Yes.
Where does it appear that those lights are heading towards?
To the Pump House Access Road. Pulaski Avenue ends at Sheridan, and then it turns into a gated access to the Pump House Access Road.
So Pulaski Avenue then would be to the right of this camera.
Correct.
All right, I'm going to play this 48-second clip. And when you see it, detective, please point out what you were talking about.
Right there.
All right, I've paused it at 33 seconds. It's this set of lights I'm circling here.
Yes, sir.
I'm going to play it from 33. And the lights have disappeared, correct?
That's correct.
All right, so by 2:54:17 a.m. on the camera, the lights are gone.
That's correct.
And would that be consistent with the vehicle arriving at that gate around that time?
That's correct.
The next clip I'm going to play is titled 6 Space CUPD. We're looking at the same camera now, correct?
That's correct.
But a different time.
Correct.
What time are we looking at?
4:32 a.m.
I'm going to play this clip. It's 39 seconds. What are we going to see?
From the last location that we saw the lights earlier on the previous video, you will see those LED headlights again, and they will appear to be traveling in the opposing direction, heading west on Pulaski Avenue.
Away from the lake?
Correct.
Okay. Tell us when you see them.
Right there.
All right, so about 4:32:24.
That's correct.
Playing, I paused it at 17 seconds. I'm playing it from there. And by 4:32:38-ish, they're off camera, correct?
That's correct.
Last clip, it's titled 8 CUPD, different camera. Tell us what we're looking at.
This is the camera that's on the west side of the Cudahy Police Department. It is facing southwest, and you see Lake Drive is the road directly to the west of that parking lot.
So Lake Drive would be this road here,
That's correct.
and to get to Pulaski Avenue, which would get you into Warmont Park, if you were here, you would essentially go down this street and you would turn left up here, correct?
Correct.
Okay. What are we going to be looking for and see on this one?
The subjects or the vehicle that was captured on Pulaski Avenue. We'll not be able to see it traveling on Pulaski Avenue, but on the houses on the left side of the video frame, you're going to see those houses lighted by headlights that would be coming towards them. You'll then see a vehicle that will enter the camera frame traveling north.
Away from Pulaski Avenue.
Correct.
Playing clip 8. 8 CUPD. It's 55 seconds. tell us when we see what you just described, please.
And there's the start of the headlights.
All right, I'm going to pause it at 36 and back up 10 seconds to 26. Play it again. Right there?
Yes.
And now you see the headlights of a vehicle heading northbound?
That's correct.
Okay. Paused at 44 seconds. What general description can you get of the vehicle from that?
That vehicle appears to be a smaller sedan with kind of like C taillights, because you are able to see the end of the taillights and that camera frame.
Okay. Pretty blurry, but small sedan style vehicle.
Correct.
All right. Dark colored?
Yes, sir.
And what did you say about the timestamp here related to the other timestamp? So right now it's just gone off frame at 4:34:56 a.m.
This camera that faces west appeared to be about 40 seconds fast, a little bit different from the camera on the east.
Okay. Exhibit 12 is going to come up next. This is the Cudahy High School video. About to see somewhat of a similar camera frame, but depicting similar areas, correct?
That's correct.
Okay. Going to start with the video labeled 450-student parking lot. And just take a minute to load quick. Was there, and while that's loading, let me ask you, Detective, was there a specific reason why you were looking for video footage from these locations from that specific time frame of 2:50 a.m. to about 4:40 a.m.?
We had received records from Life 360 that depicted that the victim's phone had been in the area between 2:50 a.m. and 4:30 a.m.
So you zoned in on that time frame because that was the information you had about when Sade's phone appeared to have been in the area of Warnemont Park, correct?
That's correct.
And it obviously goes without saying you had known already that a leg had been found there on April 2nd.
Yes.
When was it that you were going to collect these videos then? Would it have been that day?
I would have started on April 3rd.
All right. I have the student parking lot video queued up here. This one is sort of difficult to see, but what are we going to want to be looking at? If you could orient the jury, please.
On the upper left-hand side of the video, you'll see again a white shed. That is the same shed I pointed out in the Cudahy Police Department video. And
the thing I'm circling here?
Yes, it is.
Okay.
To the right is a building is going to be on the right side. That is the Cudahy Police Department where we had the other video from.
Okay.
What we're going to see is going to be on the upper left side of the video. And you'll see headlights again traveling on Pulaski east away from the camera towards the pump house access road.
Okay, and this is obviously in a different video player. Your date and timestamp for this video is down here in the lower left-hand corner, correct?
Correct.
And the road you're talking about, this would be that white shed. The road is right about over. Fair?
That's correct.
Is this where we're general area where we're gonna see the lights from that same vehicle from the other video?
Yes, sir.
All right. I'm gonna cue it up. What can you tell us about the date and timestamp being accurate for this?
The Cudahy High School is one of the first places that I had access to recover video footage. While I was in the school resource officer's office, I reviewed the timestamps and confirmed that they were correct to the second.
Based on checking your time?
Yes.
Okay. I'm gonna play this video from 2:52 a.m. to 2:53 a.m. And Detective, if you could, if Your Honor will allow the witness to stand up and point out what he's talking about, as it is kind of small on the top of the screen.
That's fine, just pull that microphone as far over as you can.
Can you bring the mic with you if possible?
Ooh, I apologize for that.
All right, playing at 2:52:02 a.m.
Right here. Right where I just pointed was a vehicle traveling east on Pulaski.
All right, where my mouse is circling here?
That's correct, and it's pulling up to a four-way stop sign at the intersection of Sheridan.
So it can either go left to go north on Sheridan, right to go south towards the golf course, or straight to the gate of the Pump House Road, correct?
That's correct.
And what does it do?
It goes straight and towards the Pump House access road.
And you know that because you can't see its lights going to the left or right, fair?
That's correct.
Pausing it at 2:52:58 a.m. Now, this video has a scroll bar at the bottom, and I can move it, and the video will play with it, correct?
That's correct.
Have you gone through this to see if there's any other any other vehicles that go that same direction down towards that service road in between the times of 2:52 a.m. and 4:30 a.m.?
I did.
Are there any other vehicles that travel that route
No, they're not.
or come out of there?
I observed nothing of note when reviewing the video footage in between the timeframes.
All right, and I'm scrolling ahead on the bottom here, and I'm gonna go all the way up until 4:34 a.m. Or as close as I can get. All right, I'm gonna play it from 4:33:37 a.m. What are we gonna see?
You'll see a pair of headlights that will come out of where the Pump House access road is, which is the last place we saw the vehicle traveling.
Please point out when you see it. Oh, I'm sorry, I have the wrong time. I'm going back to 4:30:50. Or I'm gonna start it from 4:30:43. Do you see it?
Yes.
Point to it, please. Okay. Very faint.
Very faint, but in the upper left-hand corner of the video.
Where does it appear the vehicle immediately goes to?
The vehicle is going to make a left turn onto Sheridan and enter Warnemont Park.
Towards the golf course?
Correct.
And is that a through road down there?
No, it's not. It dead ends at the golf course at a parking lot.
Okay. And why don't you describe what we're looking at as it's happening, as the video continues to play forward here. It's now at 4:31:46.
You can see lights inside of Warnemont Park, and the vehicle has entered into the area and now has turned around at the dead end and is heading back north on Sheridan towards Pulaski.
Is that it, right where my mouse is here?
The vehicle is now approaching the four-way stop sign at Pulaski and is going to make a left turn and head west on Pulaski towards Lake Drive.
Okay. So it's kind of coming towards the camera, fair?
Yes,
And now it's turning westbound on Pulaski.
that's correct.
All right. And it's heading west and it's going to go behind that white shed at this point, correct?
Correct.
All right. Pause it at 4:33 a.m. I'm going to now bring up the video on this disc titled 400 Main Entrance. And while that's loading, Detective, essentially what you observed there was a vehicle entering the service road around somewhere in the 2:52 to 2:53 a.m. hour, correct?
That's correct.
That vehicle, you never see a vehicle go in or out in the meantime up until about 4:50 a.m.
That's correct.
And when the vehicle leaves it, it goes down the dead end road and then appears to have doubled back, go back to Pulaski, and then leave the part to the west.
That's correct.
That's what we just watched.
Yes, sir.
All right. Would that have been consistent with what was on that Cudahy police video as well?
Yes, sir.
That camera's a little clearer though.
Much clearer.
I have on the screen now the video from the main entrance to the school, right?
That's correct.
Okay, just very briefly, let me go back to the map here. So those videos we watched from the police department, the other high school camera, we got the car going down Pulaski, following where my pen is going, around 2:52. It then goes into Warnemont here, or excuse me, into the service road here, right?
That's correct.
Comes out at 4:30, a little after 4:30, goes south off of this map, comes back north, and then heads out onto Pulaski, ultimately turning north onto what would be Lake Drive.
That's correct.
The camera we're about to watch is right where my pen is at here, correct?
Yes, sir.
Essentially, what are we about to see?
You're about to see the vehicle traveling north on Lake Drive.
I'm going to play this video at 4:34 a.m. $4:33:56. Where should we be looking, by the way? Can you point to it?
Yes.
All right, you're pointing to the upper right portion,
Yes, sir.
and the vehicle is going to kind of follow where my mouse is going, correct?
Yes, that is Lake Drive. And the headlights are now entering.
Okay. And you're able to see, if I pause it at 4:34:29, it appears to be sort of a dark sedan style vehicle, correct?
That's correct.
All right. Off the screen by 4:34:31, right?
That's correct.
All right, I'm gonna put in Exhibit 11 now. This is gonna be the pump house video. This might take some time, Judge, just so the court's aware.
Does the jury need a break to stretch your legs for a few minutes? Let's do that. Let's take a 5-10 minute break. Give him a moment to set this up. Just leave your notebooks on your chair, please.
CB, she's number 4. She's victim number 4. Victim number
Are the next videos brighter?
victim number 2, I think, was Mia. Not Mia, Gina. Excuse me.
Or a broad flat surface? No.
Not asking about a tail light. Any part of the back of an SUV, you agree that it is probable that you can get a break of the hand bones from just 300 to 400 pounds of force.
Your question is incomplete, right? You said any part of the back, but then you wanted me to not include taillights or not include the rear body panel. If you hit a very narrow part of the car, like say the edge of the tailpipe, that creates much more of a narrow contact. So force divided by area is pressure. So if you have a very tiny area, you have very high contact pressures. And so, but if you distribute the load over a larger area, the number on the bottom of that fraction is much bigger. So your contact pressure drops. So hitting the edge of the exhaust pipe is going to have a much higher likelihood of causing a fracture than hitting flat against the tail light.
Okay, what we're going to do to make this more efficient, sorry. Mr. Wolf, can you pull up a slide from Mr. Wolf's or Dr. Welcher's presentation for the back of the Lexus, please? The back hatch, and Your Honor, may we publish that?
Sure. Do you know what number though, Mr. Lewis?
Mr. Wolf does, and
And
I
then
know
he'll
you
tell
need it, so
us.
he'll tell me before I publish, and then we'll give you the number.
Your Honor, may I look here?
Yes, I'm going to let Dr. Welcher look at his slide
Oh, sure.
here
Yeah.
instead of just up there.
The back hatch, yes. Do you have one of just the rear gate? The one measuring the height, maybe? There we go. Thank you. Okay, this is your slide presentation. Is there any part of the back of the Lexus SUV that has that more concentrated area where if the hand hit it, 300 to 400 pounds of force could break it? Is there any part, for example, the edge of the license plates, above the license plates, the L symbol that sticks out that would be concentrated? Anything you see there could 300 to 400 pounds of force contacting at any of those points cause a fracture of any of the bones of the hand?
So, I don't know how to show this because in the middle photograph, right where the 2 is on the license plate,
yes,
there's a vertical edge. That area is recessed in. So if you hit right on that vertical edge, that could potentially do it.
That could do it. How about the L of for the Lexus symbol if the hand is there?
No, it's not deep enough. The compliance of the hand is just going to sink into the car.
Is there any other part other than the license plate that the force applied, you would only need 300 to 400 pounds of force to break the hand?
Maybe the exhaust pipe, and potentially if you hand your hand up near the spoiler.
Right. So now let's go from 300 to 400. Let's go to the 2188, which is your number. Use 2188. Is there any place where in 2188 force you could have a fracture of the hand on that back gate?
Just to be clear, 2188 is a number I calculated for you. It's not, quote, my number.
I understand, but we did. I understand, but we did the calculation. Is there anywhere on the back of the vehicle where 2188 could cause a fracture of the hand?
So that was a forearm fracture tolerance I thought we were talking about, because we used the weight of the whole arm for that.
We did. And my question is there anywhere in the back of the vehicle, in your opinion, that could cause a fracture with that?
I'm sorry, what, to the hand? Just the hand or the whole arm?
I'll take any part of the right arm. You call it the hand, the forearm. Is there any part that could cause a fracture?
So probably similarly, if you got your forearm down near that transition, like I don't know if you see the little dot. I'm talking about this area.
Yes.
Right here.
Yep.
So that transition between the two body panels.
Yes.
That could potentially do it. That's back where the reverse lights are. I'd have to look at whether, that would take it before breaking the plastic. And then, again, maybe if you hit the exhaust pipe as well, it's a much more narrow loading condition.
How about the corner of the tail?
The corner of the tail lamp. I suppose if you had just your hand on the very, very corner, potentially.
Potentially. But you didn't do any of that force analysis for this case, did you?
For the hand, no.
But you did it for the head, correct?
Correct. Because that I'm able to quantify.
Mr. Alessi, that was slide 108. I just want to
I'm
keep
sorry,
track.
Your Honor. Yes, Mr. Wolf. Yes.
All right, thank you.
Thank you. You are aware, Dr. Welcher, that Mr. O'Keefe suffered no fractures of any kind in his hand, correct?
So there were no fractures noted in the autopsy report, but they didn't actually x-ray from the records I've seen, either his hand or his arm. So there was, at least according to the autopsy report, no overt fractures, but the x-rays I saw, none of them were the arm, and the autopsy report said no sternum, spine, I think it said torso. They didn't say that there were no fractures there.
Was there any evidence in the medical records that you reviewed of any indication whatsoever of a fracture in Mr. O'Keefe's hand?
No.
Was there any indication whatsoever in any of the medical records you reviewed that there was a fracture of any bone in the right arm of Mr. O'Keefe?
Not that I saw. Again, it wasn't x-rayed.
Was there any indication in the medical records and the autopsy that you say you reviewed of any fracture of any bone anywhere in the body of Mr. O'Keefe?
Yes.
Other than the occipital bone or the skull?
There's a couple bones in the skull that were fractured, but other than the skull, no.
Correct. So, are you aware that the medical examiner for the state of Massachusetts, Dr. Shorty Bello, performed an autopsy on Mr. O'Keefe? Are you aware of that?
Yes.
And you're aware of it because you read the autopsy report, correct?
Correct.
Are you implying, it's a question, that Dr. Shorty Bello missed a fracture or didn't look properly for a fracture on Mr. O'Keefe?
No, I'm simply indicating that, for example, a hairline fracture, I didn't see any evidence that they actually x-rayed the structure, so there would be no overt evidence of that.
There were wounds on the right arm of Mr. O'Keefe, correct?
Correct.
And you are saying that the medical examiner should have x-rayed that to determine whether there was a hairline fracture? Is that your testimony?
No, you're asking me about evidence and proof of absence of fracture. So I would look for an x-ray to see if that was the case. I haven't seen any evidence of an x-ray of the arms.
So it's your position that on every autopsy, there should be an x-ray of every bone in the body, and that the clinical judgment of the medical examiner should not be accepted, and there should be an x-ray of every bone before a conclusion can be drawn that there's no fracture to a bone in the body of the deceased. Is that your testimony?
Absolutely not. Like, I'm an engineer. You're asking me about proof. And so proof is somebody looked at it, somebody took an x-ray, somebody palpated it and found a comminuted fracture. So we're talking about proof.
Sir, I didn't use proof in my question.
You asked me about the opinion of a medical examiner. I'm not a
Hold
medical.
on. Only one person at a time. Mr. Alessi, let him finish, and then you can ask the question.
Your Honor, I hadn't finished my question.
Okay, then finish your question, Dr. Welcher. Wait for the question. Then let Dr. Welcher respond. It's a nightmare for medical.
I understand, and I think I've been doing that, but I'll redouble my efforts. Dr. Welcher, I didn't use proof in my question. I'm going to repeat the question. Is there any indication in any medical record, autopsy report of the deceased of any fracture of any bone in the body?
That was not your original question, but to answer your question, no. Except for the skull.
Except for the skull.
Correct.
Do you understand whether the absence of any fractures other than the skull of Mr. O'Keefe was of significance to the medical examiner, Dr. Scordy Bello, in the conclusion she reached in the autopsy report that you read.
System.
Did you read the conclusions of Dr. Scordy Bello in the autopsy?
I believe so.
Are you aware of whether Dr. Scordy Bello has analyzed whether the injuries to Mr. O'Keefe are inconsistent or consistent with a motor vehicle impact? Are you aware of any analysis to that effect?
So I'm gonna see you on this one.
That's exactly what happened. I think I really do think that he matched up against him. He wasn't as able to he's it's not as easy for him to back him into a corner as it has been for other folks who testified. He getting on my damn nerves though.
Correct?
Correct.
With the arm held out, correct?
Correct.
And at a right angle, correct?
Correct.
And then the vehicle, the Lexus SUV, is backed into the test subject, correct?
So I ran 3 different tests.
I know. Well, let's just do each one at a time, okay?
Okay, so you're starting with the last one.
I'll start with whatever one you want.
Okay.
How about if we start with the one at 1 mile per hour?
None of them are at 1 mile an hour.
2 miles per hour?
2 miles an hour.
Let's do 2 miles per hour. Let's start with that one, okay? Now, did you conduct that test in an attempt to show that the injury patterns on Mr. O'Keefe's right arm are consistent with being struck by the Lexus taillight on that arm?
So generally, I wanted to show that the location, area, and span over which that headlight covers matches the location and area of the lacerations on his arm.
That's what I want to get to. So you discussed data that you say shows that that you say shows the Lexus SUV was traveling above 20 miles per hour during the period that you allege the SUV made contact with Mr. O'Keefe. Is that correct?
No. Where'd you get that from?
Hold on. Okay. The answer is no. So did you do a test involving 20 miles per hour?
I did some other backing tests.
Yes.
I was looking at how the rear pedestrian system and what warnings you got from the rear pre-collision system, the PCS system.
Let me ask you this. Would you agree that you did a blue paint test with the vehicle going at 2 miles per hour? Did you? Of course. Do that? Okay. You didn't do a blue paint test with the vehicle going at 20 miles per hour, correct?
That is correct.
Correct?
Correct.
With the arm held out.
The focal point of the purpose of that test was to show the contact width and location of how someone of Mr. O'Keefe's height, which happens to be me, contacts and where it would contact where the broken taillight was. So no, that was the focal point of the testing. That's why I did the testing. That's why we're calling it paint transfer testing.
Right, but my question, sir, I understand you use paint tests as the focal point, but aren't paint tests in accurate accident reconstruction not used as focal points? They're used as supplements to other tests to get more accurate information. Do you agree or disagree with that?
You didn't give me enough information. I can't agree nor disagree. It depends on what you're trying to do.
Let's go to, on direct examination, you testified that after the 1162 trigger event, Ms. Reed's vehicle traveled a distance of 87 feet. Do you recall that?
You are mixing up two things. Remember, the trigger is in the middle of the event.
Get the chart, please. Your Honor, I'll give you the, as soon as Mr. Wolk gives it the slide 23, I believe it is.
I'm sorry, what slide?
Well, I want Mr. Wolk to go through it to check. Let me ask it this way, see if we can get to it quicker. Do you remember talking on direct about a calculation of 87 feet where you added, there was like a 30-something number and a 50 number, and you came to 87? Do you remember that in your slide presentation, sir?
Slide 37, yes.
Right. So if we could bring up that slide, please, Your Honor, with your permission.
Okay.
That's 36, but okay.
Are you on 33, sir?
No, I'm on 36.
Mr. Wolk, do you have 33? If you could go to 33, sir.
Oh, sorry.
Yeah, because that's where your 87 number is, not on the other.
It's on a bunch of slides.
Yep.
Go ahead.
All righty. So if you could zoom in, Mr. Wolk, so Dr. Welcher can see the numbers in the column.
You're going the wrong way.
Yep, to the farther to the right.
Oh, I'm not the only one that has problems. No.
Okay.
You
Sir,
still
do
don't
you
have
remember testifying about this? To the farther to the right?
Farther to the right.
Yep.
Keep going. Keep going. A
Is
little
that
more.
53 number down there? That column?
Right.
So
Can
if you
we scroll up a tad so you can see the headers? There you go.
Okay.
No, okay, go ahead.
So am I in the right column relative to start? Is that the column?
So there's two columns, like Z is relative to where it started. And then positive is forward. And then as you back up, once you go past 0, it becomes negative.
Right. So what I want to do is have you direct us to the column where you calculated 87 feet.
It's in two spots. It's at the end of column Y.
Right. We go all the way down. Is that in the yellow there? Is that 87, sir?
It is.
Okay. Is that the 87 number you were
Hold
referring
on a
to?
second. You asked me to identify. So then see where the one next to it says minus 53?
Yes.
0.429. If you go up, so it's not a little bit down, a little bit, and see where it's changing directions at 34.157?
Yes.
You add those two together, that gives you the same result. So it went 34 feet forward and then 50-something feet backwards.
Right. And what is the 87 feet traveled, is that what you're indicating is the distance traveled during the trigger? Is that what the 87 represents to you?
That is so 87 represents the total rearward distance traveled during the trigger.
Okay. So you believe 87 represents the total rearward distance. Did I hear you correctly?
Correct.
Now, can you
Hold on, to be clear. So it starts, it pulls forward, then it backs up, passes where it initially started, and goes 53 feet further back.
That's what I want to get to. How many feet did you say on direct, and did you just say now that it went 87 feet in reverse?
Correct.
Okay.
From its furthest point forward.
Well, that's what I want to get to because I want to have this point clear. How many feet do you believe the Lexus went in reverse based upon your PowerPoint presentation? Not when it went forward and then came backwards. How many feet do you believe that vehicle went in reverse?
Your question doesn't make any sense because when it went forward, then it went in reverse.
How many feet do you believe the Lexus went during the trigger?
So it went a total of 80, it went 34 feet forward, then it came back 80, or another 53 feet past where it went.
Exactly. So you've testified that the 1162-2 trigger event represents a backwards maneuver, correct?
So again, that was clear. It initially pulls forward and then backs up.
I would like you to define, so it's clear to the jury, do you consider the event of 1162-2 just backward movement, or do you consider the trigger to be forward movement and adding to it backward movement? Which one?
So can we pull the slide up?
Sure.
Could you zoom in? There you go. No, go back to the left. So that T in the third column for data ID represents the trigger. If you scroll over a little bit to the right, where the highlighted yellow blocks are, you can see 1 is a forward drive gear, 0 is neutral, 2 is reverse. So that's where it's switched from forward to reverse. I mentioned the brake. So you have it on the brakes coming in, slowing, stopping, going into reverse, and then backing up.
So you conclude that the vehicle for this trigger went 34 feet forward, is that correct?
Correct.
How do you know the vehicle didn't go 150 feet forward? How do you know it just went 30 feet, 4 feet forward? How do you know that?
So the only data we have is this 10-second window. And so we have the velocity when it's going forward. We know how much time it took to do that. So that tells us how far it would travel. Velocity times time is distance.
So are you saying that it is a certainty that it went forward 34 feet and there's no other number of feet it could have gone forward? You're absolutely certain of the 34 number?
No. Again, if you look, see where it says vehicle speed?
I see it.
So at the start of this event, which is the trigger -5, so the trigger is actually where it's triggered, and it takes 5 seconds before, 5 seconds after. But when the trigger happens, it's actually stopped. But the 5 seconds before, it's going 13.6 miles an hour forward. So at the start of the data, it's still going 13.6 miles an hour forward, but it's slowing down. You can see you have the brake, where it says brake SW, which is short for switch. The brake switch is a 1, which means it's on. So when this event data started, it's going 13 miles an hour.
I'll ask the question a different way. Are you certain that the distance traveled forward during this trigger event was 34 feet? Are you certain?
Yeah, I'm pretty certain during this trigger event.
Pretty certain or certain?
Well, I've checked the math. I've had people check my math. So I try to be as accurate as possible. I would say I'm certain, but I'm an engineer.
Okay.
So there's no absolutes. There's no 100% in my job.
So you're certain of the 34 feet, and is it correct that you're certain of 53 feet going backwards? Are you certain of that, sir?
So backwards from its initial starting position.
Yes.
Correct.
Okay. And therefore you are certain of a total of 87 feet traveled that you have at the bottom in that yellow orange. You're certain of that as well?
87 feet of backing, correct.
Okay. Now, you also testified on direct, as I understand it, in slide 23, that different numbers represent different gear states of the vehicle, correct?
Correct.
And a 0 represents neutral?
I think it's either neutral or park, but I'm pretty sure it's neutral.
A 1 represents drive?
Correct.
A 2 represents reverse?
Correct.
Or a 2 can represent slowing down, is that correct?
Not for a gear shift number.
So you didn't say on direct that 2 could represent reverse or slowing down?
God, I hope not. It doesn't. So those numbers simply represent, is the transmission in drive? Is it in neutral? Is it in reverse? It doesn't tell you anything about whether it's slowing down or not. But the brake switch and the brake pressure and the longitudinal accelerometer data gives you some information on that.
Okay. So if Your Honor, we could go to slide 30, please.
Okay.
Mr. Wolk. And I want to do it generally. There's not a need to read any specific number. I just want it clarified.
Mr. Leslie, so is this 30 or 31?
It's I'm sorry, Your Honor, you are correct. It's 31 in the most up-to-date presentation. Thank you. You see all the numbers in blue font on that slide, sir?
I do.
Those are all numbers that you have placed on that slide. Did I have that correct in your direct presentation?
You do.
Okay. So this Excel spreadsheet, there's also numbers in black, correct?
Correct.
So all the ones that are in blue, those are numbers that you have placed into the spreadsheet. Correct?
Correct. The one exception is column N, where it says ship position.
Yes.
I changed green to forward and red to reverse.
So the data in the columns in blue are not from the original data that was downloaded from the vehicle, correct?
Like, for example, if you look at column H, I simply did a unit conversion. So it's the same number, it's just in different units. But the black numbers represent exactly as it comes out of the vehicle, but it's the same number.
All right, that's what I wanted to get to. So for clarity for this slide, when you download this data from the vehicle, what is in black, those numbers just come right out, correct? As they're stated. But the blue numbers, they don't come out like the numbers in blue. You have to do something, some calculation, some application to get to the blue, correct?
Correct.
Okay, thank you.
You're welcome.
Now, we're going to keep that up, Mr. Wolk, please. Thank you. And when we need to get to the specific numbers, we'll be fair and make sure you can see them. Now, in these columns, do I understand it correctly that you attempted to account for wheel slippage in the revolutions per minute speed values produced by the car?
Not here. You're looking, this is 1162-1. The wheel slippage occurred in 1162-2.
Okay, and so if we go to a slide with 1162.2, we will then go to the slide you believe represents wheel slippage, is that correct?
There are data points in that represent slippage.
That's my question. In which slide, sir, would you like to pick?
35.
Thank you. So we will go to slide 35. So
I've highlighted the slippage.
Exactly. So you agree that there is data that shows that there is wheel slippage with the Lexus SUV during trigger event. Let's enlarge it for this one here. The trigger event, the number 1162.2, correct?
Correct.
And as I understand it, you testified that this trigger event was caused by a depression of the accelerator pedal at more than the 30%. Is that correct?
It's a transition into reverse and then a quick acceleration exceeding 30%.
So let's
in reverse.
Okay, got it. So the accelerator pedal being depressed to this degree, more than 30%, can be the result of wheel slippage, correct?
It doesn't necessarily work that way. You can have wheel slippage at any acceleration, technically, depending on the roadway. It's just what is in the data that shows that it's slipping. It isn't necessarily because of the accelerator. Normally, that's what causes slippage. But it's the data. When you look at the data, you're like, well, that doesn't make sense. It's increasing in speed, but yet the longitudinal acceleration is dropping.
My question, again, doctor, is you can have an accelerator pedal depressed greater than 30% and it be caused by wheel slippage. That can occur, correct?
The wheel slippage does not cause the accelerator pedal.
I'm not saying a cause and effect. I'm just saying a correlation. Do you understand what I mean by a correlation?
Let me, if I may, try and straighten this out. So applying heavy acceleration can cause the wheels to spin. Is that what you're asking me?
Yes.
Yes.
Okay, that's all I wanted to get at. Already. So in your review of the materials that are related to January 29, 2022, did you become aware of whether there were, and you said you extensively reviewed documents, did you become aware whether there were people at 34 Fairview?
Yes.
And approximately how many people, without regard to names, just number, how many people did you become aware were at 34 Fairview on January 29th, 2022, the early morning hours? How many people approximately did you become aware were present?
It depends on which time, but there could be as many as 16.
As many as 16. And let's talk about the time period from midnight to 1 a.m. Do you have an understanding of how many people could have been present at 34 Fairview at that time period?
So I'm going to see you at sidebar on this.
I'm trying to hold out to get us oh Lord. Hell no, I ain't doing no damn redo. Oh, that's Mr. Alessi still. Oh no, that's Mr. Brennan. Hank, yeah. Okay, so it's a whole nother hour of this. I'm gonna go ahead and end my stream for today. Yeah, I can't cut my camera on because they don't like me. But I'm gonna go ahead and end my stream for today. I'm gonna go ahead and go pick up Marley or let her come in here and terrorize these kids. At the end of the day, the man don't want to say that the car was going 20 miles per hour because they don't know when the contact allegedly occurred that, with John O'Keefe at the end of the day. If you follow me over on TikTok, I'll be on TikTok in a little bit. And we will talk Diddy. So I'm going to spend my time. I've read all of the NBC updates, so I'm going to spend my time catching up on the live tweets from today, and then we're going to talk about it over on TikTok. So thank y'all so much for rocking out with me today. I will see y'all tomorrow. We will absolutely pick up with Sade Robinson, and the jury coming back from whatever they had. I don't mind being behind because we get to skip the breaks. Okay, that keeps us busy all day. So I'm actually in my element with at least 2 or 3 different things going on because keep the folks busy. So I shall see my folks later. I want you to have a safe week, safe evening. If I don't see you over on TikTok, and holla at your girl.